One matter, my lords, for an offence under the Land Grabbing Prohibition Act. There is a report, my lords, of the revenue authorities that the land has not been grabbed. Despite that, my lords, the trial court, my lords, has ordered, taken cognizance and ordered issuance of summons. I'm 75 years old. And my lords, I intend to travel abroad. Your lordships may.
Next week ಹಾಕೋಣ.
My lords,
ಯಾವ ಡೇಟ್ ಇದೆ ಅಲ್ಲಿ?
My lords, that is, my lords, during the first week of December. But my lords, I intend to travel abroad to meet my daughter.
Is it?
My lords.
Tomorrow. Okay, tomorrow.
Very well. I'm very clear.
I want to make a mention for adjournment, man. Serial number 22.1 appear for the appellant.
22.1.
22.1. The arguing counsel is not well.
2013 matter. 2013 matter na?
As per the direction, I received the certified copies on the last date of hearing. Part of the paper book is to be filed. So for 15 days, if time is granted, in the meantime, I will file the paper book and I will get ready for the arguments.
Finally, a period of 15 days is granted as requested by the learned counsel appearing for the appellant for filing the paper books. ಎಲ್ಲದರಲ್ಲಿ ಹಾಕಬೇಕಾಗ್ತದೆ ಒಂದ್ ಸಾಕು.
Since I had filed paper book in this case, in paper book in other cases are dispensed with.
You have filed or you are filing?
So far as the pleading part is filed, my lord. So far the exhibits are concerned, it is not filed.
All right. In RFA 1564.
1313, I appear for appellant in 1322.
322 of 2013, filling which this appeal stands rejected on that ground itself. First, if paper book is filed in the said appeal, comma, in time, comma, the filing of paper books in the rest of appeal, in rest of the appeals is dispensed with. Okay.
Mentioning
Serial number 3 weeks.
serial number 26.
26.
Respond
Same.
number, ಅದರಲ್ಲಿ ನಮ್ಮ senior is not throat infection ಆಗಿದೆ.
Not well.
ಇವತ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ಒಂದು 2 days time ಕೊಟ್ಟು.
First, we'll give you 2 months. We'll give you 2 months. We'll be very liberal today. In the second week of February,
ಅಲ್ಲ sir, 2 days.
on request.
days.
Entry ಮಾಡ್ರಾ?
2 days.
Entry order to continue.
Date may fix me.
ಬರತ್ ನಾವು ಮುಂದಿನ ಬೆಂಚ್ ನಾವು ಹೆಂಗ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದಪ್ಪ. ಎಸ್, ಹಂಗಾಗಿ week we are fixing. Yes.
Serial number 41.
50?
41.
41.
Seeking permission to 2 days accommodation.
2 days ಅಂತ ಹೇಳಿಕ್ಕಾಗಲ್ಲ. ಬೇರೆ ಬೇರೆ ಇರುತ್ತಲ್ಲ, ಬೇರೆ ಬೇರೆ.
My lord,
Due to inconvenience.
Interim order
senior
may be
counsel,
ಎಂಟ್ರಿ ಮಾಡಿದೆಯಾ?
ಇದೆ. There is.
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಂತ.
due to inconvenience, senior counsel is
Huh?
Ravishankar sir.
Same order. Entry order to continue.
Yes, applies.
Next.
Lordship, serial number 26.
26.
Inconvenience, short accommodation.
ಯಾರೋ ಕೇಳಿದ್ರಲ್ಲ ಈಗ ಬಾಲ್ಗಂಗಾಧರ್
26 side. Thank you.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
May I make a mention?
ಹಾ.
Number 14.1 and 14.2.
1/4.
Yes, ma'am. Yes, ma'am. 14.1 and 14.2. I am for the petitioners. There is an IA for vacating which is filed by the respondent.
Vacating ಅನ್ನೋದು 22 ಮ್ಯಾಟರ್ ಹೇರ ಮಾಡಿಬಿಡೋದೆ.
My lord, the only reason I am seeking for an adjournment is that the arguing counsel is not able to appear today. Any date next week, my lord, I will argue.
In the
There is
What's
an
the
interim
second?
order also which is there in operation.
December last one working day. 17th of December. On
Interim order
request of counsel for so and so interim order to continue only till then. Yes,
is applied.
yes. Yes,
The
Varun,
appellant in this
The
case, my lord.
official liquidator, my lord.
So the matter may kindly be passed over, my lord. The senior is engaged in another court hall.
Also, urgency there, no?
As in.
My lords, there's no urgency, my lords.
Urgency.
This is a rent recovery matter, my lords.
Which had come before me.
No, my lords, not, this matter your lordships had not
By
dealt with.
protocol, it comes before me, no? OS, because of this.
Oh, I say yes, my lords, please.
Okay.
My lord, one opportunity, my lord, of being heard. The matter may be passed over. My lord.
Your senior will be angry if a passover is not given. All right, let his senior come.
Great.
Tell his senior. Yes.
Appear for respondent number 3, my lord.
To be very frank with the court, I'm a bit emotional whenever this case comes up because there is no progress in the appeal. One,
What is that you want here?
confidently, my lord, I can say 4 times this respondent is changing the counsel. That is how he's putting a spokes into the wheel.
Which law says, prescribes only so many counsel can be changed?
Though this appeal was listed about a year ago,
Please,
For-
we are
for
asking
hearing.
you the question of law. Which prescribes the numerical limits for changing?
no,
the-
not at all.
Bidding.
If I may submit, my lord, respondent number 3, my lord, is a subsequent purchaser, is a retired Indian, served in the armed forces, my lord.
ಏನ್
And
ಬೇಕು?
because of this, my lord, what is happening, my lord, this builder,
ಏನ್ ಬೇಕೀಗ?
my lord, the matter is heard and disposed of. my
ಸರಿ,
lord.
ನಾವು ಅದೇ
Yes, my
ಮಾಡ್ತೇವೆ.
lord. Yes, my lord.
No, that second respondent,
Huh.
he has filed a memo that he wants to retire from the case.
Don't worry about it. It's a matter between the court and us. You argue your matter, please.
My lord, today I'm unprepared because
That you
of
can
this.
say.
I'm
Don't say all
unprepared.
irrelevant things.
Next week, any date in the next week?
We'll give you, but don't say irrelevant things which do not concern you. Call this matter next week at the request of the dead counsel.
Date may
Mr.
be
So
fixed, my lord,
and
if I may.
so.
request.
Finally,
Yes, my lord, date may be fixed, my lord. you may-
next week.
Yes.
Wait.
Yes.
10 ವರ್ಷ ಏನು ಮಾಡಿಲ್ಲ ನೀನು. All of a sudden.
No, my lord, only because of this builder, my
Alright,
lord,
alright. Next.
this is getting delayed.
Irrelevant things ಹೇಳ್ಬಾರ್ದು ಕೋರ್ಟಿಗೆ.
Sorry, my-
Yes. ಯಾರೇ ಇದ್ರು ಹೇಳ್ಬಾರ್ದು. ಸೀನಿಯರ್ ಇಲ್ಲಿ ಜೂನಿಯರ್ ಇಲ್ಲಿ. Yes.
much obliged.
Yes, Imran Bhai.
This case, I'm appearing for the respondent number 1. My lord. They have not amended the cast title, my lord, from last 26/6 on 3 occasions posted before your lordship.
Who appears? ಪಾಸ್ವರ್ಡ್ ಈಗ ಅಮೆಂಡ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಕರೀರಿ ಅವ್ರು ಬಂದು ಅಮೆಂಡ್ ಮಾಡು ಅಂತ ಹೇಳಿ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಬಂದು ಇಮಿಡಿಯೇಟ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಬೇಕು ಇಲ್ಲಪ್ಪ ಅಪೀಲ್ ಹೋಗುತ್ತೆ ಅಂತ ವಿಚ್ ಇಸ್ ದಟ್ ಪ್ರಾವಿಷನ್ ವಿಚ್ ಗಿವ್ಸ್ ಅಮೆಂಡ್ಮೆಂಟ್ ವಿಚ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ಸ್ ಲಿಮಿಟೇಷನ್ ಫಾರ್ ಅಮೆಂಡಿಂಗ್ ದ ಪ್ಲೀಡಿಂಗ್ಸ್ ವೆನ್ ಲೀವ್ ಈಸ್ ಗ್ರಾಂಟೆಡ್ ವಿಚ್ ಪ್ರಾವಿಷನ್ CPC
6 rule 17.
which is the period prescribed under CPC. ಮಗಿ ನಿಂತ್ಕೊಂಡ್ರೆ ಹಿಂಗಿದೆ ನಮ್ಮ ಬಾರ ನಾವು ಹಗಲೆಲ್ಲ ಇನ್ಸಲ್ಟ್ ಮಾಡಬೇಕು ಅವ್ರನ್ನ ಕಲಿಸ್ಲಿಕ್ಕೆ ಟು ಟ್ರೈನ್ ದೆಮ್ ಐ ಹ್ಯಾವ್ ಟು ಹರ್ಟ್ ದೆಮ್ 14 days ಇದೆ
14.
that is not done what will happen is also spoken under 1976 amendment is deemed not to have been accorded ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿ ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು
Sure.
ಅಲ್ಲೇ ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ಕೇಳಂಗಿಲ್ಲ ಹೇಳಿ ಹೋಗ್ಬಿಡು
My lord, appear for the petition, prepare 2 weeks time, my lord, comply with the office.
ವಾಟ್ ಇಸ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಬ್ರದರ್ ಕೊಡಿ ಮಾಡಿ ಕೂತ್ಕೊಳ್ಳಿ ಒಂದ್ಸರಿ ಪೋಸ್ಟರ್ 2,000 ರೂಪಾಯಿ ಹೋಗ್ತದೆ ಗೌರ್ಮೆಂಟ್ ಅದು ಗೊತ್ತಾ ಕೇಸಿ ಕೊಡಿ ಡೀಡ್ ಆಡಿಟರ್ ಜನರಲ್ಸ್ ರಿಪೋರ್ಟ್ ಎಸ್ ಮಾಡಿ ನೀವು ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು ಬೇಗ 4 ಸರಿ ಕೊಡ್ತದೆ ಮೆಮೋ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಫಾರ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಫೈಲ್ಡ್ ಬೈ ಅಡ್ವೊಕೇಟ್ ಫಾರ್
We have filed an
ಯಾರನ್ನು ಇಂಪ್ಲೀಡ್ ಮಾಡಬೇಕು
Union of India, my lords.
ಯಾಕೆ
Matter relates to Indian Police Service appointment, promotion by selection matter. It involves the interpretation, my lords, of proviso to rule 5(2) with regard to the word continuous service.
why we need them
Please, my lords.
why we need them
My lords,
for interpretation is the
no,
job of the
interpretation
court.
is there, but the, my lords, names have to be forwarded to the central government, my lords. UPSC is made a party, central government has to be made a party, my lords.
ಅವ್ರದ್ದೇನ್ ರೋಲ್ ಇದೆ
They
ಇದರಲ್ಲಿ
had not they were not implemented, my lords, before the CAT. My lords, they would be
May I make one submission?
Proper parties, they are the
My
implementing.
name was not sent up to UPSC for consideration for selection. It is at that stage that I approached the tribunal.
CAT got the
CAT
order.
allowed my, on the ground that my person who was junior to me in the select list, he was appointed in the year 2008. I was made to wait till 2013.
So you want to say these are not necessary
It
parties?
is not necessary because the role of the central government comes
Arises after it is sent.
after I am selected and then the select list is sent to the UPSC.
Lords, they may not be necessary parties, but they are proper parties for this reason. The regulation, my lords, is framed by the central government. And my lords, though it is a court which interprets the regulation. My lord,
You are a respondent, you are respondent in
I am
the,
respondent, my lords, before the
how can
tribunal.
you gain entry of
Yes.
some other candidate to the
Yes.
cost title? How are you concerned?
Lords, before the OA, they are the dominance letters, before the CAT.
They will
Before
decide.
this court,
No.
lords, though supervisory jurisdiction, we are in supervisory jurisdiction, my lords,
Ah.
in terms of Chandra-Kumar's case, but still, my lords, 226 also,
No.
because my lords are accessing 226 and 227.
Correct, that's all
also.
right. Though it is original,
My lords,
it was because of apex court decision in SP Sampath Kumar, where Supreme Court said, though an appeal provision is made, it is desirable that parties go before the rate court. Therefore, it partakes the character of it has some elements of appeal.
Please.
Therefore, how can you can resist the petition
Please.
on the ground?
Please.
Necessary parties or proper parties are not arrayed.
Please.
That can be a ground. But you cannot say that, no, he should have an enemy,
No,
one
no.
more enemy in
No,
the
no, all I'm
battlefield.
saying is this, my lords,
Perfect.
for the adjudication, they may not be necessary.
Having heard learned counsel, learned AAG
Please.
for the petitioners and the learned senior advocate appearing for the contesting private respondent, who was the applicant before the CAT, we are completely convinced that the petitioners who were respondents in the CAT do not have any right to meddle with the cost title, which ordinarily belongs to the domain of the dominus litis. Although it is open to the petitioners to alter the CAT order on the ground that necessary party / proper party was not arrayed, and therefore no relief would have been accorded to the private respondent. First, in the above circumstances, application is liable to be and accordingly rejected. Next point.
Next week for hearing.
All this matter week after next at the request of learned AG. Finally,
Please. Great.
yes.
Here for petitioner, my lords. One document ಆಗ್ಬೇಕು, one day time bench.
3 opportunities were granted by the
Final.
coordinate bench for complying with the office objections. And today matter is posted for the 4th time. First, 3 opportunities having not been availed, we don't believe
One
that
day.
4th opportunity would be exploited. First, in view of the above, petition is rejected
So
for
one day time.
non-prosecution. Next. And go on playing with the court. Who will pay the money to the central government?
One day time.
All don't do it. 3 ಸರಿ ಕೊಟ್ಟ ಮಾಡಿಲ್ಲ ಮತ್ತೊಂದು ಪಡಿ next. ನಾವು ಆ ರೀತಿ ಮಾಡ್ಕೋತ today, tomorrow will be difficult for us to walk in the park. People will hold our collars. Yes. And they should. Yes.
Office objection, Lord, is non-filing of translated copy.
Dispensed this. ಬೇರೆ ಏನಿದೆ ಮತ್ತೇನ್ರಿ ಇದೆಯಾ?
Lord, this is the matter.
ಒಂದೇನಾ?
that-
Dispensed.
Lord,
Yes, brother, what is this? Mohammed
The matter, Lord,
Shamil.
where, Lord, the grievance of the applicant before the tribunal was that the disability of scoliosis and kyphosis was not provided reservation under the recruitment notification under locomotor disability category. This was the specific grievance of the applicant. Applicant suffers from scoliosis. He said, my lord, that he applied for the posts, but while applying for the posts, the option was not available to mark for scoliosis as his disability. under the
Was
locomotor.
online application. huh?
Online application under the locomotor disability category. Tribunal, my lord, relying upon a 2018 guideline of the central government, said that, my lord, he ought to have been provided that opportunity. Though the recruitment notification is not set aside, tribunal said, my lord, that within 1 week time, he may be permitted to make application either online or offline. This is the case, my lord.
ಏನ್ ತಪ್ಪಿದೆ ಅದ್ರಲ್ಲಿ?
My lord, the
ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅವರಿಗೆ ಡಿಪ್ರಾಯವಾಗಿ ಹೋಗ್ತಾರೆ.
my lord,
ನಿಮ್ಮ ಫಾರ್ಮ್ಯಾಟ್ಸ್ ಮಾಡುವಾಗ ಅದನ್ನ ಪ್ರಾವಿಷನ್ ಕಂಡು ಮುಂದೆ
that is because, my lord, the particular disability was not an identified disability in terms of the act. Section
No,
33.
the disability identified by the court is generic. Generic ಅದು.
My lord,
Locomotive disability
please,
is generic.
within that, my lord,
Many will fall.
many will fall.
Correct.
That particular disability, my lord, has to be identified
ಹಂಗೇನಿದೆ. Where is the law?
under the act, section 33 of the act.
ಕೊಡಿ. 2016 Act,
16 act,
disabilities.
persons with
Person with
rights
the
of
POW.
persons with disability.
Who should identify?
The state government,
The
the appointing
government.
authority. In fact, here, that exercise has been carried out. Specific disabilities have been identified, and we have been sent requisition in accordance with that. Accordingly, we issued the notification. I have produced the requisition also before the tribunal.
Saying that
Saying-
separate provision should be made for these people.
The requisitions issued by the appointing authorities that so and so post disabilities can be identified for the post.
The one
That-
which petition the respondent,
That was not identified, my lord, by the expert.
but you recommended for identification.
No, Lord, we have not undertaken that. Not that requisition.
What is the medical report about
Lord,
The
that
deceased
stage
being
had not
disabled.
yet, that stage had not yet arrived, Lord. This is at this
No,
is
that
at
stage is one
notification
thing.
stage.
What the medical science says about this deceased to be a
Disability,
Ah.
this, in so far as this particular disability, my lord, it is recognized as a locomotor disability. In fact, central government has also framed guidelines, but our state government has not, my lord.
Then state, the
identified.
central government guidelines will have to be given effect.
It will not, my lord, because under the act, state government is the competent authority. It defines.
What do you? ಓದಿ. Read.
Not section 33, identification of posts for reservation. The appropriate government shall,
The state government.
the appropriate government is defined, my lord, as state government for state posts. The appropriate government shall identify posts in the establishments which can be held by respective category of persons with benchmark disabilities in respect of the vacancies reserved in accordance with provisions of section 34.
How this ground is treated by the tribunal?
Not
Which paragraph? Where is your contention? Where has it been treated?
Lord, the tribunal's order, my lord, is at page 29.
29.
Page 29, my lord. Page 29, the reasoning of the tribunal. In fact, page 27, para 13 and 14 is the detailed reasoning. 15 gives out the gist. The applicant has prayed.
Scoliosis ಅಂದ್ರೆ ಏನದು?
Lord, it's a disability where the spine is bent towards one side.
Spinal lurch.
Please. Lord, para 15, the applicant had prayed for quashing the recruitment notification insofar as non-specification and omission of reservation in category of locomotor disability for scoliosis and kyphosis is concerned. We do not think that prayer for quashing the notification is tenable when the whole case of the applicant is that scoliosis and kyphosis are to be considered in the locomotor disability category. As far as the applicant who is suffering from kyphoscoliosis is concerned, the ends of justice will be served by a direction to the fifth respondent to provide for the acceptance of application of the applicant either manually or through making necessary changes in the online application format to enable the applicant to apply if he has benchmark disability for availing reservation, and thereafter consider the applicant for selection in the reservation category on the basis of the merit in the competitive examination. Accordingly, we direct the applicant to approach the fifth respondent within 1 week from the date of this order for filing the application for appearance at the examination in response to the recruitment notification dated so and so through online
Correct.
or manual process.
Correct. It has brought justice,
Please.
which legislation intends. The policy content and the policy intent of the legislation is given effect to by the tribunal. In the absence of rules being made by the state government, they may not choose to make rules at all. They will wake up one fine day, start doing all exercise. But we cannot wait. Human
Only one
life
aspect
is short.
that is true, my lord. Only one aspect.
When
that-
are you going to make the rules?
Direction is given, your lordship.
To make the rules? When it was given?
1 month is given, your lordship.
When the order was made? July 2024. What government has done?
That instructions are okay.
Not learned AGA is requested to accept. How many states of Karnataka are there in Karnataka?
Sorry, my lord.
How many states of Karnataka are there in Karnataka?
Sorry, my lord.
Our constitution says only one state.
Yes,
Then why have we implemented so many Karnataka states?
I'm sorry.
You want to split?
No, my lord. It's a mistake, my lord. I'm sorry. I'll rectify.
For AG is requested to accept notice for 1, 2, 3. Commission, disabilities commissioner ನೀವು ಬರ್ತೀರಾ?
Separate panel.
Emergent notice to fourth respondent. KPSC ಯಾರು?
I am appearing for the
You are a KPSC
commission staff.
petitioner. Okay. Emergent notice to first. No interim order is granted since matter does not merit one. And therefore, the petitioner shall scrupulously abide by the order, impugned order of the state administrative tribunal. First.
Great.
Brother, when are you going to make the rules?
That I will do.
The government advocate is directed to secure information as to compliance of the direction given by the tribunal and place it before the court in a sealed cover. Within 2 weeks, failing which, the principal secretary,
For 4 weeks, please.
the principal secretary, which department?
Various departments, my lord.
Of departments of principal secretaries of DPAR, comma, of Department of Women and Child Development and
Posts were
shall
called
be
for.
personally present before the court. Yes, ordinarily, we would not insist personal presence of the officials of the high functionaries of the government. However, in matters like this, that course becomes inevitable. Okay.
Great.
Next.
Here for the petitioner, please, your lordship.
Yes, Madam.
That your lordship had directed notice on the respondents. I requested your lordship to consider the prayer for the interim prayer.
Another interim prayer.
Your lordship may kindly see annexure A, L and N is what is under challenge. A is the case at order. L and N are the notices issued directing termination of the petitioner. Now, your lordship may kindly see the genesis of this case goes back to 2001 when backlog vacancy rules were notified. Now, instead of making appointments as per the rules, contract appointments were made in 2003. Then in order to
Till next date of hearing, matter shall not be precipitated in terms of impugned order,
insofar as the petitioner is
so
concerned.
far as petitioner is concerned.
Please.
Okay.
Tribunal has given a finding, my lord, that the petitioner did not possess the,
Not, we'll see that. Yes. Otherwise petition becomes invalid.
he had no
Yes.
qualification.
Let us. Notice, DG. ಯಾರಿಗೆ ನೋಟಿಸ್ ಅವೇಟ್ ಸರ್ವಿಸ್ ಆಫ್
Notice ಆಗಿದೆ.
ಒಬ್ರಿಗೆ ಅವೇಟ್ ಆಫ್. ನೆಕ್ಸ್ಟ್. Yes, Mohan.
Appear for the appellant.
ಏನ್ brother?
Takes time to comply the office objection, the translation copy.
ಏನ್ ನಾಟ್ ನೆಸರಿ. ನಮ್ ಕನ್ನಡ ಬರ್ತದೆ.
Next date, it is a Marathi document.
ಮರಾಠಿನೂ ಬರ್ತದೆ ಅದಕ್ಕೆ ಇಬ್ರಿಗೂ.
Page number, very difficult to get translated. Weeks time maybe.
Compliance within 1 week.
Right.
Yes.
My lord, I appear for the petitioner, my lord. The office objection is relating to translation, my lord. Kannada translation.
Dispense it.
And so the matter is relating to department inquiry, my lord, after the incident of 2003, inquiry in 2021, after retirement, my lord. 18 years after the incident, alleged audit.
How tribunal treated this
Interim
contention?
order stay before the tribunal, my lord.
How tribunal treated this contention?
Tribunal, my lord, state that the articles of charges are dated 20th February 21, my lord.
How tribunal treated this contention?
The tribunal said that in the question of delay, this is a mixed question of facts and law, therefore we are not going, in spite of several citations. The tribunal referred to saying that it's a question of fact and law, therefore we are not going to interfere.
Issue is regarding whether charges.
Yes, madam.
Whether charges were issued or served. That was the issue, my lord.
Charges
Though
were?
yes, my lord. Though it was served on the petitioners, my lord, they have evaded it several times.
Avoided.
Yes, my lord.
First time when it was.
First time, my lord. 6,
That itself is highly belated.
22-21, my lord.
When the incident took place. You can't go back to history when Alexander had come here. There is some limit. Salmond says statutes of limitations or law of repose and confidence. In Salmond's jurisprudence in 12th edition, Procedural edition, a separate subparagraph is made. You can't reopen. You can't go back to Babur's period, 1526, when he came to India and say, no, things were bad at that time. Some wrong happened. And now, therefore, we want to rake up. The statutes of limitations are like that. Even if assuming on the first day itself, he has been served with a notice. Still, years have lapsed. Issued.
The ground of limitation.
AG is requested to accept. ನೀವು ಎರಡೆರಡು ಸ್ಟೇಟ್ ಮಾಡಬಾರ್ದು. ನೀವು ಕರ್ನಾಟಕ ಗತ ವೈಭವ ಆಲೂರು ವೆಂಕಟರಾವ್ ಅವರ ಪುಸ್ತಕ ಓದ್ಬೇಕು ಒಂದ್ಸಾರಿ. ಅವು ಬರೇ ಲಾ ಓದಿರ್ ಗೊತ್ತಾಗಲ್ಲ ಲೈಫು. ಬೇರೆ ಬೇರೆ ಪುಸ್ತಕಗಳನ್ನು ಓದಬೇಕು. ಅವಾಗ ಎರಡೆರಡು ಸ್ಟೇಟ್ ಮಾಡಲ್ಲ ನೀವು. ಅವನ್ನೆಲ್ಲ ಓದಿದಾಗ ಗೊತ್ತಾಗ್ತದೆ. ಬರೇ ಡೆಡ್ ಲೆಟರ್ ಆಫ್ ಲಾ ಓದೋದ್ರಿಂದ ಏನ್ ನೋ ಆಲ್ ಯೂಸ್ಲೆಸ್ ಆಗಿ ಹೋಗ್ತದೆ. Issue emergent notice. Learned AG is requested to accept notice.
R1.
Then the interim order as prayed for is granted, acting on the assertion of counsel for the petitioner that he had won at the hands of the tribunal. Throughout.
My lord, this is also Kannada translation, my lord. Otherwise, no interim order, only seniority matter notice may be ordered.
Only seniority?
Yes.
that the AG is requested to accept notice for official. Notice for respondents.
1 and
1 and 2 alva.
yes, ma'am.
1 and short date if possible.
Next.
Madam, for the petitioner, Miller,
ಏನು ವಿಜಯ್ ಕುಮಾರ್ ಇದು?
IFR dispensation is relating to translation copies. Madam.
Just dispensation granted.
Not the-
English translation ಇದ್ದಲ್ಲಿ.
Not the petitioner while working as Malad, police sub-inspector, Malad had married one Shilpa Malad. It was a love marriage and love and a registered intercaste marriage. Malad. Malad, she committed suicide on love,
Please repeat.
intercaste and registered marriage.
Registered marriage means what?
Malad,
What is
it
meant
was a
by that?
registered Malad, and there was some opposition by the parents of the.
No, we are asking you,
Yes,
in our system,
yes, ma'am.
a marriage is brought about by adherence to the rituals like
Yeah, rituals.
Samdapadi,
Yes, yes, ma'am.
tying of Mangalasutra,
Yes, ma'am.
Vivaha Homa, and Arundhati Nakshatra
Yes,
Darshan.
yes.
Whether
was not there,
that
ma'am.
marriage or special marriage act marriage.
Special marriage, my lord, they have registered under, they have got the marriage registered under the act, my lord.
Special marriage act.
Yes, ma'am.
Special marriage act.
No, my lord, it's a registration was done, my lord, it's a Hindu marriage act. ma'am. My lord, she committed suicide on 3/6/2023, my lord.
2620.
3/6/2023, my lord. My lord,
When
she
the
had
marriage, when the marriage happened?
6/7/22, ma'am.
6/7/22.
Yes, ma'am.
Less than a year.
Yes, ma'am.
She committed suicide.
She committed suicide for the reason that, my lord, she was unsuccessful in a competitive examination for civil post. My lord, she
When,
left it.
when examination was written?
My lord, that I'm not aware, my lord, but she had left
How
a
that
note.
you get-
She left a note stating that her husband is not, my lord, responsible for her death. And that note, my lord, has FSL has clearly stated that it was written by her only.
Who gave the FIR? Complaint was given by whom?
Parents of the
Father.
father, my lord.
Why father will lie?
Lord, the father-in-law has given a complaint. Lord, based on that, a charge sheet has also been filed on 28/8/2023, my lord.
Are you given up or set up?
Lord, I was,
In the charge sheet? What was said something about you?
Lord, they said that I was responsible for her death, my lord.
Charge sheet is a process, it comes from statutory process.
Yes, my lord.
You have seen that 2013-14 Supreme Court. ಎಂತ ಕುಮಾರಿ Lalita Kumari 2014
14.
2ACC1.
Yes, ma'am.
So the charge sheet comes into play under is prepared and filed under section 173 of
Yes.
CRPC. So primer for non-criminal proceedings, charge sheet can be acted in Motor Vehicles Act. We act upon charge sheet.
Please.
And it's also like that. Why a father-in-law will give a false complaint?
My lord, he has given a complaint, my lord.
Anyway, it has been investigated and the charge sheet is filed now.
Yes, ma'am. Now, my lord, a departmental inquiry is initiated against me on the very same charges.
Correct.
I made a request to defer the departmental inquiry in view of the very same witnesses are being cited in the inquiry also.
You
But
know
I
the
also
law.
brought to the notice there is complicated question of law and fact for
Vijay,
involved.
Vijay knows the law. We need not say.
Therefore, my lord, I had approached the tribunal, my lord, seeking for deferring the departmental inquiry till my lord, the evidence in the criminal proceedings are concluded.
The police sub-inspector who has been facing charges, grave charges, both in disciplinary proceeding and in the criminal proceeding, is grieving against the state administrative tribunal's order. First, learned counsel appearing for the petitioner vehemently argues that the subject matter of disciplinary inquiry happens to be the subject matter in the criminal proceeding. Semicolon. the witnesses in one proceeding would possibly be the witnesses in the other. Semicolon. Therefore, disciplinary proceedings need to be halted till criminal proceedings are accomplished. First, this aspect having not been properly adjudged by the tribunal, comma, he argues, comma, impugned order has an error apparent on its face, warranting interference of the writ court. First, next one. Learned AGA on request appearing for the respondents vehemently opposes the petition, contending that law relating to parallel proceedings of the kind has been firmly established, semicolon, established, comma, precedent by precedent. First, the apex court in
Tribunal has also considered it.
which is that latest judgment of the apex court.
Not in Paul Anthony's case, my lord, it has been.
Paul Anthony is very old.
Please.
Paul Anthony, thereafter we have moved much.
Please.
Semicolon. The nature and purpose of these two proceedings are different from each other. Semicolon. The quality of evidence, rules of burden of proof are also different. Semicolon. No extraordinary case is made out to fit into exception to the rule of concurrent and parallel proceedings to be allowed to continue. First, next one. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the submission of the learned AG appearing for the official respondents. First, despite vehement submission, comma, it is not demonstrated before us that the case of petitioner would fit into an exception to the general rule, which warrants halting of the proceedings. First, next one, learned AGA appearing for the respondents points out, and learned counsel appearing for the petitioner does not dispute that after accomplishing the investigation, the police have already filed the charge sheet under section, the charge sheet stroke final report under section 173(8) of CRPC for the offenses 490-88, 304B, 304B, and 3 and 4 of DP Act, 325 of SC, ST, etc. Act. First, this also is another ground for not halting the disciplinary proceedings. First, in the above circumstances, petition being devoid of merits is liable to be and accordingly rejected. Costs having been made easy. Yeah, within what period you are finished completing the inquiry proceeding? Police are kallagli. The subject DE would be accomplished. I am cooperation better. Cooperate matter, nim kelsa new matter. Will be accomplished within a period of 6 months. 6 months, and report of accomplishment shall be compliance shall be filed before the Registrar General of this court. Failing which, matter will be viewed very seriously. Okay. Yes. Yes, Mr. Murthy.
Appeal is by the plaintiff. Dismissed before the trial court. That I sought an injunction against. I sought an injunction against the respond number 1A to E and 2 and 5 and 11 or 9 or not to develop the property. They are changing the nature of the property.
You had injunction in the court below.
That was not there. Now,
You
the-
were-
after the suit has been
Suit
dismissed.
is by, your suit is dismissed now.
Also, also they have filed an IA for temporary injunction. It was
That is also rejected.
dismissed. Before this on.
Now, my lord, after the change of the filing of this appeal and also dismissing the IA, my lord. Now they are now changing the nature of the suit. my
Now,
lord.
was it
there
dismissed
is-
on the ground that they were not changing?
Change at that time, my
order-
lord, I had not to interfere.
Lord, there is,
Yes.
he had filed a suit for partition of 11 properties.
Ah.
9 guntas of land is retained by the family for the residential purpose. I am the 9th respondent. They are only.
Ninth respondent is a purchaser. Ninth
Purchaser,
respondent is
subsequent.
purchaser of the.
There are other properties also.
There are other properties.
Totally nine properties.
11 properties.
11 properties.
11
Then equities can be worked out.
But
in
not
FD.
the ninth respondent is a purchaser.
That's all right.
He making a layout and putting on the leads.
So
to
you will not claim any equity. If you undertake some construction or development activity, that will be lease maintenance only. You will not seek, on that ground, you will not seek any other benefit. We'll make
ಅಲ್ಲ
that.
ಅವ್ರು ಏನ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಇದು BDA ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಆಗಿ ಬೇರೆಯವ್ರಿಗೆ 50 ಜನಕ್ಕೆ ಮಾರಿ ಆಗೋಗಿದೆ ಲೇಔಟ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಲೇಔಟ್ ಸೆಂಟ್ರಲ್ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು ಇವತ್ತು
Your Lordship may kindly see the page number 11.
Your lordship may kindly see order
Photos I
dated
have
22/9/2023.
I have produced the photographs also.
ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಅವರೇ ಹೇಳ್ಬಿಟ್ಟಾರೆ. ಫೋಟೋಗ್ರಾಫು ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರಷ್ಟ ಆ ಪ್ರಶ್ನೆ ಅವ್ರು ಹೇಳೋದು. ಈಗಾಗಲೇ ನಿಮ್ದು ಇದು ಆಗಿದೆ.
Page number 10, my lord, page number 10. Now they are using the JCB and leveling it to form the layout.
ಲೇಔಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ ಅದೆಲ್ಲ ಆಗಿ ಸೇಲ್ ಆಗೋಗಿ
ಇವಾಗ ಹಿಂದೆ ಇರೋದು ಮನೆಗಳು ನಮ್ದಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂದೆ ಇರೋದು ನಮ್ದು. ಪೇಜ್
ನಿಮ್ಗೆ
11 ಅಲ್ಲಿ ಪೇಜ್ 10 ಅಲ್ಲಿ JCB ತಗೊಂಡು ಲೆವೆಲ್ ಮಾಡಿ
ಹಾ ಮಾಡ್ಲಿ, ಏನಾಗುತ್ತೆ?
ಅಲ್ಲ ಲೆವೆಲ್ ಮಾಡಿ ಇವಾಗ ಲೇಔಟ್ ಮಾಡ್ಬಿಟ್ಟು ಮಾರ್ತಾರೆ.
ಲೇಔಟ್ ಮಾಡಲ್ಲ, ಮಾಡಿ BDAದವ್ರು ರಿಲೀಸ್ ಮಾಡಿ 50 ಜನ ಬೇರೆಯವರು ತಗೊಂಡಿದ್ದಾರೆ, ಅವ್ರು ಏನನ್ನ ಮಾಡ್ಕೋತಾರೆ. ನಾವೇನು
ತಗೊಂಡಿದ್ದೆ ಅವಾಗ ಸೂಟ್ ಹಾಕೋಕ್ಕಿಂತ ಮೊದಲು ನಂತರ
ಇಲ್ಲ,
ಹಾಕಿದ್ಮೇಲೆ ಮಾಡಿದ್ದು ತಗೊಂಡು ಸೇಲ್ ಆಗಿದೆಯಾ?
ಮಾಡಿದ್ವಿ, ಆಮೇಲೆ ಇಂಪ್ಲೀಟ್ ಮಾಡಿದ್ವಿ.
ಇವ್ರು ದಾವಾ ಹಾಕಕ್ಕೆ ಮುಂಚೆ ಲೇಔಟ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ, ಕ್ವಶನ್ ಅದಲ್ಲ.
I am not a party to the sale deed. I am not a party to the sale.
You are not a party
To the sale deed.
that sale deed.
That sale deed.
No, these sale deeds came, they are post suit, post institution of suit or
Earlier to that.
earlier only. But they were not made parties.
I am not been made as a party to the sale deed.
No, that's all right. But whatever sales have been taken
That is
place,
been said in the affidavit also.
you are not answering the question.
Sorry.
ಪರ್ಚೇಸರ್ಸ್ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ.
ಇಬ್ರು ಸರಿಯಾಗಿ ಅಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಈ ಎಷ್ಟು ಸೇಲ್ ಡೀಡ್ಸ್ ಆಗಿತ್ತು ಸೂಟ್ಗಿಂತ ಮೊದಲೇ? How many sale deeds were there?
Only one sale deed in favor of the ninth respondent.
Only one sale deed.
Yes, ma'am.
And he sells it to rest of the people.
Yes.
That's, those sales take place after the institution of the suit.
But that I am not aware.
Ah,
But
ಮತ್ತೆ?
he has to, my lord. That
No,
is-
you have to say that.
No, my lord.
Suppose
that
if
is-
the
that-
seller has
that-
already sold the properties,
Yes.
bits and bids to others.
No, my lord, now he is making a layout, my lord. That is the photos I have produced.
I will not make any layout.
Making
Not
a
already made.
layout.
I have
When-
surrendered to BDA
When that layout is made by whom?
by me, my lord, ninth
Where is
respondent.
the layout approval? So the,
ಅದೆಲ್ಲ
show
from
approval
government
under section 34. Where is your
ಪ್ರಯತ್ನ
approval?
ಮಾಡಿ ಪ್ಲಾನು ರಿಲೀಸ್ ಆಗಿದ್ದು BDA ಗೆ ನಾವು ರೋಡು
Where is your, sir, Rao Saab, give us the approval under 34. Approval kodi. Okay. Call week after next for filing objections to the.
Office objection, my lord. Only objection is that, my lord,
ಅಲ್ಲ,
respondent number 3 died.
ಶುರು ಮಾಡಿಲ್ಲ
My lord,
ನಮ್ಗೆ.
appellant is also party
Office
to the.
objection board.
Your
It's significant.
lordship, they are also not filed paper book.
Huh?
Paper books.
Sorry, ನೀವು ಇದನ್ನ ಕೊಡಿ. Paper book ಹಾಕಿಲ್ವಾ?
BA ಕಾಪಿ ಕೊಡಕ್ಕೆ ಹೇಳಿ
ಒಂದು
ಸ್ವಾಮಿ ನನಗೆ.
4 time kudi will file it.
Huh?
He is a poor man. He has not been given.
ಬಿಡಿ, ಪವರ್ ಇದ್ರು ಅಪೀಲ್ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಬೇಡ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ,
He has engaged you. How can he be poor?
My lord, dispense with the paperwork.
ಹಂಗೆ
ಏನಿದೆ ಎವಿಡೆನ್ಸ್ ಬೇರೆ RTC ಮಾತ್ರ.
RFA ಅದು ಇಟ್ ಲೈಸ್ ಬೋತ್ ಆನ್ ಲಾ ಅಂಡ್ ಫ್ಯಾಕ್ಟ್ಸ್. ನಾವು ಎವಿಡೆನ್ಸ್ ಅಸರ್ಟನ್ ಮಾಡಿದ್ರೆ ರೀಅಸೆಸ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಪೇಪರ್ ಬುಕ್ ಬೇಕಾಗ್ತದೆ.
ಆಯ್ತು 4 weeks time.
2 weeks ನಲ್ಲಿ ಹಾಕಿ. Post the application for consideration if and when the paper books are filed by the appellant. And not otherwise.
He may be done.
ನೀವು ಹಾಕಿ ನಾಳೆ ಹಾಕಿ ನಾಡ್ದು ಬರ್ತದೆ.
Office objection maybe.
ಅಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
My lord, appellant is also a LR of the third respondent. She is the mother of the appellant. Third respondent is the mother of the appellant. Office has raised objection saying that he's been mentioned as a.
Office objection being insignificant is overruled. All.
IA ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಒಂದು ಡೈರೆಕ್ಷನ್
ಇನ್ನೊಂದು ಕೊಡಿ ಏನ್ 2 ಪೇಜ್ 3 ಪೇಜ್ ಇರ್ತದಪ್ಪ ಬಟ್ಲು. ರಾಮತುಲ್ಲಾ ಕಲತ್ ಹಾಕ್ಬೇಕಲ್ಲ.
I'll file undertake to file of
Name of Ramatullah shall be deleted unless he files the wakalat within 1 week. Yes. Next.
Your Lordship, kindly pass it over. The
Pass it.
council trying to get on that. To respond.
Respondent.
Discovery.
No, 15, sir, 49, 57. I filed the IA.
Application.
Yes, my lordship. Since the relief start in the CAT had been implemented, the WP year has become infrastructures, my lordship. You have implemented the CAT orders completely.
It is implemented.
Yes.
But the aggrieved party is filing WP. If
Yes,
you
my lordship, first of all, he filed the CAT. The relief has not been granted for the stay order. On that ground, they moved to they filed the WP year. While the WP pending, CAT case has been finalized in his favor. Yes, in his favor.
Okay.
That's the WP has.
Alternate CGC, na?
Yes, I am CGC, my lord.
CGC. Mr. D. Basavaraja appearing for answering respondents submits that petition has become infructuous in as much as the main matter that was pending before the CAT itself has been
implemented,
disposed of.
Yes,
Main
disposed
matter
of
is
in the
disposed
favor of the
of.
applicant.
Main matter is disposed of.
Yes.
Disposed of. Come. The relief having been granted to him.
Yes.
First, there is none from the petitioner's side to contradict this. First, next, in view of the above, petition is disposed of as having become infructuous. Yes.
Lord, your lordships have already connected this matter by the order dated 6/11/2024.
16, huh? 16. 16.
16.
This to be called along with
WP 29043. I'll make a note of it.
Call this matter along with WP number
290.
ಬರ್ಕೊಡಿ ತೊಳಿ ಅವಕ್ಕಿಂತ ಬರ್ಸ್ಕೊಂಡು ಅದಕ್ಕೊಂದು ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಂಡು ಅಲ್ಲಿ ಸ್ಲಿಪ್ ಇದು ಮಾಡಿ.
Your lordships have already passed orders in this matter.
In terms of this court's order dated
6/11/2020.
6/11 ಅಲ್ಲ.
ಇದರಲ್ಲಿ ಆಗಲಿಲ್ಲ, it has to already connected.
ಅದರಲ್ಲೇ ಆಗಿದೆ.
ಆಗಿದೆ.
Call along with sides. Leave.
Please.
Next. Gupta?
Yes.
Any?
My lord, this is case of casual laborers.
Kindly pass it over.
Pass over.
Yeah.
Any urgency?
Case is urgent, my lord. They were working from 98 onwards. They completed 25, 26 years service. And then they removed them without any reasonable cause after a service of 26, 25 years.
They removed?
Yes. 3 persons. One is handicapped, one has 2 handicapped daughters, and third is lady.
We'll have this in the second week of January for a final disposal.
Yes.
Okay. Call this matter in second week of January 25 at the request of learned CGC. Okay. Thank you.
With your lord's kind leave. Your lordship, serial number 14, we had moved the matter.
14 hour time zone, right?
Yes, your lordship. We didn't know about, somebody don't inform us also, but they have moved the matter and took time. And it is posted on 17 December. I would appreciate if it can be sometime in this month itself.
How date before 17th you want it?
Yes, your lordship, sometime in this month.
27th, 28th. Bardagidini order. Set, Bardaki. 28th. You inform your friend.
Yes, your lordship.
Heli, nan absence nalli togondidri, ನಿಮ್ಮ absence ನಲ್ಲಿ ನಾವು ಹೋಗಿ ಆರ್ಡರ್ ಚೇಂಜ್ ಮಾಡಿಕೊಂಡಿದ್ದೀನಿ.
Much obliged.
ಅವ್ರು ತಿಳಿಸುದಿಲ್ಲ, ಬಾರಿನವರು ಶುಡ್ ಇನ್ಫಾರ್ಮ್ ದಿ ಫ್ರೆಂಡ್ಸ್. ನಾ ಟೈಮ್ ತೋಳ್ತಾ ಇದ್ದೀನಿ.
Yes.
ನಾ ತಗೊಂಡಿದ್ದೀನಿ. ಏನದು ಏನಿಲ್ಲ. Here is that yesterday's my notes in Pollock and Mullah Partnership Act. Good. Yes.
Appearing for the petitioner's counsel. I made some research, my lord. I was unfortunately, I was unable to get an authoritative pronouncement, my lord, on this aspect of the matter.
No ruling. But it's a mixed.
In some cases, they say contract to the contrary.
No, section itself says. Section itself.
That's how, my lord, the judgments, my lord, either on the, my lord, the contract or on that. Authoritatively, it is not pronounced that in the goodwill is to be shared only on dissolution.
Only, you said because of the text of section 55, 56, huh?
55, 55.
55.
Yes.
You know, there is another section also, 55, 56. They use the word dissolution.
Yes.
Therefore, you are saying without dissolution, there cannot be unless there is a contract to the contrary.
Yes.
If
Section 14 says, my lord, your lordship will kindly see section 14. It says, my lord, it is an asset of the firm.
That's true.
If it is an asset of the firm, it is capable of, my lord,
appropriation.
Appropriation, my lord, it says. Then your lordship will kindly see 15. One has to read, my lord, 14, 15 and 55 together to understand, my lord, whether it is capable of being used, my lord, for anything other than, my lord, the business. Subject to the contract between the partners, the property of the firm shall be held and used by the partner exclusively for the purpose of the business. When it is a running concern, after the, my lord, death continues, my lord, when the partnership deed says, my lord, the death of the partner will not come to an end. It continues to be carry on the firm.
Is covered by the judgment of Honorable Supreme Court with respect to this calculation. But I'm not seeking the goodwill of the firm or to say that I want the name of the firm to use for another business. All I am saying is, Lord, that if is the partnership deed provides that after death of partner, the partnership can continue. Then for the purpose of calculation of my share, the goodwill should also be taken as a property and its valuation has to be taken and that has to be calculated. But for that, my lord, Honorable Supreme Court has held, my lord, that very same argument was Kenmar. Stating that it cannot be considered because it becomes only the goodwill cannot go without the firm. Lord, the first judgment, my lord, 1970 Supreme Court, my lord, the very same issue arose, my lord, page number 2.
And subsequently, all judgments, my lord, referred to the first one.
All judgment refers to this judgment. My lord,
and if your lordship would see the last paragraph, my lord, in that, the first judgment.
Page number 2, my lord, para number 2 is the contention.
70, volume 1.
Oh, please, my lord. That is referred even in the order, my lord.
Kushal Khimgar Shah versus so and so. Last paragraph.
paragraph 6.
We are unable to agree with Nariman.
ಅದನ್ನ ಹೇಳ್ತಾರೆ ಮ್ಯಾಲಿಂದ the contention your lordship finds, my lord, in paragraph
Stipulate it shall be
Four, I
continued by
think.
the surviving partners of the death of a partner. The court will not award to the liquidator to the deceased partner a share in, it goes against you.
ಹೌದು. My lord, there is no reference to 15.
How can we say that the part, the.
No, I am not on that, my lord. What I try to say, my lord, is there is no authoritative pronouncement to say that even though there is a partnership firm is continued, even though the goodwill is part of the firm, after the retirement or death of a partner, this is capable of being given to, my lord, that is without reference to section 15. My lord, if the property of the firm continues to be in the hands of the firm, which is exclusively required to be used for the running of the business of the firm, then it is not capable of, your lordship will kindly see, my lord, how, my lord, the distribution of this goodwill takes, my lord, section 55. Even it is capable of being sold also to third parties.
No, two things. Sharing value of goodwill where partnership continues despite death of one of the partners,
Yes.
few of the partners, as provided in the deed, is one thing. The question for appropriating the goodwill as a property of the firm, because section 15 says so, that will happen only if dissolution of the partnership firm happens.
Yes.
That appears to be little, because that's how, kindly read para 6.
Yes. We are unable to agree with Mr. Nariman that interpreting a
Deed of
partnership,
partnership,
business whereof
it
it is stipulated shall continue
as
by
in your
surviving
case.
partners after the death of a partner.
But
The court will not
award
award
to
a
the legal representative of the deceased
deceased
partner
partner a share in the goodwill in the absence of an express stipulation to the contrary.
Correct.
A goodwill of a firm is an asset.
Correct.
In interpreting the deed of partnership, the court will insist upon some indication that the right to share in the asset is by virtue of an agreement that the surviving partners are entitled to carry on the business on the death of the partner to be extinguished. In the absence of the provision expressly made or clearly implied, the normal rule that the share of a partner in the assets devolve upon the legal representative will apply
to the goodwill as well.
Yes,
It's answer.
Lord, section 15, your lordship will kindly see, my lord, it is not.
So you
capable-
mean to say,
Yes,
this is per incurium?
I do not want to say, my lord, it is per incurium.
That
I
is
would
the
like,
only ground on which we can say, and that is also not available now, that you cannot say, we will not follow.
my lord,
the
I
decision
can
of-
put it, my lord, in this way, my lord, it is sub silentio.
That also is not available.
But sub silentio is, my lord, it is done, my lord, without taking into consideration, my lord, section 15.
In Indian jurisprudence, there is no difference between per incurium decision and sub silentio
My
decision.
lord, there is, my lord.
No.
There is, my lord.
Read summoned. Summoned. Bring summoned. Summoned 10th, 11th edition by Glanville Williams said what you said, but in the next edition of Fitzgerald, the 12th edition, there is no difference.
Lord, section 15 itself is not taken.
We understand it
Yes.
is not referred to history. Even blind man can see that.
Yes.
But question is, can on that ground, can a lower court like us?
Kindly see, my lord, the paragraph, my lord, in the last paragraph, it says, my lord, extinguished. ಅದಕ್ಕೆ 15, my lord, is a prohibition for use of the property for anything other than the business. Unless there is a contract.
15 enacts two rules.
Yes.
Each subsidiary to each other.
Yes.
One is goodwill shall be the property of the firm, and goodwill shall be used only for the purpose of the business, nothing beyond that.
Yes.
If I may, my lord. Section 14 says what are the properties of the firm, which says goodwill is also property of the firm. 15 does not simply refer to goodwill, my lord.
The cognate provision of 15.
It says all the properties of the firm has to be exclusively used for the business of the firm. If this logic is taken, my lord, I should not get even a single rupee because even immovable asset is.
May
exclusively
I
by the
make
partner.
this suggestion, my lord?
Yes.
Permit us to raise this as a preliminary issue, my lord, before leading evidence, before the learned. Arbitrability, my lord, on the.
Facts and law, the very mixed facts of law and the facts.
Cannot be a preliminary issue.
Mixed facts.
It's question of law.
ಅದನ್ನೂ ಒಂದು issue ಮಾಡಿ.
Let there be.
ಅದೊಂದು issue ಮಾಡಿ.
Before, my lord,
Maybe try along with him.
before permitting the, my lord, the leading of evidence, my lord, and the experts' evidence, my lord, on this aspect. My lord, let the learned judge, because the decision on that, my lord, is postponed. Your lordship will kindly see the order of the.
But he says will be considered, it's a mixed question of law and we read that.
ಆ ತರ ಇಲ್ಲ.
Question of law and facts, so ಆ ರೀತಿ ಎಲ್ಲ ಇದೆ. ಆ
ಆ
ರೀತಿ.
ತರ ಇಲ್ಲ.
The question is whether the goodwill and the partnership firm are separable or inseparable. The first notion is that it's inseparable, it goes with the business of the firm.
Yes.
Continues, you will have it.
The availability of the goodwill is only on a dissolution.
That is one.
In the absence of a dissolution, when there is a prohibition to use the property of the firm for anything other than the business, it is not permissible to
No,
be
they are
given.
not using the good, there is a difference. Difference between using the goodwill and taking some money in lieu of goodwill by way of share. There is difference between these two. He's not going to establish another firm,
May I-
seeking the same.
May I request your lordship kindly see, my lord, the deed of the partnership, my lord.
ಅಲ್ಲ ಸಪೋಸ್ ಅದನ್ನ ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಆಗಿ ಮಾಡಿದ್ರೆ ಏನ್ ಕಳ್ಕೊತೀರಿ ನೀವು ಅಷ್ಟು ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ಬೋದು ಸುಮ್ಮನೆ ವೇಟ್ ಮಾಡೋಬೋದು ದೇ ಆಲ್ಸೋ ವಿಲ್ ಬಿ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಹೌ ಯು ವಿಲ್ ಬಿ ಅಗ್ರಿ ಎನಿವೇ ಇಟ್ ಈಸ್ ಒನ್ ಆಫ್ ದ ಇಶ್ಯೂ
Being agreed, my lord.
ನೋ ವಿ ಆರ್ ಟೆಲಿಂಗ್ ಯು ವಿ ಆರ್ ಜಸ್ಟ್ ಆಸ್ಕಿಂಗ್ ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದ nuances. There are many ABCD issues. Is it not? Please, ordinarily, all issues need to be restricted in trial. That's all right. But suppose if this issue can be tried as a preliminary issue, provided you agree, otherwise we'll pass some order. We don't know what order we are going to pass. Perhaps God also will not be knowing.
My lord, under Arbitration and Conciliation Act, my lord, there will be issues. Because if that is even considered as a preliminary issue, if any order is passed, whether it can be considered as decree for the purpose of them to approach.
No, question is not that. Suppose if it is held, it is not, if his contention is accepted. No, we are asking you how you will be aggrieved. They are one sitting, you are sitting extra. But Mushamudi, he also will be happy. But there is an arguable point. There is some arguable point in that.
So
ನಾವಿದ್ನ ಸ್ಟೇ ಮಾಡಿ ಇಟ್ಟು ಮತ್ತೆ 5 ವರ್ಷ ಹೋಗಿ ಮಾಡೋ ಬದ್ಲಿ ಸಮಥಿಂಗ್ ಆಮೇಲೆ ಅವ್ರು ಹೇಳೋದು ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ವಿಲ್ ರನ್ ಅವೇ ದೇ ಸೇ ಟ್ರೀಟ್ ಇಟ್ ಆಸ್ ಅ ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಅಲ್ಲಲ್ಲೇ ಮುಗಿಸ್ಕೊಳ್ತೀವಿ
treating of the preliminary issue, my lord, my contention, my lord, there are various contentions. The first, my lord, I have 10 assets which is there. I have pointed out that I want to be calculated minus all the liabilities of the firm. Whatever net asset of the value is there, please give me my share in the property. In that, they say that, my lord, only book value have to be taken. I am saying, my lord, that market value, fair market value of the property as on the date of death has to be taken into consideration. That is one of the issue which is there. Of the 10 assets, this goodwill is also one of the assets that I have treated. Now, my lord, it is only at the time of final argument when all the evidence is led that one can say what can be treated. That means to say, my lord, that only book value have to be taken or the market value of the property has to be taken. Whether the good value have to be considered as a claim or goodwill should be considered as a claim or goodwill should not be considered as a claim. Lord, all these things, Lord, it is only at the time of final argument when the calculation is being made. Lord, the difference between the regular civil court, my lord, where preliminary decree is passed and FDP is there, that is not there in this arbitration because both preliminary and final decree is passed in the same proceedings, my lord. So, my lord, if goodwill is to be treated preliminary issue, similarly, my lord, they are taking, there is one another contention that only book value have to be considered and not the market value of the property. The courts have held otherwise saying that as on the date of death, the fair value of the properties have to be calculated and in that share has to be granted. Tomorrow, my lord, that they will say it as a preliminary issue, it has to be considered. All those issues, my lord, and goodwill is not even an issue, it cannot be an issue. It is ultimately what share I have to be granted. It is for that reason, my lord, finally it was held that if evidence itself is not there, tomorrow if court, tribunal comes to the conclusion that yes, I have to be given share in the goodwill also. If there is no evidence, if no opportunity is given to me to lead evidence on that issue, then I will be put to a great hardship. That's why, my lord, this order was passed and I was permitted to lead evidence.
There is some sense in what he is saying. Not preliminary ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಮತ್ತೊಂದು ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೋತ ಕೊಡೋ ಬದಲಿ ಒಂದು ಓವರಾಲ್ ಇದನ್ನೊಂದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಒಂದು ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿ.
And my lord, it is not arbitrable, my lord, will be our argument.
They can take up that
Your lordship
because we have
judgment
held
is there.
no interference in writ petition. There is one judgment of
Your
mine.
lordship judgment itself is there.
ಈಗ ನಾವು ಇಟ್ ಇಸ್ ಆರ್ಬಿಟ್ರೇಬಲ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರೆ ಆ ಕಂಟೆನ್ಷನ್ ಮುಂದೆ ನಿಮಗೆ ಬೈಂಡ್ ಆಗ್ಬಿಡ್ತದೆ.
ಅದಕ್ಕೆ ಅಲ್ಲಿ ಹೋಗಿ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಸೊ ದಟ್ ದೇರ್ ವಿಲ್ ಬಿ
ಅಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅದ್ರ ಪ್ರಿಲಿಮಿನರಿ ಇಶ್ಯೂ ಆಗಿ ಬೇಡ ಅಂತ. ನಾವೇನ್ರ ಹೇಳಿದ್ರೆ ಬೇಸ್ಡ್ ಅಪಾನ್ ಪ್ಯಾರಾ 6
may I put it in this way, my lord. I may be given liberty to make an application, my lord, to try it as, my lord, arbitrable or non-arbitrable. Without prejudice to my contention, my lord.
That liberty is there, but for that also.
ಅದು ನೀವು ಅಪೋಸ್ ಮಾಡಿ ಅಪ್ಲಿಕೇಶನ್. ಈಗ ನಾವ್ ಏನ್ ಹೇಳಿದ್ರು ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. He wants some shadow of the order of the court. ನಾವು ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಆ ರೈಟ್ ಇದೆ. Instead of keeping it at
Supreme Court, my lord.
ನೀವು ಇದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳಿ, ಆ ಲಿಬರ್ಟಿ ಕೊಡ್ತೀವಿ.
Distinguished, yes, my lord.
This petition is structured on the proposition that in the absence of dissolution, comma, no claim for be made for in respect of goodwill of the firm, which continues to be in existence despite death of a partner. First, in support of this, learned senior
And it is exclusively required for the business of the
in
firm.
support of this, learned counsel appearing for the petitioner draws our attention to the provisions of Partnership Act 1932 na? 1932, more particularly sections 14, 15 and 55. First, learned counsel appearing for the contesting respondent resists the petition, contending that the question is no longer res integra in view of Apex Court decision 72 na 71?
72, 70.
71.
70.
1970, para 6, which reads as next paragraph. At this stage, learned senior advocate appearing for the petitioner on instruction of advocate on record seeks leave of the court to withdraw the petition with liberty to move an appropriate application before the learned arbitrator to treat the question as a preliminary issue. First, learned counsel for the respondent opposed granting of such liberty. First, next, having heard learned counsel appearing for the parties and having perused the petition papers, we are inclined to grant leave to withdraw the petition, coupled with liberty to move the application of the kind before the learned arbitrator. First, in that connection, all contentions are kept open. First, ordered accordingly and WP is disposed of.
Not preliminary, my lord, arbitrability.
ಅದೇ ಆ ಇಶ್ಯೂನ ಆರ್ಬಿಟ್ರೇಬಿಲಿಟಿ ಅಲ್ಲಿ ಕ್ವಶನ್ ಆಸ್ ಟು ಆರ್ಬಿಟ್ರೇಬಿಲಿಟಿ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ ರಿಲೇಟಿಂಗ್ ಟು
Goodwill.
claim for the goodwill as property of the firm. Okay. But whenever you come, you bring always one or the other new point also. Even when we will be under impression everything is covered, still you make us think again, oh, it is something like that.
Several authors, my lord, on this subject have categorically held, my lord, there is something needs to be done, my lord. There is no clarity and all that. In spite of 1932 Act, my lord, there are some loose ends also.
Law is like that only.
Yes. Your lordships have seen, my lord, section 6. Without any basis, my lord, that proposition is, my lord, been made. It becomes difficult, my lord, in adjudication. There cannot be, my lord, giving the goodwill, my lord, to a person, my lord, who is no longer there. Goodwill is required to be used, my lord, by the firm. Or it can be sold to third party who is purchasing the entire firm. And it is a notional value. A person who is carrying on only will get it. Maybe they will only say, I may get some more money in addition to what I am entitled to.
Property of the
But
firm.
what happens, my lord, in a partnership, my lord, business, there is a separate account meant for the each partner. That is called my lord, partner's account. Every capital account. Every time, my lord, something is brought in, something is taken, profit is added. That is a separate account. Whatever is there in that account, a person will be entitled for that, not more than that. Here, my lord, there is an attempt to take more than what is available to. In fact, we have sent a check also for them. They have returned the check and started these proceedings. We settled the amount. They are not satisfied with the amount that we have settled according to the profit and loss account and, my lord, the capital account of the partners.
You are appearing before the arbitrator.
No, my lord.
Counsel non-record. Yes. All right. Thank you. There is one last sentence. Precedent in English law by Rupert Cross nearly says what you said. Sub silentio is when statutory instruments are lost sight of by the court. Per incurium is one where binding precedent is lost sight of. This is how the 10th edition
It is also called careless judgment.
That way. Correct. Yeah, you said that. But Indian counterpart, Professor Lakshmi Kanta, precedent in Indian law, treats it in a different way. 2nd edition.
Lord, sub silentio, my lord, will not carry the, my lord, the
Binding nature.
Binding nature. It will not be a precedent.
But this
It is a judgment for that particular case. It will not. It loses the character of a binding precedent.
It will be devoid of presidential power.
Yes.
This one.
Yes.
But this is treated by Professor Lakshmi Kanta in his 2nd edition, precedent in Indian law. It's a counterpart of precedent in English law by Rupert Cross. Not of that quality. And you can just look into. Many students will be sitting in my court. Therefore, I said, yes. Correct. Mr. Joshi, what is the urgency?
The urgency is this. One, I'll just give I am a tenant in a company. That company has gone into liquidation. The liquidator has come on record. I am a tenant under a duly registered lease agreement valid for the next 30 years. The agreement provides for a certain formula for payment of rent. Since the liquidation has happened,
the
urgency is this. The liquidator and I entered into mediation, were sent for mediation. We entered into a mediated settlement agreement. It came before the learned company court. Before the court, the liquidator says, no, I'm not agreeing to the mediated settlement agreement. Thereafter, the learned single judge also directed that the mediator, who is the retired judge of this honorable court, submit his report. His lordship's report also has come before this honorable court saying, no, the parties did come before me and they have signed the mediated settlement agreement. Therefore, what is the effect of that settlement agreement is one issue, because pending this issue before this honorable court, the liquidator, like a private landlord, has sent notices to my service provider in the building to cut off my utilities, my electricity and water supply, which is a fundamental right to me. That cannot be. When I come before the learned single judge, the learned single judge says, whatever it may be, if there are arrears, you have to pay. I said, arrears also is a matter of settlement to be seen. What is the quantum? What is the amount?
Where is fundamental? You are a company?
I am a company. Well, this court, various high courts have held that cutting off of utilities cannot be used as a threat against a tenant who may otherwise be in default. If there are other remedies in law under the Transfer Property Act or otherwise can be done. But an officer of the court, my lord, official liquidator, making threats like this, saying that I'll cut off your electricity, I'll cut off your water, when I am paying. And as of the question in dispute now.
On what ground you have made that instruction you have given to power supplier?
My lords, if I may just clarify this matter, it was a rent recovery matter. It was ordered for mediation. During the course of mediation, of course, they gave a proposal which we were not happy with, and that was notified to the Honorable
That's
Company
all.
Court.
We are just asking. Only foundational facts.
Please.
Suppose if presently he has been paying the rents.
Correct.
Not paying.
I am.
My lords.
My instructions are the current amounts are being paid.
Show that.
Do we have any material to show that the current amounts are being paid?
Show that. No, he has
Now
not.
they are
paid.
disputing. My lord, the material was not kept available because there was never any dispute on this. If this is in dispute, 2:30, I will bring the material. This was never in
But
dispute.
this was always in dispute. I
It's okay.
can provide our statement. They have been chronic
My
defaulters, my
lords,
lords.
may I submit, my lords? My lords, the total dues pending,
Hmm.
there were 2 crore dues asked in the original CA, which is here before my lords in the OSA through joint memo and all. After that also, if I calculate, even if I remove those dues, as of today, they have to pay 9 crore 97 lakh. And that is after 1.25 crore they have paid after my notice. So my lord paid, they have paid 1.25 crore.
How much is payable?
9 crore 97 lakh, my lords. And my lords, their rent comes in very bits and pieces. We are not able to adjust it against anything. And my lords, they are.
Under the agreement,
Yes, my lords.
when rent is payable,
My lord, rent is payable by the 7th of every month.
every calendar.
Or my lord, if we are raising the invoice late, then it is payable within a week of that.
Where no invoice is raised, normatively they should pay on or before 7th of every
Yes.
calendar.
Yes.
Just show us.
My lord, that is, this, my instructions are that this issue that I'm currently paying rent was never in dispute, but now that since that is also being disputed.
Two things you have
2:30
to show. You are before this court now.
Yes.
You have to show that if suppose if it were to be some Kalegoda, Malegoda, another thing. You are a company. Therefore, to invoke jurisdiction of this court, we are now asking you to show your bona fide. Because you are putting forth your status as a tenant, that becomes permissible, provided you have conducted yourself as a tenant,
Very true.
not otherwise.
Very true. Correct.
Therefore, you give complete details as to what amount is due, how you have paid it, regularity of the payment, give it in 10, 12 pages.
That is
Call this
absolutely right.
matter.
Tomorrow then I'll complete a proper schedule and give it by tomorrow or day.
ನಾಳೆ ನಾಳೆ ನಮ್ ಬೇರೆ ಕೆಲಸನೂ ಇರುತ್ತೆ.
ಇಲ್ಲ, whenever, given the urgency.
Call this matter, one day, but next week, we have many heavy matters, na? 28th of
But
November.
In the meantime, this cutting of business need not happen. My lord, no precipitates.
Power cut.
Great.
Exactly.
Ask Martha, sir.
We have to be fair.
I will bring.
We have to be fair. Supreme Court say,
Yes, my lords.
even those who have been serving sentence
Yes, my lords.
should be treated with human dignity, human respect. They don't shed, to use words of Justice Neely of one state Supreme Court in the US. He says, a convict does not shed all his rights at the prison gates. Same applies to, after all, it's a company.
Great.
ಅವನ್ನೆಲ್ಲ ಮಾಡ್ಬೇಕು.
Grateful.
Internet Counsel, senior advocate appearing for the appellant.
Appellant.
Grieves that the respondent OL has directed stoppage of power supply, power and water supply,
And what is?
power and water supply.
My lords, they have filed a CA in the same, against the same in.
Till next date of hearing, we are.
Yes, yes.
He,
My lords.
to the Emperor, stoppage of science, power and water and power and water supply to the structure in question. And this is harsh. Regardless of arguable merits of the case. First, learned counsel appearing for the OL and the learned OL himself oppose their claim for restoration. Appellant's claim for restoration of supply.
My lords, as on date, it's not cut, my lords.
Cut it.
We've not.
Only
cut, my
notice
lords.
was
Only
given.
a notice was issued, my lords.
Learned counsel appearing for the OL and learned OL himself submit that only notice is sent to the supplier.
Yes.
Conventional suppliers. And as of now, the stoppage has not yet happened. First up. they agree they reluctantly agree with the suggestion of this court that as of now, the said notice shall not be pressed into service before the concerned suppliers till next date of hearing. First, this is a good gesture. First, next, call this matter on 28th.
Great,
All.
great.
ಅವನ್ನೆಲ್ಲ ಮಾಡಬೇಡ, ಪವರ್ ಸಪ್ಲೈ ಕಟ್ ಮಾಡೋದು ಮತ್ತೆ ಇದೆಲ್ಲ ಹಮುರಾಬಿ ಕೋಡ್ ಆಗ್ತದೆ. That will be Hammurabi's code. ನೋಡೋಣ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೋಡೋಣ.
My lords,
I
the
don't have
payment
a
schedule, my lords, they have to.
I don't have a choice. I'll bring my bona fides. I have to. Otherwise, I don't have a say before this court.
That's why. Call this matter for further hearing. So it's
Grateful.
further hearing. They cannot just escape by saying something. Yes.
That's not you. Grateful.
Yes. What is it? In 3-4 minutes, just we go back and come.
Three is also passed over. Next, 3 is also passed over. It will call, na? It will be called na immediately. Called, na?
ಹೊಸ ಆಕ್ಟ್ ಸೆಕ್ಷನ್ 92 ತಾನೆ. Yesterday's RFA matters. 92 of new act. 30 years. Section 92 and it is 30 years. 92. I have told correct now. It is 30 years. It is not increased to 60.
It's there.
It is there. In ಕೊಟ್ಟಿದ್ವಿ. ಬಟ್ ಬೆಳಗಾಂ ಸಿಕ್ಕಿಲ್ಲ ಮೇಡಮ್ ನಂಗೆ.
ಹೌದಾ?
ಆಯ್ತು ನೋಡೋಣ ಬಿಡಿ. It is beyond 6 months by operation of law.
ಅದೇ ಸಾಹೇಬ್ರು ಬಂದ್ರೆ ಮೆಮೊ ತಗೊಳ್ತಾರೆ ಈಗ ಸಾಹೇಬ್ ಕೊಡ್ತಾರೆ ಈಗ.
ಹೌದಾ? ಮೆನ್ಷನ್ ಮಾಡ್ಲೇಬೇಕಾ ಇಲ್ಲ ಹಾಗೆ ಕೊಟ್ಟು ತಗೊಳ್ತಾರ ಸರ್? ಬೆಳಗ್ಗೆ ಹೊತ್ತಾದ್ರೆ 10:30 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್. ಹೌದಾ? ಅಲ್ಲ ಬೆಳಗ್ಗೆ ಹೊತ್ತು ಮೆಮೊ ಕೊಡೋ ಹಾಗಿದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡ್ಬೇಕಾ ಇಲ್ಲ ಮೊದ್ಲಿನಾಗೆ ಹಾಗೆ ಕೊಡ್ಬೋದಾ?
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗ.
ಹ್ಮ್. ಏನು ಕೊಡ್ತಿರಲ್ಲಾಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕಿಗೆ ಬರಲ್ಲ? ಇನ್ನೇನ್ ಈ ವೀಕ್ ಮುಗ್ದೆ ಹೋಯ್ತಲ್ಲ, ಇವತ್ತಾಗ್ಲೇ ಬುಧವಾರ. 2:30. 2:30 ಮಾಡೋದಾ?
2:30 ಮಾಡ್ಬೋದು.
2:30 ಮಾಡ್ಬೋದಾ?
Lordship's
ಮಹಾರಾಜಪ್ಪ.
kindly serial number 38. That C. Ramakrishna matter, my lord advocate.
ರಾಮಕೃಷ್ಣ ಇದಾರಲ್ಲ ಇಲ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 13.
38, my lord. Senior counsel is also there, Bhagwan.
ಇಬ್ರು ಇದ್ದೀರಾ?
He's senior counsel representing on behalf of me.
ಎಲ್ಲಿ ನಿಮ್ಮ ಅಪೋನೆಂಟ್ ಕರೀರಿ.
Opponent government ನಮ್ಮ opponent.
38.
32.
ಹಾ. ಕೊಡಿ. ಕೊಡಿ.
AG ಪ್ರದೀಪ್ ವೈಸ್ಕಾ.
ಏಜ್ ಇಲ್ ಕಮ್ 2:30 ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? 2:30 ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಓಕೆ. ಎಸ್ ಸತೀಶ. ಏನಿದೆ?
Without going into the merits, matter pertaining to suspension. Not suspension order is
6 months ಆಗಿದೆ ಏನೋ?
6 months elapsed.
ಯಾವ್ದದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಯಾವ್ದು?
Ajay Kumar Chaudhary versus my lord, Union of India.
Yes, what are you going to do?
My lord, there, my lord, it was 3 months. Thereafter, my lord, our CCA rules are amended, enhancing it to, my lord, 6 months.
Maximum period is 6 months.
6 months. My lord,
Automatic revocation ಆಗ್ತದೆ. Professor, what is the point? It automatically stands revoked.
10(5)(b) of the CCA rules.
ಕೊಡಿ.
My lord, says that, my lord, if no charge memo is issued within an outer limit of 6 months, shall be suspension order deemed to be, my lord, revoked, and they shall be.
ಅಲ್ಲಿ ಡೀಮಿಂಗ್ ಇದ್ದಲ್ಲಿ ಅವ್ರು ಆಪರೇಟ್ ಮಾಡಲ್ಲ. Deem it to be revoked. Word used is deeming. What do you say, madam?
And
Sir, 23/9.
Charge memo issued when? By that time, what was the period?
6 months.
ಆಗಿತ್ತು. 6 months ಆಗಿತ್ತು. ಆಗಿತ್ತಾ?
Yes.
ಅಂದ್ಮೇಲೆ deeming is a deeming.
46 officers are involved in this scam.
100 are involved, we'll assume now.
That is misappropriation of government funds.
Correct. But law says.
Because of the correspondence which they had to do with all the officers.
No, but section does not recognize that. If the rule maker wanted, he would have said, excluding the period consumed for communication, etc., etc. That's not the rule. We cannot tinker with the rule. What is that? When we were given. No, where is the question of objection? Question, deeming. Deeming is a fiction arising by operation of law. If it arises, it arises. For example, 95 there, the Land Revenue Act. Suppose if no orders are passed within the period, then the land is deemed to have been converted. Deeming, what we can do?
Allegations are very serious.
Very serious, wonderful. You hang them to the nearest tree, hold inquiry, get it proved, hang them to the all trees in the Vidhan Sauda. But the law says like this.
Colluded with the contractors, my lord, in getting the arbitral.
There are very good grounds for hanging them also, removing from, dismissing them from service, etc. We go by law. Law says, if charge memo is not served within an outer limit of 6 months, from which date? From the date of suspension.
18/1/2024 is the suspension order.
1 second.
1/2024 suspension order. Lord, 23/9/2024
service.
Charge memo is framed
23/9/24. Charge memo is served on you.
Is issued. It is not served upon some of the petitioners, my lord. It is served
On your client when it was.
Lord. There are many petitioners, my lord.
ಯಾವಾಗ ಎಲ್ಲರಿಗೂ 6 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದಾರ?
ಹೌದು, beyond 6 months only. 80.
How tribunal looked at the matter?
Tribunal, my lord.
ಕೊಡಿ.
The tribunal says that
ಡೆಲಿಬರೇಟ್ಲಿ ಲೇಟ್ ಆಗಿ ಕೊಟ್ಟಿರ್ತೀರಿ ನೀವು. ಅದು ಡೀಮಿಂಗ್ ಪ್ರಾವಿಷನ್ ಬೆನಿಫಿಟ್ ತಗೊಳ್ಳೇವರು ಅಂತ ಅದು ಇರ್ತದೆ.
Submission is that, my lord, there are different officers, not the, not.
ಇದು ಮಾಡಿರ್ತಾರೆ ಅವರು. ಹಾಗೆ ಮಾಡ್ತಾರೆ ಅವರು. ಅಯ್ಯೋ, their ingeniousness is not cannot be underestimated. Deliberately ಇವರಿಗೆಲ್ಲ ಅನುಕೂಲ ಆಗಲಿ ಅನ್ನೋದಕ್ಕೆ ಮಾಡಿ. Which how that tribunal has treated the issue?
page 86, my lord, para 12. There is a delay in issuing the
charge memo.
Lord, at the time, well, Lord, when tribunal has decided, charge memo was not issued. Tribunal dismissed our application on 28/8/2024.
There you challenged what?
Suspension.
Only suspension.
Suspension.
It was within 6 months.
Lord,
Challenge was to the order of
suspension.
Now, because of the eclipse of efflux of time,
Efflux of time, Lord,
deeming provision comes into play.
And my lord, similar, the very impugned order was challenged before, my lord, Kalburgi bench. Kalburgi bench has taken contra view, my lord, of the principal bench and allowed the application quashing the very impugned order in respect of two, my lord.
ಅದು ಇಂಡಿವಿಜುವಲ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ. ಅದು ಅವರಿಬ್ಬರದ್ದು ಏನೇನು ರೋಲ್ ಇದೆ, ಏನು ಓವರ್ ಟ್ಯಾಕ್ಸ್ ಏನಿದಾವೆಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
Only on the ground that.
ಅಲ್ಲ ಅಂದ್ರೆ ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ.
Yes, that's all me.
Monday, my lord, I'll go through few judgment, team provision.
Call on Monday. Read 53 Supreme Court. So beautifully they have written what is meant by. There is one book, Law of Fictions by Raghavachari. Very good book. Yes, Professor.
Also the same not suspension. And the suspension order is 24/1/2024.
ನಿಮ್ದಾ?
Awesome.
ಯಾವ್ದು ಕೇಸ್?
Seal number 36.
ಅದನ್ನು ಇದ್ರ ಜೊತೆ ಕಾಲ್ ಮಾಡ್ಬಿಟ್ರಿ.
So far, no, in this case, articles of charge were served. No, in my case, nothing is served.
Very well. No, I did not know that you are arguing the same point. Otherwise, I would not have asked you. Because you have professional interest in that. No, we understand.
The similar bench, the coordinate bench of this honorable court has said that if referring to 10(5)(b), caused so many suspension order. I'm sorry, I'm the last person to.
No. We know, therefore we asked. But generally, when in English procedure is, there they say, if you ask, my lord, we are arguing the same point, therefore I may not say anything. Because you will be.
Henceforth they will adopt. Henceforth they will adopt.
All right. Monday, ಅಥವಾ Tuesday, ಅದರ ಒಂದು ಡೇಟ್ ಕೊಡಿ. 19th.
Entry model should be
Entry
continued.
model-
ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು. ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ.
In
ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು.
serial number 19 also entry model is there.
ಇದೆ.
It may be extended.
Yes. ಅದು ಸತೀಶ ಜಜ್ಮೆಂಟ್ ಕೊಡೋದು ನಾವು ಓದ್ಕೊಂಡ್ ಬರ್ತೇವೆ ಅಟ್ ಲೀಸ್ಟ್ ವಿಲ್ ರೀಡ್ ದಟ್ ಲೇಟೆಸ್ಟ್ ಜಜ್ಮೆಂಟ್.
Here,
ನೋಡಬೇಕು
Supreme Court says 3 months.
ಕೋರ್ಸ್ ಮಾಡಿಕೊಡಿ ಬಿಕಾಸ್ ರೂಲ್ ವಾಸ್ ದಟ್ ವೇ. ಅಲ್ಲಿ ರೂಲ್ 3 months ಇತ್ತ?
Oh, not this,
ಅಲ್ಲಿ ರೂಲ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಯಾರ?
No, that is CCA rules maybe.
Central rule,
CCA rules. Central rules.
Central rules is ready.
Okay.
Rule the 3 months.
ನಮ್ಮ ಅನು ಮೇಡಮ್ ಆನರಬಲ್ ಅನು ಮೇಡಮ್ ಏನ್ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ?
Deemed to be.
ಎಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್?
That is also.
ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದೊಂದು ಕಾಪಿ ಕೊಡು. ಜಸ್ಟ್ ವಿಲ್ ರೀಡ್ ಅಂಡ್ ಕಮ್ ಬ್ಯಾಕ್. ಯಾ, ಅದೊಂದು ಇಟ್ಕೊಂಡು ಅಲ್ಲಿ ನೋಟ್ಸ್ ಮಾಡಿಕೊಡು. ಪ್ರಿಪೇರ್ ನೋಟ್ಸ್, ಸ್ಮಾಲ್ ನೋಟ್ಸ್. Law relating to suspension. Prepare some, tell other interns to do it. Yes.
I am for contesting respond number 1.
I am for the.
ಏನು ಕಾಂಪ್ರಮೈಸ್ ಏನ್ ಆಯ್ತಾ?
My client is present before the court. She is a senior gynecologist from Chennai only. She came from there.
I am for the appellant matter.
Sit down, please be seated. Be seated, be seated. Yes. ಏನಿದೆ? ಏನಿದೆ ಆರ್ಡರ್ ಏನ್ ಬರ್ತೀವಿ?
ನಿಮಗೆಲ್ಲ
No objection for adjourning. Finally call this matter on sides. ಏನಾಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ನಾನು ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀನಿ. ಅವ್ರು ಸೈನ್ ಹಾಕ್ಬೇಕು. ಅವ್ರ ಪಾರ್ಟೀಸ್ ಬಂದ್ರೆ ಹೋಗುತ್ತೆ.
Lord,
ಹೇಳಿ.
have to submit before entering into compromise is final, my lord, that we are going to file. But before that, I number 3/24 for impleadment, because there are several parties in the compromise, that should be allowed, my lord.
ಅಲ್ಲ ಅದನ್ನ ಅವತ್ತೇ ಆಗ್ಬೇಕು ಒಟ್ಟಿಗೆ ಬಿಕಾಸ್ ಇವರು
Legally, there should be first of
ಅಪ್ಲಿಕೇಶನ್
all.
ಸಲುವಾಗಿ ಕಾಂಪ್ರಮೈಸ್ ಬರಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ ದೆನ್ ಲಾರ್ಡ್ಶಿಪ್ ದಟ್ ಈಸ್ ವೆರಿ
ಅಲ್ಲ, ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡಿದ್ರೆ ಅವ್ರನ್ನು ಸಿಗ್ನೇಟರೀಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
ಸಿಗ್ನೇಚರ್ ಆಲ್ರೆಡಿ ರೆಡಿ ಆಗಿದೆ.
ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಅಲೋ
ಆಗಿದೆ. But your lordship, the compromise, their impleading application only extend to lordship be allowed, your lordship, with respect to compromise petition. Otherwise, they don't have any locus in this matter. Appeal.
ಯಾರು
Because
ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋರು ಯಾರು?
they're all his own brothers, your lordship, they are.
ಏನು ಸೂಟ್ ಏನಿತ್ತು?
Suit for only ejectment suit. Ejectment suit. And your lordship, after filing a suit, your lordship, they created general power of attorney and they filed several suits. And
That
they
is
filed
not the-
one second, they have filed several obstruction application. All obstruction are dismissed. This honorable court have upheld the order of the obstruction application that taken up this matter to Supreme Court. Supreme Court also dismissed their all obstruction application. Now, your lordship, they come forward for the settlement. You are ready to, your lordship, and in the meanwhile, your lordship, after filing execution petition, you have taken the premises of the property through the warrant.
Taken the possession of property now.
In only in
Only
respect
thing is ಆ period
arrears
ಏನು?
of rent. That is
Arrears
the-
of rent ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು?
That is
That
my
is the
case, my lord.
arrears come to your lordship, the more than 60-65 lakhs is comes around. That is only in respect of that issue, your lordship, the compromise is taken place. If they are
The imaginary value they are placing on that day, they are saying 30 lakhs. Now they are saying 60 lakhs. That is by case in RFA, my lord.
that is law.
Fortunately, this is the compromise is taking place. So I have filed this application to bring all the.
We can't endlessly wait for compromise to take place.
Compromise is almost ready, my lord.
ರೆಡಿ ಇದ್ರೆ ನಾನೇ ಮಾಡಿ ನಾವು
Have to file it, but before that, they should be brought on record. my lord.
Read the order. Don't waste time of the court. Read the order. On your submission, we made that order.
Compromise is ready, my lord. I am
You are
not going
repeating.
anywhere.
You are uselessly repeating it because the repetition has no use here. You have understood. ಏನಂತದ್ದು ಏನಿದೆ ಏನು ರಿಪೀಟಿಕನ ರಿಪೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ?
On their behalf, may make request, lordship. Kindly have it 19th, finally, your lordship.
19th.
19th.
19th ಗೆ ನಿಮ್ ಪಾರ್ಟಿಸನ್ ಎಲ್ಲ ರೆಡಿ ಇಡಬೇಕಿಲ್ಲ.
In that pleading, I have to file wakalat also for all those persons.
They are
ಅದು
already,
impleading
That is
allow-
permitted.
they are already,
impleading allow ಮಾಡ್ಬೋಣ so that
only for extent of compromise petition, that is only their role. For that reason, your lordship, I have no objection to allow that impleading application.
That's why I'm doing all this in their favor, my lord. I am bringing all persons in on record and compromise to take place.
For only extent for compromise, you have no objection. Brought their record.
Otherwise, I am having a case in RFA.
argue.
No, that's what compromise is taking place.
Why are you wasting
I am
time?
not insisting.
Why are you wasting your time and our time. Argue.
We are before the court.
Before the court, argument cardinal madak bartada. In our order dated 7/11/2024, we had said as under. First off, the above order obviously was structured on the premise that parties were parleying. First off. Today, learned counsel appearing for the appellant submits that impleading application needs to be considered. And learned counsel appearing for the opposing parties agrees that impleading be permitted for the purpose of bringing about an amicable settlement so that list can be settled once for all. First off. Next part, in view of the above, the subject application having been supported by an affidavit, having been favored, leave to implead as sought for is accorded. First up, appellant to amend the cost title right now. Amendment. Call this matter for reporting settlement on 19 is to the matters. Agalog, 9 matters is the period date.
5th of December.
5th of December.
Because she came from Chennai, she is there.
Why? Because they have to sign the papers. All right. 5th of December. All right. If settlement is not reported, matter shall be heard on that day, hopefully. Okay. ಅದೆರಡು ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಬೇಕು ಅದು ರೆಡಿ ಮಾಡ್ಬಿಡಿ ಆಯ್ತು ಮಾಡಿ ಹಾಕಿದ್ರೆ ಸೇಮ್ ಆರ್ಡರ್ ಆನ್ ಬೋತ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ ಸೇಮ್ ದಿಸ್ ಎಸ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ ಮಾಡಬೇಕು ಫಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ ಮಾಡಬೇಕು ಎಸ್ ಎಸ್ ಮಿಸ್ಟರ್ ಹೆಗಡೆ
Let's dependents appeal.
APA for the respondent in this. This was last week, today it is posted. It was a small matter where I requested lordships that I have paid advance. It is only regarding alternate relief trial court granted for refund. Against that, lords, the owner of the property has filed this appeal. Specific performance suit. Trial court's judgment is to refund the advance. Against
and he has retained the property. Whether property was with you at any point of time?
The property he has sold it to somebody else, my lords.
He has sold it to
It
somebody
was a
else.
specific
And,
performance for the enforcement of the contract. Let's by the time the suit was filed, the property was alienated to the third party. Then the plaintiff restricted the suit claim only
Refund.
for the refunding of
ಯಾವ section ಅದು?
refunding of 20 lakhs.
Section ಯಾವ್ದು ಅಂದಿದೆ ಅದರಲ್ಲಿ? ಅದು ಒರಿಜಿನಲ್ ಆಗಿ ಮಾಡಿದ್ರು, ನಾಟ್ ಅಮೆಂಡ್ಮೆಂಟ್.
My lord.
It was the original plaintiff, original prayer ಆದಿತ್ತು.
No, my lords,
We filed a memo, my lords, restricting the claim that instead
Only
of-
for refund.
only for the alternate relief of
Okay.
refund, my lords.
All right.
During the pendants.
Let's the written statement what we had filed before the trial court, we had denied the execution of the subject matter of the agreement. Let's
That amount was paid in cash or check?
Cash.
It was paid in
Cash. We had denied. Let's, I'll just put it in a nutshell. Let's my specific, the agreement, the so-called, the agreement is dated 21/5/2009.
21/5?
2009 for an amount of rupees 55 lakhs. For an amount of rupees 55 lakhs. Advance.
How much was paid to you?
20 lakhs was said to have been paid. Let's, we filed a written statement. But on 20th of April 2009, there was an agreement in respect of the same property.
You filed WS on?
Let's, I filed.
That date cannot be.
Let's,
You filed the WS on which date?
let's, I lied. Let's, I filed a WS on 14th. Sorry, let's.
Otherwise, you would be filing the WS without there being a plaint.
No, my lords, the plaintiff.
Which date? Please tell us
Yes.
the date. Waste time.
My lords, the suit is of the year 2009. My
When
lords,
WS was filed.
I will.
14th March.
My lords, the 14th March
To prove agreement.
11.
All right, understood. To prove agreement,
Yes.
who were examined from their side.
My lords, the plaintiff.
How your cross-examination?
The plaintiff is
That's the
PW1.
only
My
point.
lords, I'll just 2 minutes, I'll take the background of this case. So that will throw the better light on the entire case, my lords. My lords, my defense was the so-called agreement of dated 21/5/2009 is a sham document. It is not executed by me. However,
Sham or concocted?
it is concocted. I stand corrected. Understand? But how it has been concocted. My lords, my defense was, my lords, the written statement on 20th of April 2009, there was an agreement between the parties wherein the sale amount was agreed to be paid for rupees 35 lakhs. Under the 35, my lords, out of 35 lakhs, 5 lakh was paid to me by cash and 15 lakhs was supposed to be paid by way of a check, and description of the checks was also mentioned in the agreement. Subsequently, the check was not duly honored. It was not passed on. The check leaf has not been passed on. But subsequent,
Honored case alive.
it is not honored. It is not passed on at all.
Check was not given to you at all.
Yes. Though
But,
it was,
though it is said in the. agreement.
description has been mentioned in the agreement.
Fact remains that check is not, realized.
Yes,
That
my-
remains as it.
Yes, my lords. My lords,
ಸಂಗಮೇಶ್
Lord,
ಕೊಟ್ಟಂತ ಚೆಕ್ ಪ್ರೆಸೆಂಟ್ ಆಗಿತ್ತಾ ಅಥವಾ ಪ್ರೆಸೆಂಟ್ ಆಗಿಲ್ಲ?
present ಆಗಿಲ್ಲ, instead of
ಆಗಿಲ್ಲ.
that, cash has been paid.
subsequently, my lords, when I insisted for the passing of the check, my lords, the plaintiff says that he wants to take the loan from the bank for purchasing of this property. The earlier agreement may not help him. So execute another agreement, helkondu, he takes my signature on a blank paper.
What is the qualification of your client?
My lords,
Is standing in the light?
I'm sorry, my lords, I don't have ready information about the qualification, but he is, when I spoke to him, I can make out, my lords, he is a qualified person. He is a qualified person.
ಏನ್ ಮಾಡ್ತಾರೆ ಅವ್ರ ಕೆಲಸ?
He is a musician.
Magician.
He is a musician. He plays flute.
It's nice that he is not a magician. Therefore, he has engaged an advocate having magical powers of argument.
He takes the signature on a blank paper. Subsequently, he comes once again, informs
Stamp
that
paper, ಸಾದಾ paper.
stamp paper.
Paper ಮೇಲೆ.
Subsequently, he says he could not, they purchase the property because there is no loan has been sanctioned. Hence, the earlier agreement was cancelled. The earlier agreement, that is on 24/4/2009, the agreement is cancelled. Original has been returned to me. Original has been.
One second. It is cancelled under the second agreement.
No,
dated
the
21.
second agreement was a blank paper.
It
was-
was blank paper is your case.
Yes, my pay. He says he could not secure.
Witnesses is ಅನ್ನೋದಕ್ಕೆ.
Yeah, my lords.
Are there witnesses to this agreement?
Yes, my lords.
Yes, yes.
ಯಾರು
Yes.
witnessಗಳು?
PW2 is the witness. PW2 is.
Two
the-
is witness.
PW2 is the witness.
How is he related to you, known to you?
My lords, he claims he is known to both of us.
What you say?
My lords, he is known to us also. He is known. My lords, subsequently, my further defense is, he returns the original of the first, this one. The second one, he says, I had given it to the bank for the sanctioning of the loan. They have not sanctioned the loan. I will get it and return it. By then, my property was already under the equitable mortgage with the bank. The bank has issued a notice for bringing the property for auction. Under that circumstances, I entered into a contract with the third party where the loan was taken over by the third party. They purchased the property. Now the suit was filed. What?
5 ಲಕ್ಷ ರೂಪಾಯಿ ಇಸ್ಕೊಂಡಿದ್ ನಿಜ.
5 ಲಕ್ಷ ಇಸ್ಕೊಂಡಿದ್ದು ನಿಜ.
ಆ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಿದ್ರ WS ನಲ್ಲಿ?
ಹೌದು, ತಗೊಂಡು.
Show that.
Even notice has been,
Let us-
notice reply nu ಕೊಟ್ಟಿದ್ದೀನಿ.
Where is that WS stand?
My lords, may kindly come to my, in the paper book ಅಲ್ಲಿ, page number 7 ನಲ್ಲಿ WS start ಆಗುತ್ತೆ.
ಯಾವ paragraph?
Paragraph number 3.
7.
In the month of April 2009, the dependent was urgent need of money. At that time, the plaintiff approached.
5 lakh rupees iskond ಬಗ್ಗೆ ಎಲ್ಲಿದೆ? Then
Well,
plaintiff
last-
paid rupees 5, last line.
Last 2 lines is all.
Then plaintiff at page 8, paid rupees 5 lakhs by transferring a sum of rupees 4 lakh 52 to the account of the brother of
52,000.
the defendant Muralidhar and paid 4 lakh 81,000.
Then the plaintiff agreed to issue the check for rupees 15 lakhs white check number so and so drawn on State Bank of India, Kuvempu Nagar, Mysore in favor of.
1 second.
Yes,
Kindly come to last 2 lines of page 8.
please, my lords.
Then the plaintiffs paid.
Then the
This is
plaintiff-
your version.
Yes, my lords.
Rupees 5 lakhs by transferring a sum of rupees
4,52,000 to the accounts of the brother of the dependent, Muralidhar, and
paid
40,
rupees 4 lakh 81,000.
it is a 48,000. It's a typographical error, ಅದು 48,000.
48,000.
Howdo, 48,000. To the dependent by cash. It's a typographical error. Well, subsequently, what transpires well, during the course of the
52
trial,
plus 48,000, why? 5 lakh 1,100. 52,000, 48, 1,000. 48 ಅಷ್ಟೇ.
48,000 ಆಗಬೇಕು, 1.
1 to be ignored.
Yes.
48.
What? It is admitted fact.
The plaintiff, ಅದನ್ನ ಆ ದುಡ್ಡು ಕೊಟ್ರ ವಾಪಸ್ ಅವ್ರಿಗೆ?
My lords,
5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ರ?
my lords, though I have stated in my written statement that at the time of cancelling the first agreement, we have returned it ಅಂತ ಹೇಳಿ ಹೇಳಿದೀವಿ ನಾವು. But I have not inquired into my clients to be fair. My lords, now that,
Should have paid.
yes,
You should have said,
I have,
take this 5 lakhs.
yes, that's what I have
At
stated.
no
in-
point of time you have said that.
My lords,
And on the other hand, your pleadings
yes,
are different.
my lords, kindly see the paragraph number 4 at page number 10. Thereupon, the plaintiff did not approach the dependent, nor issued the check to the dependent, nor made arrangement for the payment of the balance of the sale consideration to the dependent. In the month of June 2009, the plaintiff approached the dependent along
You have
with
said we have refunded rupees 5 lakhs to the plaintiff.
5 lakhs and the dependent.
Where is the, but if you say we have refunded,
Yes.
that amounts to admitting that we have received, that amount was due to him. Where is the proof for that?
My lords, apart from the averments, I have no proof. My lords. I have no proof.
Any witness said on that? When, how that money was given?
The
Because
rent-
they gave the money by check. They credited the money to you
Yes,
and to your brother.
yes. My
Where
lords,
have you taken
there
up
is,
the-
apart from this, my lords, it's a limited because I have filed an application for the production of the additional evidence also. Now, what transpired subsequently, my lords, during the course of the cross-examination, the original of that agreement which was returned by him, it was misplaced. But the photocopy which was given to me when it was entered, it was in my hand. During the course of the evidence, it was that photocopy which was not cancelled then. It was marked as exhibit P4, exhibit D4.
From
Exhibit
your evidence.
Exhibit D4 in my
Subject
evidence.
to objection.
Subject to objection. Plus, the trial court has discarded that entire evidence because it was a photocopy and it could not have been relied. But subsequently, I traced that the original of that document, it was cancelled agreement. Now, along with the main matter itself, I filed an application along with the,
No, that's all.
The
right.
original.
But
But-
you should have, if your version to be accepted, you
Yes.
should have said, brother, I had taken 5 lakh from you.
Yes.
Take this 5 lakh. Then court would have passed order 12 rule 6, judgment on admission. Straight away, ಅಷ್ಟ್ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತು.
my lords,
ಅದನ್ನೂ ಕೊಡಲ್ಲ, ಇದನ್ನೂ ಕೊಡಲ್ಲ. ನಾವ್ ಹಿಂಗೆ ಇರ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ. How to falsus in, falsus omnibus. Roman lawyers used to say. One, if a person lies, though it is not applicable to criminal case, in civil case, there is scope for such invocation. You should have given. On the other hand, not only you did not give, you took up a false stand that I have paid back this money. Paid back amounts to admission under section 58 of the admission, the evidence act.
Please,
One who
please.
says, I have paid, then admission is that so much money was received and so much money was due.
it was due. Yes.
Then you have not established that repayment.
Let's, kindly see the document which I have enclosed along with
No, we'll agree.
the IA for additional.
Even going by your version now.
Apart from that, my lords, apart from my, the averments in the written statement,
ಅದು ಸಹಿತ ನೋಡಿ. Defendant requested to so and so, accordingly defendant defended 5 lakhs to the plaintiff. ಯಾವಾಗ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ, ನೀವ್ ಯಾವತ್ ಕೊಟ್ರಿ, ಆ ಅಮೌಂಟ್ ಅನ್ನು ಎಲ್ಲಿಂದ ತಗೊಂಬಂದ್ರಿ? ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ. ಎಲ್ಲಿದೆ? Yes, bare, very, very naked pleadings.
Yes, my lords. My lords, may I take your lordship to exhibit T3, my lords, for a moment?
Page number?
Page number 98. Page number 98 is the reply.
Where you
Reply
admitted
notice.
5 lakhs received.
Even prior to, my lords, the initiation of the suit.
Correct.
My lords, in response to his notice, I had taken a specific contention even there also.
Correct. Why did you not send the money
Yes.
with this notice?
My lords, that is
Take
the,
back your money.
my lords, the original was collected and the
You should
amount
have
was
said,
paid.
you at least you should give that original and get the money back. Where is the stand?
No, original has been returned.
Returned.
It is, but that's why I filed an application for
Correct.
return.
Then why, where is the justification for retaining his money of 5
My
lakhs?
lords, that I have no other, this one.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಇಟ್ಕೊಂಡು?
My lords, it is from 2009, from 2009 on.
9, 8% ಆಗಿ ಹಿಡಿದ್ರೆ ಎಷ್ಟಾಗ್ತದೆ? 2009, 2019, then 5 years.
15 years.
15 years.
15 years.
7%, 8% ಅಂತ ತಗೊಂಡ್ರೆ 15 ಎಂಟ್ಲೆ 120, 120% ಆಗ್ತದೆ. 5, 10 ಪ್ಲಸ್ 60,000. 10 ಲಕ್ಷ 60,000 ರೂಪಾಯಿ. Even going by frugal rates of interest.
Yes.
It will be this one. But Justice Bhandari, Dalivir Bhandari writes, in matters like this, no frugal interest. It should be 2% per mention. ಹಂಗಿದೆಯಲ್ಲ? Because it's a commercial transaction. ಏನದು ಪ್ರಾಪರ್ಟಿ?
It is a two-storied building on a 60-40 site in Mysore, Kuvempu Nagar.
No issue. Retain the property, but you back what is.
Perhaps it has been already.
There's a very, very good
Given
poem
the-
by Shakespeare,
It is already been.
where the engagement ring was given to the bride, but it did not materialize. He asked the bride to return the engagement ring. He did not return. That's one very good poem. He refers to Greek story, the Greek mythology. Who pens that this one? There's no law in Shakespeare. There's a famous book by Harris. Anyway, that amount ಅವರು ಕೊಡ್ಬೇಕು. ಅದ್ರ ಪ್ರಕಾರನೇ 10,60,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು. ಪ್ಲಸ್ ನೀವು ಸೂಟ್ ಹಾಕ್ಸಿರಿ ಅವ್ರ ಕೈಯಿಂದ, ಇಷ್ಟು ವರ್ಷ ಒದ್ದಾಡ್ಸಿರಿ, ಡಿಕ್ರಿ ಆಗಿದ್ದು 20 ಲಕ್ಷ, ಒಂದು 15 ಕೂಡಿಸಿ.
ಇಲ್ಲ. Millers, the trial court has not considered the original agreement. The trial court has passed the decree based on the second agreement.
Document, stamp.
The decree is based on the second agreement.
ಯಾವುದೋ ಒಂದು ಪೇಪರ್ ಮೇಲೆ ಒಂದು ಎಂತದೋ
Yes, my lords.
ಒಂದು ಸಾದಾ ಪೇಪರ್ ಮೇಲೆ ಅವರು ಮಾಡಿದ್ರು. We can understand.
Sitting
Is he an income tax payer? Is he income tax payer?
Millers, I'm really sorry, Millers, I'm short of information, Millers. I'm short of-
ಸಂಗಮೇಶ್ ಏನಾದ್ರು ಒಂದು some compromise. These
fact-
things happen. Otherwise ನಾವು ಇದನ್ನ ಮಾಡ್ಕೋತ
Before entering into the
Millers,
court, I requested my
Before
senior
entering
friend,
into the court,
I requested if there is any
Millers,
possibility, then he said he has to.
ಎಂತದ ಒಂದು ಮಾಡ್ಕೋಬೇಕು. ವೆರಿ ಆಫನ್ ವಿ ಕೋಟ್ ಭರ್ತೃಹರಿ ನೀತಿ ಶತಕ ಯಾವುದೋ ಒಂದರಲ್ಲಿ ಒಂದು ಶುಕ್ರ ನೀತಿಯಲ್ಲಿ ಬರ್ತದೆ. ವಿನಾಶಕಾಲೇ ಸಮುತ್ಪನ್ನೆ ಅರ್ಧಂ ತ್ಯಜಿತ ಪಂಡಿತ. When everything is going, one who retains 50% is the wise man. He's a pandit.
Millers, in fact,
It applies to both of you, because what order we are going to pass, we do not know.
Millers, in fact, while coming inside, I have told him that my client, looking at my client, Millers, it's very difficult for me to convince him, but I'll take one more opportunity to prevail upon him and I will try to convince him.
ನಾಳೆನೆ ಮಾಡ್ಕೊಂಡ್ಬರ್ಬೇಕು. ಈಗ we have heard you, ಮುಗಿದು ಹೊತ್ತು ಅಷ್ಟೇ.
Millers, could it be taken on Monday, Millers?
Today.
Oh, Monday, sorry, Monday is a holiday, Tuesday. Tuesday.
But so far as
4127 ಅಲೋ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Xerox was produced there.
ಇಲ್ಲಿ ಒರಿಜಿನಲ್ ಪ್ರೊಡ್ಯೂಸ್.
And now original comes within the four corners of.
That 4127 ಆಗ ಬರುತ್ತೆ.
section, additional evidence and.
ಬಂತು ಅಂದ್ರೆ what is your position?
So
ಅದು ಮತ್ತೆ ರೀಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
reconsider ಇಲ್ಲೇ ಮುಗಿಸೋದು ಅದನ್ನೆಲ್ಲ. ಮತ್ತೆ ಇನ್ನೊಂದು 20 ವರ್ಷ ನಡೆಸ್ತದೆ ಇಷ್ಟೇ ಕೇಸ್.
I will. Statement regarding.
ಕೊಡ್ತೇವೆ ಅಷ್ಟೇ.
ಅದು ಮಾಡಿದಾಗ where you will be, that is what, that's what.
Because
So as a wise man, what you will do is you are the.
wise man and wise lawyer also. But he is very fairly, he said, something can be done. Better.
That's why my lords, I asked before commencement.
Judgment ಬರೆಯೋದ್ರಿಂದ ಜಸ್ಟಿಸ್ ಆಗಲ್ಲ. ಅಂದಾದ್ರೆ ಇಬ್ರು ಒಪ್ಕೊಂಡ್ಬಿಟ್ರೆ
Agreement ಏನು 20 ಲಕ್ಷ ಇದೆ.
ಅದು ಹೋಗ್ಬಿಡ್ತದೆ.
That will be under the cloud.
15 ಲಕ್ಷದಷ್ಟು ಕ್ರೌಡ್. ಅಲ್ಲ 5 ಕೊಟ್ಟಿದ್ದು ಒಪ್ಕೊಂಡಾದ್ರು.
Election ಅದು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಹಂಗಾಗಿ ಓನ್ಲಿ 15 ಬರ್ತದೆ. ಅಟ್ ಲೀಸ್ಟ್ 15 ಆದ್ರೂ ಮತ್ತೆ
ಎರಡನೇದೊಳಗೆ 20 ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ.
ಹೌದು. 20.
ಸೆಕೆಂಡ್ ಒಳಗೆ 20.
But the contention that the second agreement is a blank signed paper that may not
that's
stand,
exactly.
because the perusal of the agreement, that's why, my lords, I will not take, my lords, argue on those points. My lords, let him come back. We will, I will also take.
You should have explained this 5 lakh agreement also in your say. But you suppressed it, no?
Plaint ನಲ್ಲಿ you should have pleaded 1 sentence, 2 sentences.
Madland agreement is
And in
not-
evidence.
That is not your contention. To that extent, you have suppressed the facts.
Therefore, he also suppressed, he took up one false plea that we have made the payment.
Create.
Anyway, many times pleas are taken because of lawyers' advice. Plaints and written statements ಯಾರು ಓದ್ತಾರೆ, ಲಾಯರ್ ತಯಾರಿ ಮಾಡ್ತಾರೆ, ಹಾಕ್ತೀವಿ ಮಾಡ್ತಾರೆ. Anyway, evidence ನಲ್ಲಿ ಆದ್ರೂ ಎಲ್ಲರೂ ಒಂದ್ ಕಡೆ ಹೇಳ್ಬೇಕಿತ್ತು. ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಕೂತ್ಕೊಳ್ಳಿ, sit under the shadow of nearby tree. ಕೂತ್ಕೊಂಡು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋಬೇಕು, because we do not know what judgment we are going to pass.
Very well.
Please, madam, please. Oblige.
For this matter for further hearing on Tuesday. In the
Please.
meanwhile, parties to work out amicable settlement if possible.
Please.
Obliged.
Okay. Yes, Mr. Shastri. ಶಾಸ್ತ್ರಿಗಳು ಸ್ಮೈಲ್ ಮಾಡ್ಕೋತ ಬರ್ತಾ ಇದ್ದಾರೆ. ನಮಗೆ ಸ್ವಲ್ಪ ಭಯನೇ, ನೀವು ಸ್ಮೈಲ್ ಮಾಡಿದಗಿನ. We have to wear our guard. Good lawyer. Shastri versus Shastri.
Just a list of dates,
Yeah.
some
Put it,
mathematics, it will be useful.
To put it lightly, Shastri versus Shastri arguing before Dikshit and Joshi. So there cannot be allegation of bias, etc.
By anyone, by anyone.
Yes. What is this case about? Just make a statement.
That the suit is one million for a declaration of title, for possession,
Adverse
and
petition.
for, I set up adverse. Possession is not proved.
Yes.
My lord, the facts are, it is the case of the plaintiff. My lord, that father of the plaintiffs, one Madhavara was the owner. He died, my lord, on 5/2/1997, leaving the plaintiffs. The plaintiffs found, my lord, that
Your
the,
friends need not wait. Perhaps it will take time. You can come afternoon. Magarajappa, madhyana bani. Yes. 27. Reddy na? ಏನೋ ಟೈಮ್ ಕೊಡ್ರಿ ಒಂದು.
ಇವತ್ತು ಆಗತ್ತೆ ಸರ್, ಮುಂದೆ ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಅವ್ರು ಮಾಡ್ಲಿ ಅಂತ ನಮ್ಮ
ಅದೇ next
ಶಿಗಾರ.
date ಮಾಡಿ. ನೋಡಿದ್ ನೋಡ್. Yes.
My lord, it is a further contention of the plaintiff that defendant has trespassed to the suit scheduled property.
Where are the issues?
Lord, issues are, Lord,
120 in the paper book.
page 120, Lord. Page 120. Do the plaintiffs prove their ownership over the suit schedule property as alleged? Do the plaintiffs prove that the agreement dated 13/8/1992 is a bogus document as alleged? Do the defendant number one prove that the defendant number one has perfected his title to the suit property by a federal's position as alleged? Whether the suit property is properly valued and proper court fee paid? Whether the plaintiffs are entitled for the relief of declaration and possession and damages as paid for, what decree and what order? So for this issue number one is held to be, Lord, affirmative, there is no dispute about it. I admit the title.
You admit the type,
I
because
admit-
you adverse possession plead ಮಾಡಿದ್ರೆ admission ಆಗ್ಬಿಡ್ತದೆ.
Admission ಆದಂಗೆ, but very clearly they have admitted the title of the plaintiff in the written
So
statement.
first issue is, it goes against you.
There is,
In other words, it goes in his favor.
in his favor.
So there is no other question now.
Other question.
Next,
Then, do the plaintiffs prove that the agreement dated 13/8/1992 is
it's a bogus document as alleged.
That is,
ಈ agreement ಏನು? How you are,
this is
under that agreement, you agreed to buy the
Okay.
property.
that is someone, my lord, representing or someone, one Rajaram, a person who has no right, title and interest in respect to the suit property, has executed an agreement of sale dated 13/8/1992 in favor of this defendant.
ನಿಮ್ client,
He claimed as a.
appellants,
Please,
in favor of appellants.
in for the defendants, in the sense, appellants in the sense,
Appellants.
appellants. That way, defendant entered into the possession of the suit property in the year 1995. He put up the construction and plaintiff filed, my lord. That is, they say this agreement is false, forged and all that. This someone, a person who has no title has created this agreement in favor of the defendant.
To be the owner.
Claiming to be the, he claimed to be the owner.
You believe.
I believed it, I believed it.
Terms of the
In-
agreement ಏನು?
In Bangalore, Lord, no agreement is produced before the trial court. So we can't make out any terms of the agreement.
No, if you were claiming something under the agreement, onus is on you. They may have pleaded,
Lord, I did not claim any right under the agreement. I
but you
said,
did not dispute existence of the agreement.
that is right, that is right.
Then
And I also said, I came into possession that way.
Came into possession on the basis of that.
some other.
Correct.
ಅಲ್ಲ,
Owner son
he
ಅಂತ.
is not the owner of the property.
He is not the owner, but.
Owner son ಅಂತ.
Under that, he
I
enters
came under the.
possession of the
On
property.
the basis of that agreement,
And I,
non-owner,
Owner son ಅಂತ. Rajaram,
but there is no such son.
no such son. Earlier there were proceedings. Earlier two suits were filed, my lord, wherein he himself has produced, my lord, sought protection under that agreement. Suit for injunction.
That suit was by him,
there are two
not
suits.
to be dispossessed except in accordance with law.
Confirmed by this honorable court in RF. And we have given liberty to file suit for possession.
Only agreement was pressed into service. Whether anybody was examined to prove the agreement? In that suit,
Nobody was.
suit ಹೆಂಗ್ decree ಆಯ್ತು? Trial ಆಯ್ತಾ ಇಲ್ಲ?
That is,
Fine.
Lord, no. There are two suits, my lord. The plaintiff filed, my lord, in my synopsis gives these facts. OS 6757 of 1999 was filed by the present plaintiffs against the defendant for a direction to demolish the structure, mandatory injunction, put up by the defendants, and on failure, permit the plaintiffs to demolish the same. That, my lord, is the relief in that suit.
ಅಲ್ಲಿ ಏನಾಯ್ತು suit?
That suit came to be dismissed. Because they are not in possession. Not one can't ask for injunction
Without being in possession.
without making. He's not in possession, nor he has prayed for relief of possession. So naturally, my lord, a mere mandatory injunction demolish, my lord, is without any basis.
But
there, my lord,
suppose I permit you to be in the possession of the property
yes,
and you put something unauthorizedly. Why should I be in possession to seek a mandatory injunction to demolish that structure?
it is right, my lord, when a person with the title, my lord, permits the other person. But now here, my lord, I am a simple trespasser. It is not the plaintiffs that have permitted, or plaintiff's father, my lord, permitted me to put up any construction. I put up illegally, unauthorizedly. So, my
ಆ
lord,
suit dismiss ಆದ್ಮೇಲೆ ಮುಂದೇನಾಯ್ತು?
then, my lord, they have filed the present suit.
RFA ಹಾಕಿದ್ರು.
RFA ಆಯ್ತು.
RFA,
ದಲ್ಲಿ ಏನಾಯ್ತು?
that RFA, my lord, his
Decree was
RFA was
confirmed.
dismissed.
We were permitted to take possession in accordance
But
with.
his appeal was dismissed. And so far as my suit is concerned, I filed OS number 6757 of 1995, my lord, against these persons. For
Not to be dispossessed,
not to be
except in accordance
injunction.
with law.
So court protected me. Court said, unless they take possession in accordance with law, they can't forcibly take.
ಅಲ್ಲಿ issues ಏನೇನಿತ್ತು, ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಏನಾಗಿತ್ತು ಸ್ವಲ್ಪ ತೋರಿಸಿ. ಅದು ಪಾರ್ಟ್ ಆಫ್ ದಿ ರೆಕಾರ್ಡ್ ಆಗಿದೆಯಾ ಇಲ್ಲಿ? ಆಗಿದೆ.
Both these judgments
ಆಗಿದೆ.
are
ಎಕ್ಸಿಬಿಟ್ಸ್ ಆಗಿರ್ಲೇಬೇಕು. ಅಲ್ಲಿ ಏನಂತ ನಿಮ್ಮ
ನೋಡಿ,
title
P13
ಮೇಲೆ ಏನಾದ್ರು
Order passed by this honorable court, page 94.
ಕಾಂಪ್ರಮೈಸ್ ಇಂಪಾಸಿಬಲ್ ಅನ್ನೋ ಸ್ಟೇಕ್ಸ್ ಎಲ್ಲ ಹೆವಿ ಇರೋದಕ್ಕೆ.
compromise, my lord, my clients had attempted, but it seems there some adjustment relating to financial could not be arrived at. Page 99, my lord, is the finding. In my suit, my lord, OS
ಅಲ್ಲ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ ಅನ್ನೋದು pursuant to which you have entered, gained entry to the ಅದಿಲ್ಲ. But you claimed that by pursuant to that agreement, we gained entry to this property and we have put construction.
Correct, correct.
Structures.
Correct, correct. Lord, that is, a person enters into possession under a document which is invalid and illegal and void. So his possession itself is, right from the beginning, is that of a trespasser.
No, that contention you did not take up. That is not the structuring of your pleadings in the earlier suit.
No, all throughout, my lord, even fact, in fact.
You all throughout, you told the courts below and thereafter in RFA that your possession is lawful.
My lord, that my possession is unlawful is the very case of the plaintiffs, my lord, in the earlier suits.
Correct.
Exhibit D1, my lord, your lordship may kindly turn to page 103.
Yes, we read that. There only I asked.
There they say, my lord.
All through, you said your possession is lawful. Can you one fine day turn around and say, no, right from the beginning, I am a trespasser and I become a title holder by adverse possession?
No, my lord. All throughout, I said, I entered into possession under a person who has no title. I admitted that title all throughout. I did not dispute their title. But I am in possession and I put up a construction. That was my defense all throughout.
Case is not that. At the earliest point of time, your case is not that. You are in illegal, unauthorized occupation of the property.
No, when you said an agreement with that person,
Son of mother of.
there it's.
No.
He
Blood-
entered into an agreement with that person on believing that he is the owner, not he.
Therefore,
No,
where
how
is?
could you reconcile your
Discuss
contention
that.
that he was the owner and therefore I entered into an agreement, but I entered to his knowledge, adverse to his.
Because two things are essential, right from the pre-council days. Animus is necessary, factum is necessary. Only then adverse possession. If we accept my possession can be adverse as against X, but my possession can be non-adverse or permissive as against Y. How that reconcile madakagodilla? Your very case is,
it is like
lawfully I entered into possession of the property. Where is your WS is not marked in the petition, or WS mark madilva? Madlin suit nalli.
ಮೊದಲಿನ ಸೂಟ್ ಅಂಡ್
Mark
ಜಡ್ಜ್ಮೆಂಟ್
ಮಾಡಿಲ್ಲ.
ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ.
ಸೂಟ್ ಅನ್ನ
ಅಗ್ರಿಮೆಂಟ್ ಅಂದ್ರೆ 53A ಬರುತ್ತೆ.
marked is plaint in the previous suit, my lord,
ಅಲ್ಲಿ
where they claimed.
ಮೊದಲನೇದು ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಂತ ತೊಗೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಎಸ್ಟಾಪಲ್ ಬೈ ಪ್ಲೀಡಿಂಗ್ಸ್ ಆಗ್ತಿತ್ತು. ಪಿಯಾಸ್ ಎಸ್ಟಾಪಲ್ ಬೈ ಪಿಯಾಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು. ಈಗ ಅದನ್ನ ನಮಗೆ ಈಗ ಮಟೀರಿಯಲ್ ಇಲ್ಲ ನಮ್ಮ ಮುಂದೆ. ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ಅಲ್ಲಿ ಎಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ನಾವು ಇವ್ರ ಸ್ಟ್ಯಾಂಡ್ ಅನ್ನ
ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ
ಪ್ಲೀಸ್. Page 65, my lord, the earlier suit.
65.
Page 63 ಅಲ್ಲಿ extract ಮಾಡ್ತಾರೆ. The facts of the case in brief are as follows. Plaintiff is myself. The plaintiff is an educational trust being represented by its trustees. It is running an educational institution. The plaintiffs wanted some additional accommodation for its school. The scheduled property was lying vacant for a long time. Therefore, it had negotiations with the defendant number 1.
So you negotiated with defendant number 1. Ivre neeve. Defendant 1 is neeve, no? Ali defendant 1.
Rajaram.
Rajaram. Two only.
No,
Rajaram.
Not himself.
Rajaram, page 61.
Case of the plaintiffs in this case is no such person was there. No, he is a fictitious man. The scheduled property was lying vacant for a long time. Therefore, it had negotiations with the defendant number 1 with the view to purchasing it. Defendant number 1 is the son of K.H. Madhavrao, to whom the scheduled property would belong. Therefore, when the defendant number 1
He has no son at all.
Rajaram son.
By name Rajaram, there was no son.
Any other son?
The plaintiffs.
Plaintiff.
Plaintiffs are the children of plaintiff number 2 and 3 are the sons of Madhavrao. Plaintiff number 1 is the daughter. Therefore, when defendant number 1 was contacted by the plaintiff, he entered into an agreement with the plaintiff on 13.
BDA site ಅನ್ನೋದು. BDA site. ಕನ್ವೆನ್ಸ್ ಆದ್ಮೇಲೆ ಮಾಡಿ ಕೊಡಬೇಕು ಅನ್ನುವಂತ ಒಪ್ಪಿಗೆ ಮಾಡಿಕೊಂಡ್ವಿ ಅಂತ ಹೇಳ್ತೀರಿ. ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಆ ರೀತಿ ಇದೆ. Somewhere I read that yesterday. You took up the contention that the BDA site ಅದು ಕನ್ವೆನ್ಸ್ ಇನ್ನೂ ಆಗಿರಲಿಲ್ಲ.
Revenue site
ಆದ್ಮೇಲೆ ನಮಗೆ
revenue site reconvey ಆದ್ಮೇಲೆ
ಮಾಡಿಕೊಡ್ತೀವಿ.
ಅಂದ್ರೆ ಎಕ್ವೈರ್ ಆಗಿರೋ ಜಾಗ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಆಗಿ.
So your very case is that plaintiff was put in possession of the scheduled property by defendants themselves.
By the first defendant, Lord Rajaram.
No, all defendants. All defendants. 64.
Correct.
ಎಲ್ಲರಿಗೂ ಇದೆ. That is his style. How can he maintain adverse possession, please? When we gained entry, it was lawful, but from a particular point of time, it turned to be unlawful anta ಹೇಳಿಕ್ ಬರ್ತದೆ. 63 na 64 Bombay law BLR. From which date it turned to be hostile? ಅದನ್ನ ಹೇಳ್ಬೇಕಾಗ, because you have taken a stand That can be estoppel by fees also. For that, there need not be other evidence.
There, my lord, I may bring to your lordship's consideration
Yes.
the admissions of PW1, my lord, at page 27.
27.
Chief is 27. The cross, my lord, is very brief, my lord. Page 35, my lord. Page 35.
35.
ನಾನು BSc B.Ed ಪದವೀಧರೆ, ನನ್ನ ಸಹೋದರರು ಸಹ ವಿದ್ಯಾವಂತರು ಎನ್ನುವುದು ಸರಿ. ನನ್ನ ಸಹೋದರ 8ನೇ ತರಗತಿ ಓದಿದ್ದಾರೆ. ಶ್ರೀರಾಜರಾಮರವರು ಬರೆದುಕೊಟ್ಟರಿಲ್ಲದ ದಿನಾಂಕ 13/8/92 ಕರಾರು ಪತ್ರವನ್ನು ನಾನು ನೋಡಿಲ್ಲ. ದಾವೆ ಸೊತ್ತು
ಸೇರಿದ್ದು ವಿಷಯ.
ನನ್ನ ತಂದೆ ತೀರಿಕೊಂಡ ನಂತರ ದಾವೆ ಸೊತ್ತು ಆತನ ವಾರಸಾದ ನಮ್ಗೆ ಸೇರಿದೆ ಎನ್ನುವ ವಿಚಾರ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಗೊತ್ತು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ದಾವೆ ಸೊತ್ತು ಪ್ರತಿವಾದಿಗಳ ಸ್ವಾಧೀನದಲ್ಲಿದೆ ಎನ್ನುವ ವಿಚಾರ ನನಗೆ ಗೊತ್ತು ಎನ್ನುವುದು ಸರಿ. 1992ರಿಂದಲೂ ನನಗೆ ಆ ವಿಚಾರ ಗೊತ್ತಿದೆ. ಪ್ರತಿವಾದಿಗಳು ದಾವೆ ಸೊತ್ತಿನಲ್ಲಿ ಒಂದು ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿದ್ದು, ಆ ಕಟ್ಟಡವೂ ಸಹ ಅವರ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೆ ಎನ್ನುವ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿದೆ ಎನ್ನುವುದು ಸರಿ. 1994ರಿಂದಲೂ ಸದರಿ ಕಟ್ಟಡ ಇದೆ ಎಂದರೆ ಇರಬಹುದು. ಆ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಲು ಪ್ರತಿವಾದಿಗಳು ನಮ್ಮ ತಂದೆಯ ಅಥವಾ ನಮ್ಮ ಅನುಮತಿ ಪಡೆದಿಲ್ಲ ಎನ್ನುವುದು ಸರಿ. ದಾವೆ ಸೊತ್ತಿನ ಸ್ವಾಧೀನಕ್ಕೆ ಪ್ರತಿವಾದಿಗಳು ಬಂದಾಗ ಸಹ ಅವರು ನಮ್ಮ ಕುಟುಂಬದ ಅನುಮತಿ ಪಡೆದಿಲ್ಲ ಎನ್ನುವುದು ಸರಿ. 1994ರಲ್ಲಿ ನಾವು ಕಟ್ಟಡವನ್ನು ತೆರವು ಮಾಡಬೇಕೆಂದು ಪ್ರತಿವಾದಿಗಳನ್ನು ಕೇಳಿದೆವು ಎನ್ನುವುದು ಸರಿ. ಆ ಬಗ್ಗೆ ನಾವು ಅವರಿಗೆ ನೋಟಿಸ್ ಅನ್ನು ಸಹ ಕೊಟ್ಟಿದ್ದೇವೆ ಎನ್ನುವುದು ಸರಿ. ಆದರೂ ಈವರೆಗೂ ಅವರು ದಾವೆ ಸೊತ್ತನ್ನು ತೆರವು ಮಾಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿ. 1992ರಿಂದಲೂ ನಿರಂತರವಾಗಿ ಪ್ರತಿವಾದಿಗಳು ದಾವೆ ಸೊತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಹೊಂದಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ. ಪ್ರತಿವಾದಿಗಳಲ್ಲದೆ ಬೇರೆ ಯಾರೂ ದಾವೆ ಸೊತ್ತಿನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದು ಸರಿ. ದಾವೆ ಸೊತ್ತು ಮುಖ್ಯ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿದೆ ಅನ್ನೋದು ಸರಿ. ದಾವೆ ಸೊತ್ತಿನ ಮುಂಭಾಗದಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳು ವಿದ್ಯಾಸಂಸ್ಥೆಯನ್ನು ನಡೆಸುತ್ತಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ. ಈಗ ತೋರಿಸಿದ ದಾಖಲೆ ನಾವು OS ನಂಬರ್ 67, 57, 99ರ ವಾದಪತ್ರ
OS 6757 ಹಾಕಿದ್ಯಾರು?
ಅದು ಪ್ರೆಸೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಮಿಲಾಡ್.
ಅದ್ರಲ್ಲಿ ನಿಮ್ದು WS ಅದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ?
WS ಮಾರ್ಕ್ ಆಗಿಲ್ಲ, ಪ್ಲೇಂಟ್ ಮಾರ್ಕ್ ಆಗಿದೆ. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವರು ನಾವು ಅನ್ಅಥರೈಸ್ಡ್ ಇನ್ ಪೊಸಿಷನ್, ಟ್ರೆಸ್ಪಾಸ್ಡ್, ಪುಟ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್, ದೇ ಆರ್ ಇನ್ ಇಲಿಗಲ್ ಪೊಸಿಷನ್ ಅಂತ ಹೇಳ್ತಾರೆ.
95 ಇವ್ರದ್ದು, 99 ಅವ್ರದ್ದು. ಗೊತ್ತಿಲ್ಲ ಸರಿ.
ಪ್ಲೀಸ್ ಮಿಲಾಡ್.
ಗೊತ್ತಾಯ್ತು.
ಏನಂದ್ರೆ ಸರ್
ಪ್ರಾಪರ್ಟಿ ಪಡ್ಕೊಳ್ಳಿ. Yes.
My submission to your lordship says the trial court holds, my lord, because of the agreement of sale under which the defendant has admittedly come into possession. His possession is that of a permissive one. Here, my lord, what I wish to bring to your lordship's consideration is
unauthorized person jete na ತಗೊಂಡಿದ್ದೇವೆ. ಹಾಗಾಗಿ ಅದು you ignore that and our possession as against him will be adverse.
Understood.
Next point.
ಮತ್ತೆ next, the plaintiff here himself admits in the cross examination, I have been unlawfully there. It is open in the sense it is by the main road and construction is put up. These things there they also admit every year we used to come here and see the suit property. So constructions they are bound to know. My illegal possession which I am doing they are bound to know. It is not a secret one as such. Then that is followed, my lord, by these two suits where, my lord, they assert, my lord, that I am in unlawfully in possession right from the year 1995 as per the plaint in OS number 6757 of 1995.
Unlawful possession per se is adverse possession? No.
Open, continuous, my lord, with the intention to exclude the owner or the. Now,
I'm not very sure. I'm not good in adverse possession law. I have read only one Swarup on adverse possession. It's a very frugally written book. But unlawful possession per se cannot be approximated to adverse possession. ಲಾಫುಲ್ ಪೊಸಿಷನ್ ಯಾವಾಗ ಆಗತ್ತೆ ಅನ್ನೋ ಬಗ್ಗೆ ರೂಲಿಂಗ್ಸ್ ಇದಾವೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ರೂಲಿಂಗ್ ಇದೆ.
Now, if
ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಯಾವಾಗ ಆಗತ್ತೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆನೂ ಸಪರೇಟ್ ರೂಲಿಂಗ್ಸ್ ಇದಾವೆ. There are two different streams of law.
now this unlawful possession by way of trespass, if it continues for 12 years, that will mature into to the knowledge of the owner. Now, my lord, original owner has admitted here, he has filed suit in 99, very expressly admitting in exhibit
ನಿಮ್ಮ-
E1.
ನಿಮ್ಮ WS ನಲ್ಲಿ ಆ ಕಂಟೆನ್ಷನ್ ಯಾವ ರೀತಿ ಸ್ಟ್ರಕ್ಚರ್ ಶೋ ದಟ್ ಸ್ಟ್ರಕ್ಚರಿಂಗ್ ಆಫ್ ದಟ್ ಕಂಟೆನ್ಷನ್. Where have you taken up that? How you are structured it?
Page 18, paragraph 14.
Para 8, my lord, is one paragraph. Para 8, my lord, page 17 is one paragraph. Defendant number 1 came in possession of the suit schedule site on 13/8/1992 unauthorizedly and has continued in possession of the same, so far which fact the plaintiffs have been aware of. Then, my lord, para 14 at page 18. 8 and 14 are the relevant paragraphs. As to the averments in para 12, it is submitted that the defendant number 1, having been in possession of the suit schedule property since 13/8/1992, till the date of filing of the suit, it has perfected its title to the suit schedule property by adverse possession, as the possession of defendant number 1 of the suit schedule property since then has been actual, visible, exclusive, hostile, continuous against the said K.H. Madhavrao, his heirs, the plaintiffs and his other legal heirs, and the possession of defendant number 1 of the suit schedule property against them has been nec vi, nec com, nec scenario, and as such D1 has perfected his title to the suit schedule property in every senses of the term as per law against the said late K.H. Madhavrao and all his legal heirs, and as such they have lost title to the suit schedule property to D1, which has perfected its title to the suit schedule property by adverse possession.
At that time it was. There in your suit for unlawful disposition, what was the stand you had taken? You have read it now.
We have just read it, my lord. That
They only had put
D1
lawful possession. I have been in lawful possession of the property. You were saying.
D1 has entered into agreement, D1 put into
No,
possession.
no,
in one
no,
paragraph.
please, not like that. Kindly come to.
Yeah,
page
also
that.
says
66, not like that, please. 66 only. Last 8 lines only. You have specifically said, you said, I'll read that. Madhavrao is now aged about 84. Since the second defendant was busy in his official work, he could not visit Bangalore. Taking advantage of absence of the defendant, plaintiff trespassed over the schedule. No, rather than not. The discussion take place. 64. Therefore, the plaintiff says that it has got apprehension that the defendant would dispossess it from the scheduled premise forcibly at the point of time. Since then, plaintiff was put in possession of the scheduled property by defendants themselves, and that they have constructed a school building. It is stated by the plaintiff, defendants cannot take recourse to illegal methods to dispossess them. Your contention is, you have been put into possession of the property by all the plaintiffs.
But in the very same suit, my lord, they filed return statement saying that they have not
Put you in possession.
they have not
Your in case of
given
adverse
any-
possession, your stand is at focal point.
It came in possession in the year 1992. Illegal possession itself, isn't it?
1992.
Right. As per the available contentions, it is 1992.
Correct.
But the suit was filed in 1999. Where is it?
No. 2008, my lord. Suit was filed.
Earlier suit.
Huh?
Earlier.
All right. Earlier suit, correct, my lord. There are two suits.
Uninterrupted.
That is the, my lord,
Litigas.
An uninterrupted possession.
Now, if my lord,
Animus, animus.
If-
yes,
Animus better.
exclusive ಬೇಕಾಗ್ತದೆ.
Animus
Because
ಬಿಟ್ಬಿಡಿ.
he is admittedly he is in possession.
my lord,
ಎಲ್ಲಿಂದ animus start ಆಯ್ತು ಅಂತ ಬೇಕಾಗ್ತದೆ.
ಇಲ್ಲ, ಈಗ animus ಬಿಟ್ಬಿಡಿ.
Even otherwise that period will
Even
not be over.
otherwise, 1999 suit was filed for rejection.
from 1995, my lord.
92 to 99.
No.
There was uninterrupted, let us assume. 99 he filed a suit.
99, he filed a suit for mandatory injunction, for demolition.
He
Please.
obstructed.
No, from 1999, my lord,
The suit is.
9 years, 9 years, my possession admittedly becomes adverse because he says, I am there in possession as
What is the requirement of law? 12 years.
12 years.
12 years.
12
ಆ
years.
period ಆಗುತ್ತೆ.
12 years ಆಗದೇ ಇಲ್ಲ.
ಇಲ್ಲ ಅದು ಈಗ OS number 6757 of 99 is not for possession.
No,
It is
not
for-
possession is true.
Ah,
He said demolish the structures which you have put up.
correct. Then, Lord,
Can it-
pendency of a suit doesn't
Pendency.
cuts down the limitation.
Filing of a suit.
The limitation do not
They
starts ceasing.
They resisted your possession
Ah.
by filing a suit.
Ah.
Is it an uninterrupted?
No, my lord, resisted means,
Want that the interruption should be by way of coming with.
Physical force.
Physical
Ah.
force at doing it.
they should, my lord, either they should physically interrupt or they should file a suit for possession. Now, my lord, they filed a suit for mandatory injunction. Contending they are in possession, that was dismissed.
Next point.
My lord, so far as that aspect is concerned, what I would bring to your lordship's consideration is the limitation do not get obstructed
One start.
by virtue of one start. That is the law, my lord. That is the.
That's all. What is?
My lord, in para 5 of the, my lord, written statement,
Page number?
page number 16.
Yes.
The further amendments in para 7, the reference as to the sale agreement dated 13/8/1992 do not call for any denial. I admit the, my lord, agreement. And now,
Agreement, pursuant to which he gained entry to the.
so they can't claim protection both under section 53A and, my lord, plea adverse possession. Honorable Supreme Court, my lord, 1996, 1 SCC, page 639. Inconsistent pleas, they can't. And latest decision is, my lord, with regard, latest decision with regard to the adverse portion is 2024-318, Radheshyam Lal.
Radheshyam Lal.
Please. Para 11 and 12.
What?
Please. Court of.
ನಿಲ್ಲಲಿದ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬಿಟ್ಟಿಯಾಗಿ ಬಂದಿದೆ. Go to Supreme.
Para 12 and 13. Please.
Result.
Madam, they have deposited 2 lakhs rupees. Mean profits, it was rejected, madam. They have deposited 2 lakhs and we were permitted to withdraw, if I'm correct.
I don't remember. I'm on NOC file, so I don't have much.
Not order dated 21/2016.
Mean profits. Which you have
Mean
withdrawn.
profits ಕೊಡ್ಲಿಲ್ಲ ಅಲ್ಲಿ, but ನಂತರ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ ನಂತರ they have been
They created it to the, in the registry.
ಅದನ್ನು withdraw ಮಾಡ್ಕೊಂಡಿದ್ರು.
How withdrawn?
They have withdrawn.
They have means your clients have withdrawn.
Yes.
Your clients have withdrawn.
No, yes, man. First respondent is 75 years old, man.
Not regarding interference, my lord, a judgment, my lord, of the Supreme Court, my lord, in 2007, one number 9 SC 641 regarding limitation, my lord.
But
The relevant paragraphs,
it does not, is not interdicted once it.
interdicted. That is
The
a
old-
case, my lord, only I am quoting it, relevant paragraphs I have marked there. That was a case where, my lord, several suits were there right from the year 50s. Now, before the last suit for possession is filed, in the earlier suit, my lord, defendant pleaded adverse possession, he as a trespasser. Then the third suit, in the third suit, court held, from his pleading in the suit, limitation would start, at least from 1968 or so, my lord, in that case, where defendant said, I am in adverse possession. Illegally, I am in possession. So from that date, within 12 years should have filed. Suit filed beyond 12 years is barred.
In para 31, our judgment from our high court has been.
From 1976, the first case I argued as a young man at the age of 22 years was on adverse.
You are young
possession.
even now.
Old young man.
Didn't stay against aging. ಇವುಗಳು ಎಲ್ಲ ಇವರು
ಈಗಲೂ ಅಷ್ಟು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅವರೇ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ಬೇರೆ ಮುಪ್ಪು ಬರದಂಗಿರೋದು ಅಷ್ಟೇ ಅಲ್ಲ, ಸಾವು ಬರಲ್ಲ ಅವರಿಗೆ. ನಾವು ಯಾವ್ದೋ ಈ ಅಶ್ವತ್ಥಾಮ, ಹನುಮಾನ್ ಇವರೆಲ್ಲ ಒಂದ್ 5 ಜನನೇನೆ ಇದ್ದಾರೆ.
ಚಿರಂಜೀವಿ.
From 19, the first case I argued was on adverse possession before Mr. Justice V.S. Malimat. Order for arguing for 1 hour, he just laughed at me and said dismissed it. From that day till today, I have not succeeded in any cases where adverse possession.
Perhaps he will not break the record. We do not know. We are again, we have to go through and when later we said that. 29 is extinction of the title of the other side.
Right.
And acquisition of title by the possessor.
Right.
Both happen.
Right. But what I wish to bring by this decision, 2007 Supreme Court is the pleadings from 99. Thereafter, 9 years adverse possession, there could be no difficulty at all because of the pleadings there. Each one say the other one is a trespasser. It will not interdict the limitation. So prior to that, to complete the 4 years, what are the aspects?
He also filed a suit for injunction.
Correct. Against forcible dispossession. That's where he said, we have been put into possession. No, in his suit you said that. We have been put into possession by all the plaintiffs.
Yes.
In the meanwhile, if possible, work out amicable settlement also.
Some.
Yeah, in the meanwhile, judgment will come, some compromise.
Please, Lord. Please, Lord.
ಅವರು 5,000 ರೂಪಾಯಿ ಕೊಡ್ತೇನೆ ಅಂತ ಸ್ಕ್ವೇರ್ ಫೀಟಿಗೆ 15,000 ರೂಪಾಯಿ ಇದೆ ಅಲ್ಲಿ.
ಸ್ಕೂಲ್ ಇದೆ.
ಬಟ್ ಇವರು 25 ವರ್ಷದಿಂದ
ಕರೆಕ್ಟ್. ಈಗ ಮತ್ತಿದೇನು ಇಲ್ಲಿ ನಿಲ್ಲಲ್ಲ. ಹಂಗಾಗಿ ನಾವು ಭದ್ರವಾಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೀತೇವೆ ಇಸ್ ಅನದರ್ ಥಿಂಗ್. ವೆದರ್ ದಿಸ್ ವೇ ಆರ್ ದಟ್ ವೇ ವಿ ಡೋಂಟ್ ನೋ. If we write in his favor, you will go to Supreme Court because of the heavy stakes.
ನೋಡಿ ಇಲ್ಲ
He also may go to, in the event we enter judgment in your favor, he also will have that option. So ಇದು ಒಂದ್ ರೀತಿ to cut short all this legal battle, the finish off. Continuous fighting will not help anybody. Continuous fighting ಇಂದ ಜೀವನ ಅರಳೋದೇ ಇಲ್ಲ.
ನೋಡಿ ಇಲ್ಲ
Somewhere it will come to an end. Somewhere it has to come to an end. In the meanwhile, ನೀವಿಬ್ರು ಹೇಳ್ರಿ, ಈಗ ಸಾಹೇಬ್ರಿಗೆ ಕೇಳಿದ್ದಾರೆ, ನಾವು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋಬೇಕು. Please. Heard both the sides extensively. First off. And the matter is reserved for judgment. First off. In the meanwhile, parties are at liberty to work out an amicable settlement and report the same within 1 week. First off. Please. Correct.
Madam.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಅಲ್ಲ? RFA ಇದೆ.
ರೀಚ್ ಮಾಡಿಸ್ತೀರಾ? ಬೇಡ ಬರಲಿ, ಚಾನ್ಸ್ ತಗೊಳ್ಳೋಣ. ರೀಚ್ ಆಗಿಲ್ಲ ಡೇಟ್.
arbitration matter.
bottom, I'm again failing. You've gone way to the bottom. There's one more thing about this file that you are in there. If you can find it. Verify. Flip ಮಾಡಿ. Flip ಮಾಡಿ. ಇದನ್ನು flip ಮಾಡಿ. ಸರಿ, ಒಂದು ನಿಮಿಷ. ಇದನ್ನು ಓಪನ್ ಮಾಡಿ ಅದಾವ. ಓಪನ್ ಓಪನ್. Upper left corner ಇಟ್ಕೊಂಡು. One second, next. Upper left corner ಇಟ್ಕೊಂಡು flip ಮಾಡಿ. Next. So bottom, flip ಮಾಡಿ, flip couple of pages ಅದಾವ. ಕೆಳಗೆ. Okay, close this entire file. Close this entire file. Last one, execution. Last one. Okay, better. Okay.
ಯಾಕೆ ಲೈಟ್ ಇಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದ್ಯಾ ಆಗ್ಬೇಕು ಲಾಯರ್
सर हाँ देखो मैडम बोलना है तो स्पीकर हो बोलना है आपका 30 है ना मैं बांध दूं नहीं मैं बांध ಚಾನ್ಸಸ್ ಇದೆಯಾ ಇಲ್ಲ 42 ಚಾನ್ಸಸ್ ಇದೆಯಾ
ಫೈಲ್ ಬಂತ ಎರಡು ಫಾಲೋ ಕಂಪ್ಲೈ ಆಗಿದೆ ಅಲ್ಲಪ್ಪ ಅಲ್ಲಿಂದ ಕಳಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಲ್ಲ ಇವಾಗ 2:30 ಬರ್ದಿದ್ರೆ 4:30 ತೆಗಿಯಲ್ಲ.
Court officer? Court officer? Court officer? Court officer?
ಹೇಳಿ ಶ್ರೀಧರ್ ಅವರೇ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್? ಸರ್
ಸರ್, ಹೇಳಿ ಸರ್.
ನಡೀತಾ ಇದೆಯಾ? ಅದರಲ್ಲೇನೆ ನಾನೊಂದು ಸಬ್ಮಿಷನ್ ಮಾಡೋದಿತ್ತು ಅದಕ್ಕೆ.
ಮಾಡಿ ಸರ್ ಮಾಡಿ.
23 ನಡೀತಾ ಇದೆಯಾ? ಓಕೆ ಸರ್.
ನಾಳೆ ಬೆಂಚ್ ಇದೆಯಾ? ಶಿವರಾಮ್ಕರ್ ಅಂತ ಆಗಲ್ಲ. ಬರೀ ಡೇಟು 3 ಬರೀ ಹಾಫ್ ಡೇ ಮಾಡ್ಲಿ. ಇಲ್ವಾ ನಿಮ್ಮಾಗಿದ್ರೆ ಇರುತ್ತೆ ಹೇಳಿದೀನಿ. ನಿಮ್ಗೆ ಆಗ್ತದೆ ಅದೇ ನಿಜ ಮಾಡೋದು ಹೇಳಿದ್ದೀನಿ ಸರ್. ನಿಮ್ಗೆ ಹೇಳಿದ್ದೀನಿ. ನಾಳೆ ಆಗಲ್ಲ ಬಿಡು. ನಾಳೆ ಫ್ರೈಡೇ ಸಿಂಗಲ್. ನಾಳೆ ಫಸ್ಟ್ ಶಿವರಾಮ್ಕರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 50 ಮಾಡ್ತೀವಿ. ಟ್ಯೂಸ್ಡೇ ಹೊಟ್ಟಾಗುತ್ತೆ ಅಷ್ಟೇ. 10:30 ನಾಳೆ 2:30 ಒಂದು ಏನೋ ಬರುದ್ರಪ್ಪ. ಅದ ಅರ್ಥನ ಆಮೇಲೆ ಗೊತ್ತಾಗಿಲ್ಲ ನಮ್ಗೆ ಏನು ಅಂತ. ನಾವೇನು ಅದನ್ನ 2 weeks ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರ ಅಥವಾ 2 weeks ಅಲ್ಲಿ ಎಷ್ಟು ದಿನದಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ರಿಪೋರ್ಟ್ ಕೊಡ್ಬೇಕಂತ ಪಬ್ಲಿಕ್ ಸರ್ವಿಸ್ ಏನಾಯ್ತು? ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರಲ್ಲ ಶೀಲ್ಡ್ ಕವರ್ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ 2 weeks ಅಲ್ಲಿ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರ 2 weeks ಅಲ್ಲಿ ಎಷ್ಟು ದಿನದಲ್ಲಿ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳ್ತೀನಿ. 2 weeks ಅಲ್ಲಿ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಸರ್. ಇದ್ದಾಗಲ್ಲ ಸಾಹೇಬ್ರು ಅಷ್ಟೇ ಕೊಡೋದು, ಹಂಗಲ್ಲ ಕೊಡಲ್ಲ. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅವ್ರು ಹೇಳಿದ್ರೆ 2 weeks ಅಲ್ಲಿ ಮಾಡ್ಬಿಡೋದು. 2 weeks ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು. ಕಂಪ್ಲೇಂಟ್ ಹೇಳಿದ್ರು ಇವಾಗ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ. ದಿನದಲ್ಲಿ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳಿದ್ರನ್ನ 2 weeks ಅಲ್ಲಿ ಹೇಳಿ ಅಂತ. ಅಪ್ಲೋಡ್ ಆಗತ್ತೆ ನೋಡಿ.
ವೈಫೈ ಪಾಸ್ವರ್ಡ್ ಮೆಸೇಜ್ ಹಾಕಕ್ಕೆ
ಸುಮಾರು ಇಮ್ರಾನ್ ಇದೆ.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಅಂತ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ಕಂಪ್ನಿ
ಅವರೇ ಬಂದು ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದಾರೆ ಬೆಳಿಗ್ಗೆ.
ಇವರು ಸಾಹೇಬ್ರು ಮಾಡೋದು. ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಬೆಳಗ್ಗೆ ಇರ್ಲಿಲ್ಲ.
ಆಫೀಸ್ ಅಡ್ರೆಸ್ ನೋಡಿ.
ಕಂಟಿನ್ಯೂ ಅಕೌಂಟ್ ಇನ್ನೋಸಿ ನಾಟ್ ಓಪನ್ ಇನ್ನೋಸಿ ಇಲ್ದಿನ ಹಾಕಿದ್ರು ಇಬ್ರು ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ. ಯಾವ್ದಾದ್ರು ಜಗದೀಶ್ಗೆ ಅಂಡ್ ಮೇಘಾ ರಾಣಿಕೆ ಫಾರ್ R2 and ಅಂತ
ನಡೀತಾ ಇದೆ ಅಥವಾ ಅಂತ ನನ್ನ ಎದುರ ನಡೀತಾ ಇದೆ.
ಇವ್ರಿಗೆ ಶಿವರಾಜ್ ಎಲ್ಲೆಲ್ಲಿ ಬರ್ತಾರೆ ಕಡೆ ಇವ್ರನ್ನ ಇಬ್ರು ಪ್ರಾಬಲ್ ಇದಾರೆ. ಇದೊಂದು ಕೇಳ್ಕೊಬೇಕು ಭಾರತಿ ಪಾಟೀಲ್ ಯಾರು ಅಂತ ಪ್ರಾಬಲ್ ಇದೆ ನೋಡಿ ಅವ್ರು ಶಿವರಾಜ್. ಅದು ಅವ್ರಿಗೆ ತೋರಿಸಿ ಇದೊಂದು ಬಿಡ್ಕೊಂತದೆ ಅಷ್ಟೇ.
2:30 ಮೆಟ್ರ್ ಗೊತ್ತಿಲ್ಲ.
ಇಲ್ಲ ಅದು 3 o'clock ತಗೊಂತಾರೆ. 2:30 ಮೆಟ್ರ್ 3 o'clock ಅಂತ ತಗೊಂತಾರೆ. ಮಿಕ್ಕಿದ್ದು ತಗೊಂತಾರೆ. ರೀಚ್ ಆಗುತ್ತೆ
24 ನಮ್ಗೆ
ಎಲ್ಲಾರ್ದು ಇದು 24 ಅಂದ್ರೆ ಟೈಮ್ ತಗೊಂಡಿರಾ ಸರ್? ನೆಕ್ಸ್ಟ್ ನಿಮ್ದೆ. ಮಾಡಿಲ್ಲ ಸರ್ ಅವ್ರು ಇನ್ನ ಯಾರು ಬಂದೇ ಇಲ್ಲ. ಅದನ್ನೇ ಕರಿತೀನಿ ಈಗ. ಸಾಹೇಬ್ರು ಬಂದ್ರೆ ಮೇಡಮ್ ನಿಮ್ ಚೇಂಬರ್ ಇಂದ ಬಂದಿರಲಿಲ್ಲ ಸಾಹೇಬ್ ಊಟ ಮುಗಿಸ್ತೀನಿ. ಅಷ್ಟೇ ಸರಿಯಲ್ಲ ಸಾಹೇಬ್ರು ಕೇಳ್ಬೇಕಲ್ಲ ಅವ್ರು 2:30 ಬಂದಿದ್ದಾರೆ. ಅವ್ರು ಬಂದಿದ್ದಾರೆ. ಯಾರು ಅವರು? ಪ್ರದೀಪ್ ಎಲ್ಲಿದ್ದಾರೆ? ನಿಂತಿದ್ದಾರೆ. ಅವ್ರೇನಾ? ಏಜ್ ಏನ್ ಅವರು? ಏಜ್ ಏನ? AAG-ನ? ಅಡ್ವೊಕೇಟ್ ಜನರಲ್, ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್. AAG ಫಸ್ಟ್ ಎರಡು ಪಾಸ್ವರ್ಡ್ ಕರಿತೀನಿ, ಕರೆದ್ಬಿಟ್ಟು ನಿಮ್ದು ಹೇಳ್ತೀನಿ. ತಗೊಂಡೋದ್ರ? ಕಾಯ್ತಾ ಇದೀವಿ.
पेंडिंग ज्यादा नहीं है, ज्यादा नहीं करा सकते दिमाग का मैं जाकर
ಟೈಪ್ ಮಾಡ್ದ ಅಲ್ಲೇ ಬರೀ ಅಂದೆ. ಹೋಲಿ ಬಿಡಿ ಇವ್ರ ಆಪ್ಷನ್. ತಾವು ಮಧ್ಯದಲ್ಲಿ ಹೇಳ್ಬೇಕಾಯ್ತು. ಕೇಳ್ಕೊಂಡು ಅದು ಸೆಕೆಂಡ್ ಸೆಟ್ ತರ್ಸ್ತೀವಿ ನಾವು. ಸೆಕೆಂಡ್ ಸೆಟ್ ತರ್ಸಿ ಫಸ್ಟ್ ಸೆಟ್ ಸೈನ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋಣ.
ವಾರಂಟ್ ಹಾಕ್ಬಾರ್ದು ಯಾವಾಗಲೂ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇದ್ದಾಗ ವಾರಂಟ್ ಹಾಕ್ಬಾರ್ದು ಅಲಾಂಗ್ ವಿತ್ ಅಂತ. ಅದಕ್ಕೆ ನೀವು ನಿಮ್ ಸಾಹೇಬ್ ಬಂದಿದ್ರಲ್ವಾ ಚೇಂಬರ್? ಯಾರಾದ್ರೂ ಕೇಸ್ಗಳು ಬಂದಿರ್ತಾರ?
View of this court, Lordship. May I make a submission, Lordship?
Posting my. I'm for posting.
Posting, ಏನ್ urgency?
Challenging the KAT.
Huh?
It's a tribunal order my.
ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ
I am agreed by the KAT order, my lord.
ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು?
2910, my lord.
2910.
Transfer order.
2811 ಹಾಕೊಂಬಿಡಿ, ಕರೆಕ್ಟ್ ಒಂದ್ ತಿಂಗಳಾಗ್ತದೆ ಸರ್. ಸರಿ 2811 ಬರ್ಲಿ.
With your lordship kind permission. May I make one submission?
Yes, ಹೇಳಿ.
In serial number 23, my lord. My name has been deleted. RFA 530 of 14. My name has been deleted, my lord. I am appearing for respondent 1 to 3. I was not knowing how.
23 ನೇಮ್ ವರ್ಷ ನಿಮ್ ನೇಮ್ ಏನಿಲ್ಲ ಬಿಡಿ.
Allah, I have not given NOC. I was there in the record. File also is with me. How my name has been deleted by the office, I do not know.
ಅದು ಏನು ನಿಮ್ದು ಏನಾರ ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ, ನಿಮ್ಮ ಹೆಸರು ಹಾಕೊಂಡ್ಬಿಡ್ತೀವಿ. ರಿಸರ್ವ್ ಆಗಿದೆ ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರೆ NOC ಕೇಳಿದ್ರೆ ಬೇರೆ ವಿಷಯ ಇತ್ತು. ನನ್ನ ಹೆಸರು
ಆಯ್ತು ಹೇಳಿ, we will hear you, tell.
ಎಲ್ಲಂದ್ರೆ ಈಗ ನನಗೆ ಈಗ ಗೊತ್ತಾಯ್ತು ಲೀಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೆಕ್ಸ್ಟ್
I've done Monday, my lord. Because I am that office is very instinct to me to
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಹೇಳಂಗಿಲ್ಲ ಇಲ್ಲ ಹಾಗೆ ಮಂಡೇ ಅಂದಾಗನೆ ಕಳಿಸ್ಬಿಡಕ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳಲ್ಲ ಏನೇ ತೊಡ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಡ್ರಿ.
May I make one submission? Seal number 42, Lordship.
42.
May I request at least to be taken as the last matter of the day, Lordship? The
Today.
correction, yes, today, Lordship.
ಯಾಕೆ?
The reason is that, Lordship, I'm sure the matter may not reach. For that reason, I'm requesting
ಅಲ್ಲ,
some.
ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
It's a, Lordship, it's a correction of jurisdiction, Lordship.
ಕರೆಕ್ಟ್, ಆಲ್ ರೈಟ್, ಅದು ಅಷ್ಟಕ್ಕೆ ಆಗಲ್ಲ, ಅದು ಬೇರೆ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
The
ಗ್ರೌಂಡ್ ಆಯ್ತು.
No, Lordship, the reason is that the trial is going on, but the wrong court, Lordship, for that reason.
ನೋಡೋಣ, ರೀಚಾರ್ಜ್ ತಗೋತೀವಿ. ನೆಕ್ಸ್ಟ್
May I make a request? Serial number 31, my lords.
31.
Yes, my lord. Matter relates to suspension, my lords. My lords, I'm under suspension. Yesterday, my lords, I'm served with a notice that my lien is shifted to Bidar and I have to report within 3 days. It's been 2 weeks, Bidar. And I'm directed to report within 3 days. And my lords, I'm under suspension for 2 years. 21 times matter has been adjourned before your lordship.
Before my, before
Before your lordships, yes, before your lordships twice, my lords. And yesterday, my lords, I'm served with a notice to report to Bidar. And within 3 days, my lords, I'm directed to report. Failing which, my lords, action will be. My lords, this submission has been.
When will he appear? When will he, all right, let AG appear. When he will appear? But then don't give effect to that notice. ನೋಡ್ರಿ, ಇದಕ್ಕೂ ಅಪ್ಪಲ್ಲ ಅದಕ್ಕೂ 3 ದಿವಸದಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಏನು ಹೆಂಗ್ ಏನು ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಏನು ಅಲ್ಲೇನ ಅಲ್ಲಿ ಯಾವ್ದಾರ ಗುಡ್ಡ ಗಿಡ್ಡ ಬೀಳ್ತಾ ಇದೆಯಾ?
I am under suspension. To whom I should report? My going to office during suspension itself will be a misconduct. So what they are telling me is, don't commit misconduct in Bangalore, go and commit misconduct there, it will be a good conduct.
ಏನೇನೋ ನಿಮ್ನ ಇಲ್ಲಿ ಹತ್ರ ಇಟ್ಟರೆ ತೊಂದರೆ ಮಾಡ್ತೀರಿ ನೀವು. ಅಲ್ಲಿ ನಿಮ್ಗೆ ಬೇಕು ಅಂದ್ರೆ ಯಾವ್ದೋ ಆಫೀಸ್ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತೀವಿ, ಅಲ್ಲಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಮಾಡಿ ಆರ್ಡರ್ ಹಂಗೆ ಮಾಡಿಬಿಡ್ತೀವಿ. ಅದಕ್ಕೆ
Suspension is still in force.
ಅದೇ ಪಾಸ್ ಓವರ್.
Lord, serial number 37, my lord had permitted us to peruse the copy of the file yesterday, and I had mentioned that we'll need 10 minutes to make a submission on that.
ಯಾವುದೋ ಒಂದು 2:30 ಒಂದು ಇನ್ನೊಂದು ನಮ್ಮ ರಾಮಕೃಷ್ಣ ಒಂದು ಬ್ಯಾಟ್ರಿ.
No, may I request at 4:30 this matter, because it may require, it's a person with disability and 2 decades old. Therefore, 10 minutes of my lord's time, I had sought the indulgence of this court, maybe on 1 or 2 occasions, short indulgences, and that would save the court's time. That was my submission.
No, iri, ನೋಡೋಣ. We'll try, wait. Please, KT, wait.
Serial number 30. Serial number 34, my lord.
34.
It's a matter pertaining to departmental inquiry. Now the authority is going to implement the penalty order.
Penalty order.
Kindly, okay, penalty stay illa. There is no interim order of stay in this matter.
ಇದೆಯಾ?
Illa, stay illa.
ಇದು ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ ನೀನು?
ಇಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆ. ನೋಟಿಸ್ ಆಗಿದೆ. ಲೋಕಾಯುಕ್ತ ಮಿಸ್ಟರ್ ಅಶ್ವಿನ್ ಆಲಾದಿ is appearing.
ಏನೋ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಒಂದು ವಾರದಲ್ಲಿ?
ಹೌದು, ಒಂದು ನೋಟಿಸ್ ಬಂದಿದೆ ನಮಗೆ.
ಒಂದು ವಾರದವರೆಗೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಬೇಡ್ರಿ. ಯಾರು ನೀವು? ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅವರ?
ಹೌದು, ಸ್ಟೇಟ್.
ಏನು ನಥಿಂಗ್ ಇಲ್ಲ, ಅಷ್ಟೇನು ಅವಸರ ಇಲ್ಲ. ಇಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಆಲ್ರೆಡಿ. 1-2 ವಾರ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಬೇಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಹಿಯರ್ ಅಂಡ್ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
ಪ್ಲೀಸ್
ಮಾಡ್ಬೋದಾ?
Any till next date.
Sorry.
Any date maybe.
The order of punishment shall not be given effect to till next date of hearing. Call this matter on ಯಾವ ಡೇಟ್ ಹೇಳಿ?
Next week, any date, madam.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಲ್ಲ,
Please.
ಬೇರೆ
Week after next, any date, madam. Any convenient.
ಅಲ್ಲಿ KT ಆರ್ಡರ್ ಸ್ಟೇ ಇತ್ತಾ?
ಇಲ್ಲ ಅದು ಸ್ಟೇ ಇರಲಿಲ್ಲ.
ಹೆಂಗ್ ಕೊಡಕ್ ಬರ್ತದೆ? You did not have any interim order at hands of the KT.
But penalty was modified. It is the joint, may I submit?
No, that's all right. Did you have interim order in the KT? You did not. Recall that order.
Please.
One date hakono.
Date may be fixed on next week, my lord, because it's the joint inquiry. One KT relief ಕೊಟ್ಟಿದೆ, one DGO 1ಗೆ.
No.
Any date?
Other one date ಕೊಡಿ, next 2 weeks ಆದ್ಮೇಲೆ. Yes. 24. Sorry. Call in the 3rd week of January 25. Call. Movement. Aniruddha. ಏನದು?
ಅರ್ಜೆಂಟ್ ಮೂಡ್ ಮಾಟ ಅನಿರುದ್ಧ್
MP Anirudh? Yes, brother, ಏನದು?
My lord, I beg to appear for the petitioner.
Your tenant.
My lord, I was the owner of the property. I sold the property. Possession was not taken. I was not paid my full sale consideration. I have filed a suit for recovery of money. Suit is decreed. After decree, execution is ongoing. Property is attached, sale is ordered. Meanwhile, I discover that there is parallel execution proceedings ought to be filed by the bank.
Surface.
No, they obtain an arbitral award where the advocate is appointed as arbitrator. Instead of going and filing a section 11, unilaterally, the arbitrator assumes jurisdiction, passes an award. They're bypassing section 11 requirements, where notice is sent and arbitrator is nominated, the other side doesn't agree. So they have to file a section 11. That step is bypassed, and there are cross objections pending in both the execution petitions, Malan.
ಈಗ ಏನಾಗಿದೆ?
Ivaga, they approach the magistrate court under section 14, take an order for possession in 2020. That order is sought to be implemented in 2023.
Date of your sale deed ಏನು?
2013, my lords.
2013.
2013, 30th of November.
Loan is contracted when?
My lords?
Loan is contracted when?
On the very same day in the evening, 30th, which I don't know, they are claiming under an unregistered mortgage deed, which I discover only in the year 2023.
Unregistered equitable mortgage, another.
Illa, the deposit of title deeds.
Okay, equitable mortgage.
Unregistered mortgage under section 17, no rights arise.
Why?
Because
Equitable mortgage does not need registration.
Well, on that, the fine distinction that I wish to bring to my lord's notice is, if there is a prior deposit of title deeds and it is recorded subsequently, such a memorandum of deposit of title deeds does not require registration. But if a right is created under that very document,
itself.
yes. On that, there's a judgment of Punjab and Haryana High Court, which I. Please, Madam. So.
Agreement ಎಲ್ಲಿದೆ? Memorandum of equitable mortgage ಎಲ್ಲಿದೆ?
Manoj, I have produced it along with my a typed copy because it was unregistered.
ಹೇಳಿ ಎಲ್ಲಿದೆ?
That's at page 378, Manoj.
378.
In that clause 7 of that document. At page 382, Manoj.
Paragraph
7, clause 7.
How it begins?
For the consideration aforesaid and in further pursuance of the said agreement, the mortgage
Heading nomenclature of the document ಏನಿದೆ?
It's called a deed of mortgage.
Yeah, deed of mortgage relied on by the ನೀವು ಕೊಟ್ಟಿದ್ದು ಇದನ್ನು ಹಂಗಿದೆಯಾ? Deed of mortgage is made on side.
Under clause 7, my lords.
For the consideration of aforesaid in presence of the agreement, the mortgage hereby grants.
And transfers by way of simple mortgage. So since right is being created under this document, no rights arise in favor of the bank because it's an unregistered.
Not equitable mortgage, it's a simple mortgage.
Yes, my lords.
So right is created by the instrument itself. It's not just memorandum
Yes,
recording.
my
of the
lords.
instrument.
Yes, ma'am. That is my contention.
Emergent notice. Entry order ಏನು ಅಂತ ಕೇಳಿ.
My lords, may I request this, my lords? So this is what has transpired. I approached the DRT challenging this. Thereafter, DRT dismissed my application. I approached this honorable court in a writ petition. In fact, my lords granted me an interim order of status quo. Finally, the writ has been disposed of, granting me liberty to approach the DRAT. I filed the petition before the DRAT. Matter has come up on 6th of November. Emergent notice has been issued. Meanwhile, there is immediate threat of disposition for my tenants. Therefore,
application for any interim order ಕೇಳಿದ್ರಾ?
I'll hakittu, urgent hearing application hakittu, adr mele notice agide. Because time was spent for a period of nearly 1 year before this court. Adike, till pendency of application and appeal, one limited time order.
Interim order ತೊಳಿ ನೋಡಿ. Interim order of status quo as on this day. In respect of subject property, schedule A property, tane? Schedule A property.
Schedule, there are two schedules, undivided share and the flat description.
That is schedule B property.
Schedule B.
Schedule property. Till next date of hearing. Issue emergent notice. So, and so, ಯಾರು ಅಲ್ಲಿ ಇವರು ನಿಮ್ಮ ಲಾಯರ್ ಸರ್ ಗೊತ್ತಿದಾರ?
My lords,
In addition to taking usual steps, the petitioner shall serve copy of the petition along with all the documents on the advocates appearing for the respondents in before the DRAT.
ಅಲ್ಲಿ ಇನ್ನ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಅವ್ರು appear ಆಗಿಲ್ವಾ?
28 November ಇದೆ.
They will issue emergent notice, status quo till next date of it.
And delivery, my lords.
Got it. Correct.
Nagarajappa, yeah?
Petitioner. It's a practicing advocate, my lord, whose son was appointed on compassionate ground because of his mother died while she was in service in PWD department.
Mother was in service.
Yes, ma'am.
Mother died in harness.
Yes.
When
79, my lord, 17. (26/8/19), my lord, appointment as on compassionate as FDA.
Dated
26/8/2019. Petitioner son R. Shashikaran was appointed as FDA on compassionate ground. Posted to the office of Tahsildar, Bangalore North.
all right. Mundera.
Lord, a government servant soon after is appointed as a Lord in a government service.
ಏನಂತ appoint ಆಗಿದ್ರು?
Not 26/8/2019 is
What
appointed.
was his designation?
FDA. First Division Assistant. Group C post.
Probation was declared,
No,
not yet declared.
Lord, within a period of 1 month, he must become compulsory member of the Lord, Karnataka group insurance rules. He cannot even draw the salary. First month's salary, before drawing from salary, he must become the member of the Karnataka, my lord, compulsory life insurance rules 1958.
Group insurance member of.
Yes, yes.
ಅದು ಯಾವ rule ಕೆಳಗಡೆ?
Lord, Karnataka government servants compulsory life insurance rules 58. 50. I produced it. It's part of number. Page 44.
44.
Membership is a rule. Exception is not crossing 55 years.
Which rule?
Rule 6. Six, 2, 3. In fact,
Before he draws his first salary, he should
yes,
become
yes,
the member.
he should become member.
ಯಾರು ಮಾಡ್ಬೇಕು ಅವ್ರನ್ನ member? Who should make him member?
His superior.
ಎಲ್ಲಿದೆ?
Lord, condition rule also. His duty is superior who draws his salary. Lord, he should draw first and then Lord dispose his salary. Rule 6, Lord. Subject to Rule 39. Insurance under these rules shall be compulsory for every government servant, including a provisioner, from the date of his joining service, provided nothing in this shall apply to a government servant who exceeds 55 years. Only exemption is 55 years. Cross. Provided government by order for the reasons to be specified, such order direct that rule shall not be applicable to any government servant specified therein. Every government servant shall, before draws his first month's salary after joining service, submit a proposal, whether medical or non-medical, as the case may be, pay first premium, and undergo medical examination whenever necessary.
It's the duty of the employee himself.
And drawing of salary is concerned, drawer should not, before dispersing, must credit same to the group insurance.
You know?
Before drawing 1 month salary, first it should be debited and credited to the insurance policy.
ಅದೆಲ್ಲಿದೆ?
And if you not note, the official superior, not got it? Next page.
The officials.
Official superior of government.
Note below rule.
Note below. Shall not draw first month salary of a government unless he has complied the requirement of rule 2. ಮಾಡ್ಲಿ
ಸ್ಯಾಲರಿ ಕೊಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಮೆಂಬರ್ ಆದ್ರು.
Huh?
He became a member, my lord.
He became a
He
member.
became member.
When he became member?
My lord, 10, my lord, 10/10/2019 policy is issued.
10/10/2019
policy is issued. Policy. Rupees 5,000 deducted from the month of September 2019.
10/10/2019, he became a member.
Member, deducting the, my lord, 5,000
Membership, ನೋಡಿ ಇಲ್ಲಿ ಸೆಕ್ಷನ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಎಲ್ಲ ಕದರ ಬದಲ ಇದೆ. ಅಲ್ಲಿ he should submit the proposal. Proposal ಆಯ್ತು.
Proposal ಆಯ್ತು, policy
acceptance ಎಲ್ಲಿದೆ?
Annexure A4 blood is a policy. No dispute about it. Annexure A4 is a policy issued to him. Page 68. It is not disputed.
Should. Dated 10/10/2019.
Yes, Lord.
Page number?
Page number 68.
No. 68.
Oh, 68.
So he became the member.
Yes, Lord. He became the member. However, my lord, on 4/1/2020, he committed suicide.
4/1/2020.
He committed suicide, Lord.
ಅದು suicide ಅಂತ ಯಾರು ಡಿಸೈಡ್ ಮಾಡಿದ್ರು?
Police have registered UDR ಅಂತ.
UDR ಅಂದ್ರೆ ಅನ್ಡಿಟೆಕ್ಟೆಡ್ ಕ್ರೈಮ್ ರಿಪೋರ್ಟ್ ಅದು.
Unnatural death report.
Unnatural death.
Unnatural death report.
UD.
Unnatural death report.
Death report ಅಂತ ಮಾಡ್ತಾರ.
But there is another UDR which Supreme Court
UDR
in
ಮಾಡಿದ್ದಾರೆ.
UDR.
UDR.
ಏನಂತದು?
Unnatural death report.
Unnatural death report ಅಂತ ಮಾಡ್ತಾರೆ.
ಯಾವ್ಯಾವ ರೀತಿ ಡೆತ್ ಆದ್ರೆ ಅದನ್ನ ರಿಪೋರ್ಟ್ ಕೊಡ್ತೀರಿ?
Suicide cases,
ಎಲ್ಲಿದೆ ಅದು?
Suicide cases.
Where are the rules? Only it's your say. Where are the rules?
I will get the rules. As far as.
ಇದೇನು ಇದೆ ಯಾವ್ದಕ್ಕೆ ಬಂದದ್ದು ಮ್ಯಾಟ್ರಿ ಇವತ್ತು?
This is for where the employee he commits suicide within the period of 1 year from the date of employment. Where he does not become eligible to claim insurance. That's the question.
ಎಲ್ಲಿದೆ ರೂಲ್ ಅದು?
But question is
Rule 38.
I'll point out.
Rule 38 of the KJD rules.
Rule 38 and 23. Lord, should be read. Lord, cannot be read together. And it is Rule 38 now. 23 and Rule 38 both.
Rule 38.
All right, we'll hear you.
Yes,
please be seated.
I will.
And just clarification ಮಾಡಿಕೊಂಡು.
Lord, kindly take page 40.
ಈಗ who should decide it's a suicide or not?
Lord, here the police have
ಈ suicide, homicide, ಸೈಡ್ ಇದೆ ಅದ್ರಾಗ. ಹೌದಾ? ಇದು ಆತ್ಮಹತ್ಯೆ ಅನ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ಯಾರು ಕೊಡ್ಬೇಕು? Who will decide that it's a suicide? ಯಾವುದೋ ಒಂದು ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಏನಾಗಿ ಸತ್ತೋಗ್ಬೋದು.
ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಬಂದು ಅವರು ಮಾಜಾರ್ ಮಾಡಿ UDR ಅಂತ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅದನ್ನ
TR ಅನ್ನ ನಾರ್ಮೇಟಿವ್ಲಿ when you are registering the UDR, what are the normative basis? The normative factors ಏನೇನಿದೆ?
Usually what happens, at the stage of FIR, when the report of death comes comes as an information, if it seems to the police officer that it is by suicide and death otherwise, other than homicide, then it will be registered as UDR.
ಅದೆಲ್ಲಿದೆ ಅಂತ?
That I will provide. And in this case, the question is they would do a post-mortem report also, where the opinion of the doctor is taken. Whether it is a suicide or a homicide, the opinion in the post-mortem report. There is a post-mortem report also would have produced.
97, I produced that also, post-mortem report.
In the post-mortem report, the opinion column will decide whether it's a suicide or not.
ಎಲ್ಲಿದೆ? ಕಾಸ್ ಆಫ್ ಡೆತ್ ಇರ್ತದೆ ಅಷ್ಟೇ. ಪೆಥಾಲಜಿಕಲ್ ಕಾಸ್ ಆಫ್ ಡೆತ್ ಇರ್ತದೆ. ಡಾಕ್ಟರ್ಗೆ ಹೆಂಗೆ ಸುಯಿಸೈಡ್ ಇದು ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಅಲ್ಲೇ ಮೋದಿಸ್ ಮೆಡಿಕೋ ಲೀಗಲ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್ ತರಿಸಿ. Who should certify that it is a case of suicide? What Modi says, I think Modi has said something about that. Modi's medico-legal jurisprudence studies. Cox on medical, today, yard books studies. Cox on medico-legal jurisprudence. Modi's medico-legal jurisprudence. Another is there, one second. Narayana Reddy on forensic medicine. Call that. ನೀವು ಹೇಳ್ದಂಗಿಲ್ಲ ಅಲ್ಲಿ ಬೇರೆ ಸ್ವಲ್ಪ ಬೇರೆ ಇದೆ ಅದಕ್ಕೆ.
KN Narayan Reddy.
KN
Narayan Reddy.
Narayana Reddy, yes. Who should decide? It's a case of suicide. ಅದನ್ನ ಹೆಂಗೆ ಡಿಸೈಡ್ ಮಾಡೋದು? ನಿಮ್ಮ ರೂಲ್ಸ್ ನಲ್ಲಿ ಯಾರು ಸುಯಿಸೈಡ್ ಅಂತ ಇದೆ ಇಲ್ಲ ಅನ್ಕೊಂಡು ನೀವು ಸುಯಿಸೈಡ್ ಅಂತೀರಿ, ಅವ್ರು ಅಲ್ಲ ಅಂತಾರೆ. ಅದನ್ನ ಹೆಂಗೆ ಡಿಸೈಡ್?
No, it is admitted that it is a suicide.
The
father of the deceased, he is a complainant. He himself admits that it's a suicide.
ಈ ದುಡ್ಡು ಯಾರಿಗೆ ಹೋಗ್ತದೆ?
Moreover, my lord,
ದುಡ್ಡು ಮನಿ ಕೊಟ್ಟಿದ್ರೆ
Father ಮಾತ್ರ ಮತ್ತೆ
is the nominee.
Under the rules, my lord, only
The nominee under the rules.
not 3% can
Only
be
thing
nominee.
is he is not eligible under Rule 38, that's all.
That's all right.
As far as the opinion of the doctor, PM report. ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆ ರೆಕಾರ್ಡಿಂಗ್
ಇದೆ, ಇಲ್ಲಿದೆ, ನಾನು ಹಾಕಿದ್ದೇನೆ. ಹಾಕಿದ್ದೇನೆ.
ಏನ್ ಪೇಜ್ ಅದು?
Page, my lord will find all report, page 97. 97, post-mortem report, examination report.
99, my lord, page number 99, the last opinion as to cause of death. Death is due to asphyxia as a result of hanging.
That is non-supply of required amount of oxygen to the cerebrum is called asphyxial death.
Yes.
Cause of death is hanging.
Yes.
Where is the material to show that he himself hung him? He himself did it anta ellide anta?
In my objection statement, my lord, I have yet to file, my lord. It is ready. I have filed, my lord, his suicide note.
Ellide?
The last page, my lord. 1 minute. I'll file this, right here, my lord, the statement of objections. I have already served the copy on the other side. Page number, my lord. 57. Typed copy is at 57, my lord. Typed copy is at
So the word suicide is missing in the PM report. Anywhere it is indicated, it's a case of suicide.
I will look at it.
He cannot give that. That's what Modi says, Narayana Reddy says. ಅಲ್ಲಿ ಕೆಳಗಿದೆ ನೋಡಿ. The death is due to asphyxia as a result of hanging.
Hanging, yes.
ಆ hanging ಅವನೇ ಮಾಡಿಕೊಂಡಿದ್ರೆ suicide ಆಗ್ತದೆ. ಆ hanging ನಾವು ನೀವು ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ. ಅದು ಎಲ್ಲಿದೆ?
Suicide.
ಅದು ಎಲ್ಲಿದೆ ಅಂತ. So medical report does not help to decide whether it is a suicidal or homicidal. Death due to this, only the medical report. So oxygen supply was stopped to the brain. Therefore, death occurred is the report.
Yes.
Asphyxial death ಅಂದ್ರೆ ಹಂಗೆ ಇದೆ.
Yes, yes, I agree.
Jurisprudence. ಅಲ್ಲಿ suicide ಅನ್ಕೊಂಡು ಎಲ್ಲಿದೆ?
I will look into that matter. I don't have that.
ಅಲ್ಲಿ ಇಲ್ಲೆಲ್ಲಿದೆ ಹೇಳಿ? UDR report ಎಲ್ಲಿದೆ?
UDR report ಇಲ್ಲ. Do not have the UDR report. Death note I have. That death note is at page number 57 of my objection statement.
Page number?
57, typed copy, page number 57.
57.
Yes. This forms part of the investigation, and this is also not disputed by the father of the deceased, not who is the petitioner to do this.
ಈ ಕ್ವಶನ್ ಎಲ್ಲೂ ಬೇರೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ
ನಾನು I have searched number of, because all states have this rule.
ಹಂಗೆ ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಯಾರು ಬೇರೆ ಯಾವ ಸ್ಟೇಟ್ ನಾಗ ಯಾರು ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡೇ ಇಲ್ಲ.
ಈ ಕ್ವಶನ್ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ.
That is the norm throughout the country, my lord. I can supply for that.
ಅಲ್ಲಿ ಜನರಲ್ ಇನ್ಸೂರೆನ್ಸ್ ನಲ್ಲಿ ಆಪ್ಷನಲ್, ಅಲ್ಲಿ ಇದೆ. ಸೊ ಪಾಲಿಸಿ ಕ್ಯಾನ್ ಬಿ ಪರ್ಮಿಟೆಡ್. ಇಲ್ಲಿ ಫರ್ಫೀಚರ್ ಪಾಲಿಸಿ ಇಲ್ಲ ಅಂಡರ್ ದಿ ರೂಲ್ಸ್. General Insurance Act, Lord, if you commit suicide, they will put condition in the policy itself. Policy itself will be forfeited. ಇಲ್ಲಿ ಫರ್ಫೀಚರ್ ಇಲ್ಲ ಎಂಟೈರ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ನೋ. And rule is so ambiguous, my lord. If rule 38 is read, my lord, settlement of policy is concerned, my lord, nowhere settlement of policy is subject to rule 38.
ಅದು ಇದು ಡೆತ್ ನೋಟ್ ಎಲ್ಲಿದೆ?
ಡೆತ್ ನೋಟ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. That is, my lord, along with the
By
reply.
objection statements, page number 57.
57.
Page 57.
57. Last but one page, last page. Last page.
Last page. Yes, you are right. I'm sorry, please forgive me that I will be with you. I am going to mental frustration. I have tolerated child, but I can't. Please don't worry my body burning. Please leave my question. What was his qualification? What was his educational qualification?
BCom, my lord.
BCom.
But what he was posted clerk as Tahsildar, he did not know what Kannada.
ಇದು ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಅನ್ನು
ಅಲ್ಲ ಇದು ಇಂಗ್ಲಿಷ್ ಇದು
English
ಇಂಗ್ಲಿಷ್
translation.
ಅಲ್ಲಿ
Just
FD
one page behind, English is writing.
FD ಆಗಿ ಎಲ್ಲವೂ ಕನ್ನಡದಲ್ಲಿ ಇರ್ತಾ ಇತ್ತು. ಇವನಿಗೆ ಕನ್ನಡ ಬರಲಾಗಿತ್ತು, ಓದ್ಲಿಕ್ಕೆ ಆಗಲಾಗಿತ್ತು. ಡಿಪ್ರೆಷನ್, ವೈ? ಬಿಕಾಸ್ ಪ್ರೆಷರ್ ಆಫ್ ವರ್ಕ್ ಹಿ ವೆಂಟ್ ಆನ್ ಡಿಪ್ರೆಷನ್. ದಟ್ಸ್ ಆಲ್. ಅವ್ನು ಕನ್ನಡ ಬರಲ್ಲ, ಇಂಗ್ಲಿಷ್ ಮೀಡಿಯಂ ಓದ್ದವರು.
ಅಲ್ಲ ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಇಂಗ್ಲಿಷ್ ಹೆಂಗೆಂಗೋ ಇದೆ ಅದಕ್ಕೆ ಹೇಳಿದೆ.
ಇಂಗ್ಲಿಷ್ ಬರೆದಿದ್ದಾರೆ ಅವರು.
His qualification.
BCom.
How was he in academic performance? ಹೆಂಗಿತ್ತು? First class. But ಈ ಲ್ಯಾಂಗ್ವೇಜ್ ಯಶಾದ್ರಿಪುರಂ ಕಾಲೇಜ್. ಬಟ್ ಈ ಲ್ಯಾಂಗ್ವೇಜ್ ಹಂಗ ಅನಿಸ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
ಲ್ಯಾಂಗ್ವೇಜ್ ನೋಡಿದ್ರೆ ಅನ್ಸುತ್ತೆ
ಅದು 9th 7th
ಹೌದು.
ರೂರಲ್ ಕನ್ನಡ ಮೀಡಿಯಂ ಬರೀತಾರೆ ಅಂತ ಕೆಲವರು ಹೇಳ್ಬೋದು.
ಬರೀ ವರ್ಡ್ಸ್ ಇದೆ. ನನ್ನ ವಿಷಯದಿಂದ ನಾನು ಪ್ರೆಷರ್ ತಡ್ಕೊಳ್ಳಿಕ್ಕಾಗ ಅರ್ಥ ಬರುತ್ತೆ ಅಷ್ಟೇ, ಮತ್ತೇನಿಲ್ಲ. I am going to mental frustration.
Also, not suggest that his father is also. So he says, you wanted to be happy alone, Papa.
No, I loved you a lot, Dad. ಹೇಳ್ತಾರೆ.
You can't read it as
No, wait, I don't want to.
person written it in a foreign tongue.
ಅದನ್ನು ಹೇಳ್ತಾರೆ.
ಕಾಮ ಎಲ್ಲಿ ಏನೂ ಇಲ್ಲ ಅದಕ್ಕೆ.
I loved you a lot, Dad ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೇನಿಲ್ಲ, ಹಾಗೆ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ.
Wanted to be happy alone, Papa. Textual language, person in contemplation of death. ಬರೀ ಇವಾಗ ಹೆಂಗ್ ನೋಡ್ಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ. ಹೌ ದಿಸ್ ಶುಡ್ ಬಿ ರೆಡ್ ಅಂತ. ಇದು ಹಂಗೆ ಆರ್ಡಿನರ್ಲಿ, ಬಿಕಾಸ್ ದಿ ಬಿಲೀಫ್ ಈಸ್ ಪರ್ಸನ್ ಹೂ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ಮೀಟ್ ಹಿಸ್ ಮೇಕರ್ ವಿಲ್ ನಾಟ್ ಲೈ ಅನ್ನುವಂಥದ್ದು ಒಂದು ಇಂಗ್ಲಿಷ್. ಆಫ್ ಕೋರ್ಸ್ ಅವರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆಲ್ಸೋ ಸೆಡ್ ದಟ್. ದೇರ್ ಫೋರ್ ಇದು ಡೆತ್ ನೋಟ್ ಹಿಂಗಿದೆ ಇದು. I love you. If I have hurted anyone, I am sorry. God is there everywhere. Donate everything which I have due to my own clothes, my body organs. Don't worry about me. I will be happy alone. Hello. Stay. Sometimes these things happen. Even Robert Clive, who founded the British Empire in India after fighting War of Plassey in 1757, it's Rajat Daul.
Yes.
He goes to England back and commits suicide. It's very. That's what.
But I found the UDR final report, Munad. It is at page 88 of the petition, Munad.
88 of?
Petition, main petition. His petition.
Now let us see ಅದು ಸುಯಿಸೈಡ್ ಅನ್ಕೊಂಡು ಯಾರಾದ್ರೂ ಒಂದ್ ಕಡೆ
ಇದೆ
adjudication
ಪೇಜ್
type
88 ಅಲ್ಲಿ
ಹಾ.
typed copy
of the petition,
of the petition. Description of unnatural death.
88.
88 ಅಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 8 ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ. Description of unnatural death. May I read it, my lord?
Column number
8.
reported accidental or description of unnatural death. ಹಾ ಏನಿದು?
My lord, here, my lord, it describes that
who prepares this?
the police.
Which police and ಏನು? And the
Police prepares in the presence of the Tahsildar, Chandra Layout Police.
it is gist of what report was submitted. It's not independent judgment at all.
It is not independent judgment. And it's even column 1.
It is in first, it is in first person. It is in first person. He reproduces what the reporter said, first informant said.
Yes.
Yes. Aste.
registration form.
It's a UDR registration form.
Here what happens?
The report says there is a final report under 173 by the IO.
ಅದೆಲ್ಲಿದೆ ಅಂತ?
43.
ಅವ್ರ objection ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಅಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ. ಇದಲ್ಲ ರಿಪ್ಲೈ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ 43 ನೋಡಿ.
73. This report will be said.
Relevant at page 45. Yesterday date 3/1/2020 at 10:30 PM. I had dinner with my son and then went to sleep together. On this day, my son was seen at 7:30 AM. He was missing. After looking everywhere, the room on the first floor was locked. The room was secured with another key that I had, and the door was removed by other key which I had. And he was seen hanging on the ceiling fan with a sari around his neck. And with the help of neighbors, we lowered him down from the hanger. And in panic, I brought the dead body to Victoria Hospital without knowledge of legal procedure. My son, Shashi Kiran, used to tell about difficulty in talking in Kannada in the profession and the corruption in the society. And due to these reasons, he lost his life and died by hanging himself. There are no doubts about its death. Hence, the complaint is taken that the legal action should be taken against the dead body.
Did
We challenged this report, 173. Final report.
No, they admit it, Manoj.
We are not, I'm not saying he committed suicide.
It's accepted.
Yes, Lord.
You accepted.
Yes, Lord.
one second. See, come to page 46, column, item 10.
Yes, Manoj.
Did the police officer visit the place to investigate? Yes.
Yes.
Where is investigation report?
But we will secure it from Chandra Layout Police Station.
Huh?
I will file it.
A report in ಹೇಳುತ್ತೆ ಅಂತ ಅದು final report ಆಗ್ತದೆ 173(8) ನಲ್ಲಿ.
Yes.
Not this. Format. Final report ಇದೆ.
173 subclause 8, Manoj, supplementary charge sheet.
Page 48.
There will be inquest and then the statement of the witnesses that would be recorded by the IO under 161. Ultimately, that will be there. This is the final report.
Yes.
The final.
That final report we need to produce.
Yes.
If that he committed suicide
Yes.
is not in dispute,
No,
then there is no necessity. You are not disputing it.
no, no.
You admit that it is.
Yes,
a
sir.
suicide.
I'm not.
Now, how do you overcome?
Question is, my lord,
Section 35. Rule 35.
38, my lord.
38 cannot control, my lord, settlement of policy at all. That's why I'll read both 38 and 25, both together. I'm sure, my lord, absolutely no difficulty. If rule is happily worded, yes, I'll read, my lord, that all. Page 52 of the rule, rule 38.
Whenever a citizen dies, it's the duty of the state to investigate the cause of unnatural death. He will only say this is suicide, oh, homicide, and for the head come. That itself will not be final. Suicide. Correct. Suicide. The contract is that way, therefore we do not use them. Read
Rule 38, my lord, page 52, and rule 23. Both I read.
page number.
Page number, my lord, 49, rule 23, settlement of claim. Rule 38, page 52. I read first rule 23. Whether rule 23, lord, is controlled by rule 38. Settlement of policy claims.
Rule
23.
23.
Yes, 49. Subject to its surrender in original or in duplicate obtained under rule 28, the sum assured by policy which has matured on the insured attaining the age of 55 years will be paid to the insured. B. If the insured is reported to be dead, the sum assured by policy will be paid to the persons whom the insured has under these rules nominated during its lifetime. In such nomination is registered in the department subject to production of a satisfactory proof of death and matters of incidental thereto required by the director. Right? Form of death is immaterial. Form of death by suicide, if it is included in rule 23, but I have no case at all. It says form of death, proof of death I have to produce it. I have produced it.
Go to
38.
other
No.
provision which he
38.
acts upon.
38, my lord, now. Kindly. Page 52.
8.
Policies, not got it. 52. Policies which have been in force for not at least 1 year are not rendered void by death of insured by suicide. This is the rule. But I can understand rule 23 says subject to rule 28. Yes, 38. Not policy claim will be settled. I am out of this court. This rule, if I read about policies which have been in force for at least 1 year are not rendered void.
Rendered void.
Yes.
But rendered void ಅಂತ ಎಲ್ಲಿದೆ?
ಎಲ್ಲೂ ಇಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Not rendered void.
Correct. Suppose I read about like this word. Policies which have been in force
At least 1 year.
at least
least 1 year.
for example, within 1 year. Not why not 1
has
year?
to cover
Why
the
not 2
period
years?
of 1 year.
Why not 10 years?
That's wisdom of the
Wisdom of the
rule maker.
not a rule making authority. Policies which have been in force for at least 1 year are not rendered void by death of insured by suicide.
They are not
Policy,
rendered void if they
policy
come
which has been in force within 1 year, what happens?
Where is the clause regarding voidance?
No, my lord. Therefore, my lord,
if they cross the period of 1 year, then they are not rendered void. That's the meaning.
There may be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 reasons for voidance.
Okay.
And this says that if it is for 1 year available, it is in force,
It's in
then
force.
it is not void.
Then it is not void. Yes.
It doesn't say it is void.
No,
it's my lord.
yeah, my lord is right.
What
My lord is right, but what happens is, here my lord, he commits
What is
suicide
meant by insured?
for 4 months.
What is meant by insured?
Definition, lord. Kindly see. Come to rule 2, my lord. Definition is there. Clause 3E, page my lord 45.
So he is the person. Who
Yes.
has,
Means person who has assured his
his
life under these rules.
he is the-
Under this. But nominee, he cannot make other than parents or wife. Only three nominee. Either mother, father, if he is married, wife after marriage. Now question is, my lord, whether, my lord, rule 23 controls, my lord, 38.
38 ಅದೆಲ್ಲ ಒಂದಕ್ಕೆ ಜೊತೆಗೆ ಓದಬೇಕು. ಹಿಂಗಂದ್ರೆ ಏನು ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ. ಎಷ್ಟು ಲಾ ಶೋಸ್ ಇಟ್ಸ್ ಫೇಸ್ ಇನ್ ಮಾಸ್ಕ್ ಅಂತ ಜರ್ವಿ ಬೆಂತ ಹೇಳ್ತಾನಲ್ಲ, ಇಂಥ ರೂಲ್ ಮೇಕರ್ ನೋಡೇ ಹೇಳ ನಮ್ಗೆ.
Yes, my lord. The rule which
ನೋಡಿ, ಶ್ರೀನಿವಾಸನ್ on law of insurance person.
At least policy condition says, if you commit suicide, not policy will be forfeited, then I am out of this court.
In there is one old English judgment. In every civilized jurisdiction, laws are made to give effect to religious scriptures. Manusmriti says, Atmahatya Mahapapam.
Yes, Mahapapam.
So these religious aspirations of the community are taken note of by the legislature.
Yes.
And they make law.
Yes.
That way. The husband should look after wife, etc. The Bharta Rakshati Ravane. Like that, it
Yes.
has happened.
Yes.
In England, there is a law which says a person who has bought the policy will not be entitled to claim the benefit of the policy or anyone in whose favor he has nominated it if he commits suicide.
Correct.
Number one. Correct. Number two, if the beneficiary of the policy commits murder of the insured, then he is not entitled to get the insurance money. Such a provision is there in our Indian Succession Act, Hindu Succession Act. Hindu Succession Act, there is such a section. A person who kills, he cannot claim property under the person whom he has killed. There is such a provision.
Yes.
These are all that way they are structured. But why? If he commits suicide within 1 year, then policy stands voided anta helik bartitu. Hingandre enu anta
ಬರಲ್ಲ ಅಂತಾನೆ ಹೇಳೋದು. ಯಾಕಂದ್ರೆ ಬಿಕಾಸ್ ರೂಲ್ 23 ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ರೂಲ್ 38 ಅಂದ್ಬಿಟ್ರೆ ಔಟ್ ಆಫ್ ದಿಸ್ ಲಾರ್ಡ್ ಐ ಆಮ್ ಔಟ್.
ಅಂದ್ರೆ ಇದನ್ನ ಕಂಪ್ಲೀಟ್ಲಿ ಆಟಿಯೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತೀರಾ ಈ ರೂಲ್ ಅನ್ನು 38 ಅನ್ನ ಗೋಯಿಂಗ್ ಬೈ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್?
Yes, my lord. Benefit
38 should be removed from the book ಅಂತ ಹೇಳ್ದಂಗ somewhere it should operate. You are not put challenge to that.
I have questioned, my lord, that
rule also.
Rule 38 declare that Rule 38 is unconstitutional.
How it is?
Because Rule 23 will not control, or 38 will not control settlement of policy, any form of death.
Why can't you understand certain small things? If two provisions of a state policy cannot stand together, it is not a ground for striking one of them. Duty of the court is to harmonize and interpret them together. This is how we have said, and it is that Vijay Mallya, Dr. Vijay Mallya versus so and so. This rule is contrary to another rule, is no ground for striking down that one.
No, Rule 38 is unworkable unless, my lord, it is said policy within 1 year. If a person commits suicide, is wide ab initio. Such a rule is there, my lord, I am out of this court. It cannot be read into Rule 23. If 23 says, Lord, subject condition, Rule 23, how it is worded? It says, subject to what? Subject to this, its surrender in original or duplicate, obtained under Rule 28. That is, Lord, subject to Rule 28. No other conditions are there. Form of death is immaterial. How he had died is immaterial.
That is where 23 conditions attaining the age of 55 years.
That is only 55 years. 55 years is there? Yes.
B. If the injured is reported to be dead,
yes,
the sum assured by the policy will be paid to the person or persons whom the insured has, as under these rules. As under these rules means subsequent rules have to look into.
As under these rules, nominated during, and these rules nominated during his lifetime, such nomination is registered in the department, subject to production certificate proof of death. Death certificate produce ಮಾಡಬೇಕು.
Incidental there too.
What form he died is immaterial. If it says, Lord, subject to Lord rules 38, here, B, then Lord, I am out of this court. I have no case at all.
ಹಂಗೆ ಅನಿಸ್ತಾ ಇದೆ.
Rule 23 is independent. Independent, Lord. Where is the forfeiture policy, Lord? Entire rule, Lord, nowhere forfeiture is not there. Whereas in general insurance, Lord, policy will contain forfeiture clause. Here, no forfeiture clause, Lord.
ಇದೇ ಫಾರ್ಫೀಚರ್ ಕ್ಲಾಸ್ ಅಂತ
ಇಲ್ಲ ಪಾಲಿಸಿ ತೋರಿಸ್ಬಿಡ್ತದೆ ತಮಗೆ ತಮ್ಮ ಮುಂದೆ ಪಾಲಿಸಿ ಹಾಕಿದ್ದೇನೆ. ವಾಟ್ ಆರ್ ದಿ ಕಂಡೀಷನ್ಸ್ ಆಫ್ ಪಾಲಿಸಿ ಆಲ್ಸೋ ಮೈ ಲಾರ್ಡ್ ವಿಲ್ ಫೈಂಡ್ ದಿ ಪಾಲಿಸಿ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ along with the writ papers, Lord, and see, Lord.
The inter-provisions of insurance law.
Yes, Lord.
How courts have interpreted such cases are there under the Motor Vehicles Act ಇದೆ. Such provisions are
General insurance ಇದೆ. General insurance.
Yes, ಇದರಲ್ಲಿ
General insurance says not it is optional, not like this, Lord. Kindly appreciate. General insurance is option. If I want, you can. Here, no option. It is a compulsory insurance. That is what difference between the general insurance and this insurance? He must become a member. Membership is a rule. Exception is 55 years. Cross.
how
Suppose, Lord, general insurance. If I want policy, yes, they will put. These are the conditions under the policy. If you commit suicide, policy, entire policy will be forfeited. But here, policy will not pay 68. Only 4 conditions. Kindly take the policy. Pay 68. There are no conditions.
ಅಲ್ಲಿ ಕಂಡೀಷನ್ ಇರಾಗತ್ತೆ ರೂಲ್ ನಲ್ಲಿ ಇತ್ತು ಅಂದ್ರೆ ಕಂಡೀಷನ್ ಇರಾಗತ್ತೆ. ಈ ಲ್ಯಾಂಡ್ ಗ್ರಾಂಟ್ ಇರ್ತದಪ್ಪ ಅಲ್ಲಿ ನಾನ್ ಇಲಿನೇಷನ್ ಕ್ಲಾಸ್ ಇರಲ್ಲ. ಅವಾಗ ಕೋರ್ಟ್ ಸೆಡ್
Yes, Lord.
ರೂಲ್ಸ್ ಟು ಬಿ ಲುಕ್ಡ್ ಇಂಟು ನಾಟ್ ದಿ
Yes,
ಡಾಕ್ಯುಮೆಂಟ್.
Lord. Rules shall be looked into, but rules are not when 38 is so ambiguous. It can't be even, I can't understand what it is. I can understand what policy within 1 year old, if person commits, it is wide ab initio. Idre out of the no
And all other states also have got similar rules.
similar rules, but no interpretation of this rule.
So many states ಯಾರು
ಯಾರು ಮಾಡಿ
so many years
ಇಲ್ಲ so many years hardly will case come to the court. Hardly.
Court cannot say a rule is particularly without meaning. It has been there since many for decades.
1958 is the 309 rule which was framed by the governor. Thereafter amendment 1978 text amendment ಆಗಿದೆ.
Perhaps that rule is made after you, a little before you were born.
I am born.
You are born.
Impugned order, my lord, at page 193.
No, what tribunal says, I will come. What tribunal says is, first of all, the first order says, Lord, the tribunal, in the first instance, declares, Lord, Rule 38 is unconstitutional. It only says whatever amount paid to the under the policy shall be refunded to the father ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಈಗ ಪೇಮೆಂಟ್ ಮಾಡಿದಾರ
ಇಲ್ಲ
ಮಾಡಿಲ್ಲ.
ಮಾಡಿ.
ಏನಂತ ಹೇಳ್ತಾರೆ ಟ್ರೈಬ್ಯುನಲ್?
For the purpose of claiming whatever premium is paid, the tribunal declared Rule 38 is unconstitutional. For the purpose of matured policy amount, tribunal says it is not unconstitutional. Then, my lord, it was tested before this court. This court remanded the matter. On remand, my lord, tribunal says, Lord, he cannot maintain the application. Number 1. Number 2, my lord, it examines on merit also. What it says is, policy condition is that if the insurer commits suicide, you are not entitled any amount. Policy condition is not there.
Rule ಇದೆ ಅಂತ.
Rule ಇದೆ. But no, my lord, Rule 38 and 23 should be interpreted. If my lord says it should be read into Rule 23, probably I have no case.
Lord, may kindly look
If-
into
if
page
Lord-
193 of the impugned order, my lord.
I read, Lord, both.
Page 193 of the impugned order, my lord,
Absolutely,
paragraph
Lord.
number 16.
In one breath, tribunal says,
Paragraph number 16, my lord. Page 193 of the improved order. Applicability of rule 23B of the rules.
My lord, kindly take page 190. 190, para 13 is the first finding, 191. Tribunal says, you have no locus to question this. You are not a government servant. It's service matter Allah. You cannot approach the tribunal at all. The application is not maintainable. 191, first question. After remand. After remand, tribunal says this. Then tribunal also examines on merit. Para 14. Para 13 is the finding. I will not read the, take more time. The applicant who is not a government servant, who is just nominee on an insurance policy issued to the government servant under the rule, has no locus standi to challenge the virus of the rules regulating condition of service of the government servants, when government servant himself has not at any stage during his life challenged these rules. The applicant cannot be considered as aggrieved person under the 80 Act 85. Hence, challenge of the applicant to the provisions of Rule 38 is rejected as being without any locus standi. Hence, prayer so and so untenable. Then, my lord, para 14 on merit, it gives finding. Question number 1, my lord, one tribunal says, my lord, I have no locus. Question of going into merit never arises.
All right. ನಾವಾದ್ರೂ examine ಮಾಡ್ಬೇಕಾ?
My lord has to examine what one or other way, my lord.
ಟ್ರೈಬ್ನಲ್ ಏನಾರ ಹೇಳ್ಕೊಳ್ಳಿ. ನಾವು ನಿಮ್ನ ಮತ್ತೊಂದ್ಸರಿ ಕೆಳ ಕಳಿಸಿ ಮಾಡಿ
No, my lord, no.
ಅವ್ರು ಮೊದ್ಲು ಕೆಳ ಕಳಿಸಿದ್ದ ತಪ್ಪದು. ಮತ್ತೆ ನಾವೇ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕಿತ್ತು. ಬರೇ ಕೇಸ್ ಹಾಕೊಂಡು ಏನೋ ಮಾಡಿ.
Certainly, my lord. Para 14 ಅಲ್ಲಿ, Lord, tribunal says rule
ಇನ್ಶೂರೆನ್ಸ್ ಬಂತ ಬೈ ಶ್ರೀನಿವಾಸನ್ ಕೊಡಿ. ಡೆತ್ ಬೈ ಸುಯಿಸೈಡ್ ಅನ್ಕೊಂಡು ಏನೋ ಒಂದು ಇದು ನೋಡ್ಕೊಡ್ರಿ. ಸುಯಿಸೈಡ್ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಕೊಡಿ.
Paragraph 16, my lord, ma'am, kindly have a look.
Paragraph 16 of
impugned order, my lord, page number 193.
ನಾನು ನೋಡಿದ್ವಿ ನಾವು. We read that.
Yes.
ಸುಯಿಸೈಡ್ ಅನ್ಕೊಂಡೆ ಒಂದು ಸಣ್ಣದು ನೋಟ್ ಇದೆ. ಕೊಡಿ, ಯಾರಾದ್ರು ಬಾರ್ ಮೆಂಬರ್ಸ್ ಅಸಿಸ್ಟ್ ಮಾಡಿ. ಶ್ರೀನಿವಾಸಂದಲ್ಲಿ ಮಿಸ್ಟರ್ ಮಹಾಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. These are all intended.
But all those cases are under general insurance, my lord. It is there, my lord. But particularly under these rules, my lord, which is a compulsory insurance, my lord, it's entirely different.
How that makes a difference to the interpretation of Rule 38?
Why? Because it is my lord, insurance is option there. It is not a compulsory insurance.
All right. How that is relevant to interpretation of 38 anta?
Because there is a clause in the policy, person commits suicide, not policy will be forfeited.
ಅದೇ ಕ್ಲಾಸ್ ಇದು.
But illi clause ಆಗಿಲ್ಲ. Rule 38 will not say so, my lord, in many words.
Suicide.
Policy ಇಲ್ಲ, Rule 32 ಹೇಳೋಲ್ಲ.
Affected a policy on his death for life under the policy annual premium of £10 payable in later years. Trustees were appointed. Murphy committed suicide and the insurers paid the policy monies to the two surviving trustees. Two and possibly part of it, third, the premiums had been paid by Murphy of trust funds, which Murphy had obtained from business clients, which had parted with their money by way of an investment in a development. The investors in the present case sought share of the insurance proceeds based on their traceable proportion of the premiums paid under the policy. What was contended was the right of the investors to claim a share in the policy monies themselves, and that there was no authority upon which the investors could rely for the proposition the payment of he made to them as a part of the policy. The equitable charge applied in tracing cases went on further than allowing the beneficiary to recover the monies. Only did not give rise to equitable co-ownership. 1997, 3 All England reports. ಅದೇ as against claim person. ಮಾಡ್ಕೊಂಡು ಸೂಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಅಂತ. ಇಂಗ್ಲಿಷ್ ಲಾದಲ್ಲಿ ಬಹಳ ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ಒನ್ ಮೋರ್ ಆಸ್ಪೆಕ್ಟ್, ಪಾಲಿಸಿ ಬಿಕಮ್ಸ್ ವೈಡ್.
Yes.
Becomes suicide.
If he commits suicide within 1 year. You know, because the policy has to be in force for a period of 1 year.
It is in force
By here it is not in force
for 1 year.
because he expired within 4 months.
Of for buying that subscription.
Yes, sir.
ನೋಡಿ ಇವೆಲ್ಲ ರೂಲಿಂಗ್ಸ್ ಎಲ್ಲ ಓದ್ಕೊಂಡ್ಬರ್ರಿ, ಅದ್ರ ಮೇಲೆ ಸಾಕಷ್ಟು ಲಾ ಡೆವಲಪ್ ಆಗಿದೆ. ಯಾವ್ದು ನೋಡಿ ತಿಳ್ಬಾರ್ದಂಗೆ ಹಾಗೆ ಇಂಟರ್ಪ್ರಿಟೇಷನ್. ರೂಲಿಂಗ್ಸ್ ಎಲ್ಲ ತಗೊಂಡು ಇವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಡ್ಬರ್ಬೇಕು.
Yes, Lord.
ಲಾ ಡೆವಲಪ್ ಆಗಿ
But my endure to your lordship is, Lord.
ಇವನು ಓದ್ಕೊಂಡು ಮಾಡ್ದಂಗೆ ಉಪಯೋಗ ಇಲ್ಲ, ಬೇರೆ ರಿಪಿಟೇಷನ್ ಆಗಿ ಸ್ವಲ್ಪ ಜುರಿಸ್ಪ್ರುಡೆನ್ಷಿಯಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಕೊಡಿ ಆ ಪೇಜ್ ನಂಬರ್ ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ.
The reason behind saying that 1 year should be enforced before it becomes
Wide.
enforceable. Up to 1 year, it is not enforceable.
Yes.
Here is that, and what is the reason for it?
No. If supposing he dies in any other way other than suicide, then it is enforceable. He is entitled.
No. Even other life insurance companies also, they.
No, here rule 38 says so.
And
Rule
they
38.
this condition.
Rule 38.
The life insurance policies issued by the other companies, there is a condition that if he commits suicide within 1 year, then they are not liable to pay.
Yes.
So that laws regarding repudiation is there.
Is there.
But in this, whether it is there, if so, where?
Rule 38 itself says.
This is one. Ali, you read Rule 38 conjointly with 35, 36, 37. And then you make your submission.
Fine.
This is one. Second one, the logic behind prescribing 1 year for
Yes.
voidance of the policy.
Yes.
ಅದು ಯಾಕಿದೆ?
Yes, ma'am.
What is the logic behind that? What is the jurisprudential background of it?
What I had earlier not studied it, says that it would
Insurance-
amount to moral turpitude.
Lord, under insurance law.
I will place.
ಇವಕ್ಕೆಲ್ಲ ಲಾಜಿಕ್ ಇರಲ್ಲ. ಇದಕ್ಕೆ ಅಕ್ಯುಮುಲೇಟೆಡ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಫ್ ದ ಮ್ಯಾನ್ಕೈಂಡ್ ಮೇಲೆ ಲಾ ಮಾಡ್ತಾರೆ ಇವನು, ವಿಚ್ ಆಲಿವರ್ ವೆಂಡಲ್ ಹೋಮ್ಸ್ ಸೇಸ್ in common law, in his famous book Common Law. The life of law is not logic, it is experience gained through the life process. ಇವೆಲ್ಲ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಮಾಡೋ ಕಾನೂನುಗಳು, ಲಾಜಿಕ್ ಹುಡುಕಕ್ಕೂ ಸಿಗೋದಿಲ್ಲ ನಮಗೆ. ಇಷ್ಟು ಜನಸಂಖ್ಯೆ ಇದೆ, ಸತ್ತೋರ್ ಚಲೋ ಆತು ಅನ್ನೋ ಲಾಜಿಕ್ಕು ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಹಂಗಿರಲ್ಲ ಅದು. Therefore, Oliver Wendell Holmes said, the life of law is not logic, it is experience.
In the sense, the reason for that.
If Rule 38 is unambiguous, my lord, this question will never arise.
ಎಲ್ಲ ದೇಶದಲ್ಲಿದೆ ಇದು, in all countries.
In all the states, this
They say 1 year.
is there.
Otherwise, what may happen is, ಈ ಕಂಪಲ್ಸರಿ ಮಾಡ್ಕೊಂಡು ಒಂದು 50 ಲಕ್ಷ ರೂಪಾಯಿಗೆ, I will not name a particular person, which Freedom at Midnight mentions, Larry Collins and Dominique Lapierre, they mention a particular person before shooting a particular hero, I'll not name, he bought insurance policy making his Bhabi the nominee. There is a reference to that. I'll not say more than that because everybody is saying. Of course, what I'm saying is from the book only. That's another thing. See,
Yes. Picture one, in one picture, then my lord, he kills.
The all scriptures, including Quran, Jhanda Avesta,
Can be brought under the
Manusmriti.
doctrine of contra proferentum, 1966 SC 1664 paragraph 11. The other is 2022 4 SCC 482 or 582 by Justice Chandrachud and Nagaratna.
Please give me the citation, sir.
Contra proferentum,
Contra.
PRO. And
AR 19.
AR 1960 Constitution Bench, AR 1966
66 SC
1664, paragraph 11.
64. This is Mr. Shankar.
Then next is 22, volume 4 SCC.
Huh? AR?
No, 2022, volume 4 SCC. Page 582, party's name Manmohan Nanda versus United India Insurance Company.
This aspect is discussed.
That is under general influence.
That's all right.
Justice
Law relating to insurance is
that-
spread
that-
in various walks of life.
Yes.
So the micro vehicle nel bartade,
Yes.
agriculture insurance bartade,
Yes,
life insurance bartade.
Yes,
Mr. Shankar, can we request you to assist in this matter?
I can't desist.
No, you have got yourself risked now by assisting us.
Please.
Kindly help us in
That's
this
why I said I
matter.
can't desist.
It's such law, to my knowledge, is there even in Scandinavian countries. Some of the judgments I read. Such law is there in Israel, where Justice Aharon Barak, the Chief Justice of Israel Supreme Tribunal, Supreme Court, has referred to this. There are such judgments. Therefore, kindly help us. In the meanwhile, we will also look into.
Raul Colin Walks, RAUL, Raul Colin Walks on insurance that may be secured. Then the McGilliver, that's the other. I'll give it to the authorities later. I'll
Kindly.
have it, I'll bring it.
Learned senior advocate, Mr. S.P. Shankar, on our request has graciously agreed to assist the court as amicus curiae. First, the petitioner shall share a copy of the petition along with the copy of statement of objections with the learned amicus. Right now, we'll do something in this. Simple ansalla, just hang on, adrelle estondu material ide nodi.
the general insurance, I have made a case law, I'll bring your lordship.
Contract of insurance is a commercial contract. Rule elsewhere cannot be imported into it.
It is not a contract between the parties.
Please to stay. A rule is divorce the contract, and what the parties have contracted cannot be annulled by the court saying that we read something else into it. If it's a statutory policy, it's one thing. Here, the service conditions are controlled by those rules. Those rules cannot be imported into the policy of insurance to say we are denying the liability.
No, but Supreme Court said exactly reverse of what you are saying now. Exactly reverse of what you are saying now. Just look into. It may be of some help to us.
Yes, my lord.
When we'll have this very interesting point.
Yes, my lord.
Where it puts us on our this one. All this matter for further hearing on the other one date. Some date, amicus and kelbeku. Date and when amicus is appointed, he should be consulted. Whichever date you want. It's our duty to
25.
Ask you. 25.
Yes.
25 element.
230.
Huh?
230.
Bani no.
Copy. Copy ಮಾಡ್ಕೊಳ್ಳಿ. ಅವ್ರಿಗೆ
Reference.
For further in 230 matter, theme of 43, PD Surana.
I seek the pardon of the Honorable Court to make, I have omitted to make one submission, kindly permit me, Lord.
Yes, sir.
Section 96, which invests a right of appeal is controlled by section 99 CPC, which restricts the scope of interference. I think Karnataka High Court has not dealt with it. CPC.
Oh.
And only one decision rendered in this section that perhaps may assist your lordship is Kiran Singh.
54 Supreme Court.
54 Supreme Court, 340 paragraphs 5 and 6. The appeal had to be filed to the Court of District Judge. It was by mistake filed into the Court of Subordinate Judge. Then the subordinate decided the matter. The ultimate law, there are two aspects of law declared. One is wherever and whenever the decree sought to be pressed into service, it can be resisted for want of jurisdiction. The
That,
term
you are
quorum
referring
non-
to Kiran Singh versus Chaman Paswan.
Please, this is where the first time doctrine of quorum non judice was employed. Quorum non judice. I think we'll make it short. Kindly look at page paragraph section 99. Yes, 99. Yes. We have not used this. The buyer has not used. That's the reason. No, what is it?
99.
Section 99 CPC.
So they can.
No, I have the Leo the Honorable. No decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any misjoinder or non-joinder of parties or cause of action, or any error, defect or irregularity in any proceedings in the suit, not affecting the merits of the case or jurisdiction report. Limited scope. My lord will have to, if they know that the findings are to be upset, it is for particular reason. The jurisdiction or the want of it. That's what Kiran Singh would say. I mean, not a case for interference is the normal submission. Section 99 is pressed into service. 1954 SC 5540 is the Kiran Singh.
That only says a decree without jurisdiction, be it pecuniary, subject matter, territorial, is non-est, and therefore its execution can be resisted even in collateral proceeding.
The moral from that is, if any other reason the decree is wrong, only because the decree is wrong in a small matter of irregularity or want of it, they do not upset the press. That's not. That means it checks and controls the free flow of section 96. Section 99, in my submission, checks and controls the free flow and exercise of power under 96. It is controlled unless it is for exceptional reasons. And this is not a case where interference is justified. Assistant back.
Yes.
Your Lordship's permission. Lord, the gist of the plaintiff's case, my lord, is, my lord, that, my lord, the propositors was Chinnappa Reddy, alias Chinnaya. Lord, he had two sons, Krishna Reddy and Muniswamy Reddy. Other than, my lord, there are other children, but who have expired, my lord, without issues. So the dispute is between Krishna Reddy and his brother Muniswamy Reddy. The branches
Others may not wait. You are entitled to be here, but not for your cases. Yes.
My lord, the plaintiff and defendant number 3, my lord, represent the branch of Krishna Reddy.
Plaintiff and defendant number 2, 3. 3. Your client.
Yes.
Yes.
And my lord, defendant number 1 and 2 represent the branch of Muniswamy Reddy, my lord. The other defendants are, my lord, persons who derive title from, my lord, defendant number 1 and 2.
That alienees.
Alienees. But so therefore, my lord, the only thing that your lordship may have to see is, my lord, the evidence which is laid by the plaintiff and the defendants, my lord. 1 and 2. But here, my lord, now, your lordship may see, the gist of the plaint is that Chinnappa Reddy, my lord, had ancestral properties, which were succeeded to by his two sons, Krishna Reddy and Muniswami Reddy. And my lord, the plaintiffs are entitled, my lord, for a share in the plaint schedule properties. 5 properties are mentioned in the plaint schedule, my lord. I will not trouble your lordships by taking your lordships to the relevant pleadings, my lord, which may not be necessary, my lord. But one thing that has to be noticed, my lord, is the defendant, my lord, defendant number 1 and 2, my lord. They have been changing their or developing their stand, my lord, right from the beginning. They have 2 defenses which have raised me. Number 1, they say, my lord, there was prior partition.
There was prior partition.
Absolutely no details are given, my lord, about the prior partition, like what is the date, what are the properties which are given to, my lord, either of the branch. Absolutely nothing is said except a bold statement, my lord, in the first written statement saying that the defendant, my lord, the plaintiff's father, Krishna Reddy, my lord, has sold the properties allotted to him in the oral partition. Except that, my lord, there is absolutely nothing else which is mentioned, my lord.
They only say there was a oral partition and properties.
That your lordship may get it at page 35, my lord. Your lordship may not be, your lordship have seen it time and again. Lord, ad nauseum. So, my lord, this situation continues for another 8 years, my lord, till the plaintiff PW1 is examined. Lord, absolutely, this is the pleading which is continued. And when, my lord, they find that there is a difficulty that, my lord, they have not mentioned what are the properties and other things, then they come up with an amendment of the written statement.
Para 8.
Para 8 and 8B. For the first time, my lord, they mention that the 2 properties, my lord, they don't mention that way, my lord, but they say that 36/1 was allotted to Krishna Reddy, my lord, and he has sold 37/2. If your lordship will see para 8A, my lord, at page 42.
There was a partition between Krishna Reddy, father of the plaintiff, and Muniswami Reddy,
father of defendant.
father of defendants 1 and 2. The said Krishna Reddy and Muniswami Reddy were brothers.
During their lifetime, there was partition, and in the said partition, the said land in survey number 36/1 of Arlukundi, apart from other properties, were allotted to the share of the father of the plaintiffs. Now, 36/1, my lord, your lordship may make a note there is not the suit schedule property.
36/1 is not the suit schedule property.
It is not.
Alla, by description, ಏನೇನೋ ಸ್ವಲ್ಪ
But that lord, the appellants will clarify.
Even that 36/1 is also sold by the first plaintiff's father. Documents we have produced. 36/1 is also sold by them.
That I'll come to, my lord. I'll answer that argument.
And 37/2.
Now, my lord, 30. Now, my lord, in the additional application for additional documents that they have produced now, my lord.
Yes.
Lord, a specific contention is taken. So sorry, but I want to that, my lord, Chinnappa Reddy, my lord, sold the property in 1951. Single paper. Can you just give me the data? Additional document.
IA for additional documents.
Additional documents. The affidavit. But I'm sorry, I didn't sing that document here.
In Surana's application.
Yes.
4127 application.
Yeah, para 4, my lord, of that application, affidavit, they mention the date. I had it just now with me.
4951.
Yes. I'm sorry, para 9. No, no, it's close. Lordship, get that date, my lord, at para 9. So 4/9/1951
Is the sale deed
is the sale
of Chikka Chinnanna
by
He
Chikka
sold it
Chinnanna
to
to
that lady,
Muniamma.
Muniamma.
Now, this is the case which is made out, my lord. Now, my lord,
Right.
the lordship now will see what was the cross-examination of PW1 Lord, before the amendment of the written statement, my lord, at page 93, my lord.
At page
93 is the cross-examination. Your lordship may make a note. The amendment is brought into effect on 16/2/2005. Sorry, 2000?
No.
Amendment.
8A, 8B you're speaking of,
Yes, my lord.
when it was effected.
Yes, my lord. I'll just think I made a mistake.
But unless the court otherwise says,
Yes, my lord.
the court granting leave to amend under 617, unless it says otherwise, this is what Mr. Shankar says in his APC,
Yes, yes.
it will relate back
It will
to
relate
the
back.
date
No,
of
I
the
am-
institution of the.
I'm not saying on that point at all, my lord. It does relate back, my lord. I'm not disputing that point. What I'm saying is how they are developing the defense which is taken of prior partition. First, they don't give any my lord, details. Then, my lord, after the amendment is carried out, for the first time, my lord, sorry, before the amendment is carried out, my lord, the suggestion is put to, my lord, the plaintiff's witness, my lord.
This is amendment effected after trial began.
After trial began.
But date of the amendment, you know?
The amendment, I have noted it, my lord, as 2015.
14.
2014.
14.
14. 14.
May not be. Because amended WSC is filed on 8/2/2013.
13 it says.
So
But it might have been
amendment
allowed on
get
that.
to that.
It might have been allowed.
8/2/13.
13. First written statement is 16/2/2005. Amended is 8/2/2013, my lord, after 8 years.
Yes.
Now, before 2013, my lord, at page 93, your lordship will see the cross-examination that has taken place on 14/2/2011.
14/2/2011 cross-examination of
PW1.
PW1.
Yes, ma'am. Para 2, my lord,
Page number?
93. 93. It was not true that there was a partition between my father and his brother. It is not true to suggest, my lord, this is important, my lord, that plain B schedule properties were allotted to my father's name. So,
This is cross-examination
by
of
defendant number 1 and 2 of PW1, plaintiff.
1.
The suggestion given, my lord, is that plain B schedule property is allotted to the father.
Plain to B scheduled property is allotted to other than 37.
37, my lord, I'll just come to that, my lord. Your lordship,
Allah,
it
B
is there
schedule
in
is
this
other than
paragraph.
37.
Other than
Other
37.
than 37. You are content, you want to say that suggestion binds the suggester that way?
It binds the suggester, my lord, and the suggest, it also, my lord, is an admission that B schedule property is also a joint family property. Otherwise, there was no question of allotting B schedule to, my lord, one of the branch. To Krishna Reddy's branch. By implication. Then, my lord, it is again, suggestion is said, it is put, my lord, it is not true to suggest that the father has sold plain B schedule property to different persons under registered sale deeds. Then, my lord, then again, my lord, it is not true to suggest that plain A schedule property was also sold by my father in the 1967. Now, my lord, as regards plain C, D, and E, my lord, is in para 4, my lord.
Five properties.
5 properties.
A, B, C, D, E.
Yes.
So far as A is concerned, it comprises of 37.
37.
Rest of the properties, B is 36.
36/4 is what
36 for
suit schedule says.
4. No, what you want to make out from this?
No, what the argument that was at canvas before your lordship was B to E properties are not suit schedule properties.
No, he is not concerned with that at all.
Not concerned, but what I want to point out, my lord, is that subconsciously before this, they have started in claiming that only A schedule properties thing, my lord. They have mentioned very clearly, my lord, in their suggestion to me that, my lord, the B schedule property is a joint family property which I have sold away.
So it amounts to his admission itself and not the contention.
None. Otherwise, there was no question of, my lord, allotting B schedule property to, my lord, one of the branch of the joint family.
Page 93, na?
93, and because the sentence starts from the last 93. It is not true
Not
to suggest
to suggest.
that plain B schedule properties was allotted to my father's name. It is not true to suggest that my father has sold plain B schedule properties to different persons. Then 4 lines later on, it is not true to suggest that plain A schedule property was also sold by my father in the year 1967. So A and B properties, my lord, they are saying came by partition to your father has sold it.
Our suggestion of premise ಮೇಲೆ ಇದೆ ಅಂತ.
Yes, that's the premise. If the whole paragraph, it is not true to suggest there was partition between my father and his brother prior to 1960. It is not true to suggest plain B schedule property was allotted to fathers. Then A schedule also is mentioned 4 lines thereafter.
Yes.
It is not true to suggest that the plate A schedule property was also sold by my father. In the year 1960.
I also don't know who
That's
got that property. But he is confining now to B schedule. A schedule is separate argument is anymore.
A schedule is there. I'll come to A schedule. I'm only first, my lord, covering up the thing that all the 5 properties, my lord, are actually admitted to be joint family properties, or my lord, they don't go beyond one step, my lord. If your lordship also reads para 4 of the same in the next page, my lord, page 95.
No, a small question arises.
Yes.
We'll consider that
Yes.
also. Mr. Shankar also may consider our point of view. What he says is, we have nothing to do with B, C, D, E. But you cannot grant decree against me.
It's correct, my lord. I am only adding to Mr. Shankar's, my lord, though I am appearing for defendant, my lord, I am only adding to this. And I am the plaintiff, my lord, I have to show that these are properties, my lord, of the family. Otherwise, my lord, the decree, my lord.
No, now, since he has given up all and whatever claim in respect of B, C, D, E, his only contention is, ನನಗೆ ಅದರ ಮೇಲೆ ಯಾವುದು ಹಕ್ಕಿಲ್ಲ ಅಂತ ನಾ ಹೇಳಿದ್ದೇನೆ. ಅದರ ಅರ್ಥ ನನ್ನ ಮೇಲೆ ಡಿಗ್ರಿ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
I am only.
You can't give me give a decree against me. You can't give decree against Kempegowda.
Correct.
Because he has nothing to do with these property.
No, that is the reason why I am pointing out this, my lord. That, my lord, it is they themselves bring out this answer from my mouth that A, B, C, D, and E are family properties. Therefore, there is no question of granting decree against Kempegowda or Bairegowda. It is, my lord, we are entitled to the decree, is what I want to canvass before you.
No, even if he says you want to do whatever you want to do,
yes,
still you want a decree against him.
Not against him, my lord. I want a decree in my favor, in the favor of.
As between.
I have already filed an affidavit. An affidavit is filed before this court.
A partition decree has to be between co-sharers.
Co-sharers.
That's the premise of law of partition. ಈಗ ಯಾರು ಅಗೇನೆಸ್ಟ್ ಕೊಡ್ಬೇಕು ನಾವು ನಿಮಗೆ ಡಿಗ್ರಿನ?
Lord, the decree is granted to grant my share, my lord.
To you?
And it is up to me thereafter how I will execute it, my lord, if it
left to you.
Left.
No. To grant decree in your favor,
I have to show that it is my family property.
not only that, against whom you want a decree? There has to be a decree holder and a judgment debtor,
Correct, my lord.
except in interpleaders.
Yes, my lord.
Who should be the different, the judgment debtor is his question. I have no claim whatsoever against that property.
Their omnibus argument
Time.
is B2E properties are not family properties.
No, they say,
Therefore,
I
they are
am
not
not
entitled.
concerned with that. We'll assume for a moment, because of certain suggestions in the cross-examination. Courts have taken the view, ordinarily in the cross-examination, what has been suggested by the other side binds the suggester. ಅನ್ನೋ ಒಂದು loose view ಇದೆ.
Yes.
Going even with what he says, we have no claim whatsoever against this. If we record that statement, because that is made on oath. Correct. None, the kind of decree we should direct the registry to draw, how it should be. ಅದ್ ನಮ್ಗೆ ಹೇಳಿ, ಆ ರೀತಿ ಡಿಗ್ರಿ ಮಾಡ್ಲಿಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ ನಾವು.
Lord, yes, whoever is in possession. Lord, I will have to execute it against whoever is in possession of the property, Lord. Because these properties are alienated.
ಅವ್ರ ಪೊಸಿಷನ್ಗೂ ಇಲ್ಲ ಈಗ.
They may not claim that they are in possession. They have sold it.
Say that they are not in possession.
If they have sold family property to outsiders, to third parties, then when I execute the decree, my lord, I should have a decree which says that I have half share in the property.
ಯಾರಿಗೆ ಡಿಫರೆಂಟ್ 4, 5
4, 5 and 9 also has purchased it from 4 and 5.
The which property?
Some parts of 37, some of B schedule also, my lord.
B schedule also.
Yes, my lord. B schedule.
ಈ ಶೆಡ್ಯೂಲ್ ಯಾವ್ದು ಇಲ್ಲ.
Show.
ತೋರಿಸಿ ನೋಡಿ ಯಾವುದು.
Lord, your lordship may see page.
$30, 29.
Lord, page 48. This is fifth defendant's written statement, which starts at page 46. At page 48.
Fifth defendant claims under D1.
D1 and D2, my lord.
Huh?
D2, my lord, D2.
D1 again, he appears for only D1.
LR something D1.
That's what.
D2.
D2. You appear, so D1 and D2 both are there.
Yes.
Which property is sold by D1, D2 in favor of?
48, in the middle of the page, it refers to 36-4, which is B schedule property.
The survey number 36-3 measuring 3 acres in the survey number so and so were registered in the name of Chinnaya, son of so and so. By whom? By whom?
Lord,
Chinnaya
I have
should
to
be long ago.
Lord, I have to say, my lord, that the pleadings in this case, my lord, have baffled
Very
me.
scanty and
37 pages.
ಅಲ್ಲ ಅಲ್ಲಿ
But after,
wait.
but I found, my lord, that D5 is claiming to be the owner of 36-4.
B5 may claim. You have to show, to claim a decree as against a particular person, you should show that a person is in possession of the property, or he is making a claim, or that he has sold or alienated, encumbered that property in favor of XYZ, who are parties to the proceeding. ಅವಾಗ ಮಾತ್ರ ಡಿಗ್ರಿ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
Lord, at page 48 itself, my lord, I don't know how it has transferred to defendant number 5.
ಇಲ್ಲ ಅದರಲ್ಲಿ. Fifth
But
aspect
at the bottom of the page, it says, my lord, the father of defendant in survey number 36/4, in the name of Chinnaya, son of Nanjundappa, father of Krishna Reddy. Accordingly, by order of the Deputy Director Land Records, survey number 36/3, Issa made in the name of Guru Reddy, son of Naga Reddy, father of fifth defendant and survey number 36/4.
At the most ಏನ್ ಮಾಡ್ಬೋದು ಅಂದ್ರೆ,
yes,
defendant numbers 4 and 5.
Yes.
And 9. If they are he is the alienee of 4, 5.
Yes.
ಅವಾಗ ಅವ್ರ ಮೇಲೆ ಒಂದು ಡಿಗ್ರಿ ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
That's all. And my lord, as far as plaints C, D and E, D have already got the decree. A and D have already got the decree. Only C, B, C and E were left out. And page 95 only at para 4.
Originally, B scheduled property was different property. Substitute ಮಾಡ್ತಾರೆ. The issue number 4 is deleted.
ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ರು ಸಹಿತ
ಅಲ್ಲ,
ನಿಮ್ ಕ್ಲೇಮ್ ಇಲ್ಲ ಅದ್ರ ಮೇಲೆ.
ಅದು correct. They have given up the.
You have. That's what.
We will work out.
I think that somebody could have. ಅದು ಬೇರೆ ಆಗಿದೆ. Admiralty, insolvency, matrimonial. Four opponent ಬೇಕಾಗಿಲ್ಲ. World is the opponent. Decree is a decree in personam ಮಾಡ್ತದೆ. ಹಂಗಾಗಿ person who secures decree, person against whom it is secured, ಇಬ್ರು secure. Against 4, 5, 6, 9, 4, 5 and 8. 4, 5 and 9, 4, 5 and 9.
4, 5 and 9.
4, 5 and 9. Record ಮಾಡ್ತೀವಿ. 4, 5 and 9, who are their advocates?
I have to for 4 and 5.
ಹಾ. Just ಒಂದು ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊತಾ ಇದ್ದೇವೆ ಹಂಗೆ. ನಿಮ್ಗೆ how you got these properties?
Suran sir had already cleared, my lord, that is only with respect to the we had buy bought it from third party. Only to the extent of third party in the ಯಾರು purchase ಮಾಡಿದ್ವಿ ಆ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ನಾವು ಬೈ ಮಾಡಿರೋದು.
ಯಾರಿಂದ? From whom you bought?
From D2.
From D2?
D1 next.
Then what he says is true.
No, my lord.
Huh.
I am adopting with Suran sir's arguments.
Then you may sink also.
ಅದು ನಿಮ್ಮ
Like Titanic ship. You are riding.
Yes, ma'am. I'll get clarification.
Huh?
I'll get clarification. Implications ಗೊತ್ತಿಲ್ಲ.
If he doesn't have any claim in respect of schedule B, C, D, E.
Where do you stand?
Of B, C, D, E.
At the hands of Surana, you also will do. Because of Nemo det quod non habit will apply there. There are such judgments.
I will give the original plaint and also the amended plaint for clarification. That will clarify.
ನೀವಂತೂ B, C, D ನನ್ claim ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀವಿ.
Blindly following.
None of the other defendants, except D3 bit, none of the other defendants are concerned.
B, C, D ನಲ್ಲಿ ಯಾರ್ದಾದ್ರು claim ಇದ್ರೆ ಅವರು.
Fourth defendant is the purchaser of 36/1. Fourth defendant is the purchaser of 36/1.
Fourth defendant is purchaser of 36/1. 36/1 is B.
No, 36/4.
36 anyway, it is not A.
I will clarify.
It is not A.
I will clarify tomorrow.
One of the reasons which is given by the trial court, my lord, to refuse B, C and E, my lord, is that we have not shown it to be joint family properties, my lord. Only to cover up that, my lord, I am showing, my lord, that it is an admitted fact. Kindly see page 95, para 4, my lord. As far as this is the answer which is extracted from me. This is my submission, my lord. Your lordship may perceive it in. Correct. Plaint C schedule property was purchased by my grandfather's father-in-law in the name of his son-in-law. Idu salpa twisted ide.
Plaint C schedule property was purchased
by my grandfather's
father-in-law
in the name of his son-in-law. Andre it is purchased in the name of the grandfather.
Fortunately, he has not taken it to Adam and Eve. You should thank him.
So, Lord, the answer that is extracted from me is C schedule property is purchased in the name of. Then plaint D schedule property is in the name of deceased defendant number 1, and it was the property of my grandfather. This is, Lord, anyway, DL, there is no problem, Lord, because decree is granted. Then plaint E schedule property stands in the name of my grandfather. This is
cross-examination.
What is cross-examination of plaintiff, and this is the answer which is extracted from the plaintiff. Now, my lord, as far as these properties are concerned, I will stop at this.
Plaintiff is Mr. Shankar's client.
Yes. Now, my lord, the most important document according to me, my lord, is exhibit P45, which is there in Milord, volume 2 at page 314.
Right.
Page number?
314, Milord. Volume 2, page 314. A better copy of the same document is at page 418. I'm sorry.
Same document.
At 443.
Chinnanna bin Nanjundappa.
Bin Nanjundappa.
Krishnappa bin Chikka Chinnanna.
Chikka
Chinnanna bin Nanjundappa. Krishnappa bin Chikka Chinnanna. Yenidu?
Lord, this is the document. Your Lordship may kindly mark the date over here, my Lord. It is 1958. 26/4/1958.
26/3/1958.
And this refers to entire survey number 37.
Oh. 26/4/1958.
So in 1958, the property, Lord, has continued in the name of Chikka Chinnanna bin Nanjundappa, who is admittedly, my Lord, my grandfather.
This is Schedule A only.
Schedule A, my Lord. Now I have come to only Schedule A. I am not going to anything else now.
Yes.
If this is correct, my Lord, then, my Lord, para 9 of the additional, the application for additional documents, which says that, my Lord, the property was sold in 1951, cannot be believed. This document I will show, my Lord, now. Yes.
Yenidu?
This is survey extract, my Lord.
These are
Karda extract. That's a great.
date is 26/4/APT.
It is marked, my Lord, as
The
a
early
copy of
GLBS
survey
7
sketch,
years.
my Lord.
Survey sketch ಅಷ್ಟೇ. ಅದಕ್ಕೆ ಎಷ್ಟು ಇಂಪಾರ್ಟೆನ್ಸ್ ಅಟ್ಯಾಚ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ?
ಅಲ್ಲ,
These are all ರಿಬಟೇಬಲ್ ಪ್ರಿಸಂಪ್ಷನ್ಸ್ ಇದೆ ಅದಕ್ಕೆ 133 ಕೆಳಗಡೆ.
I will now,
Registered document comes.
I will now show, my Lord, that this document is admitted.
This document
This
is
document is
admitted.
admitted.
Admit ಆದ್ರೆ ಭಾಳ ಡಿಫರೆನ್ಸ್ ಆಗಿದೆ. When if it is admitted, and how is that going to make difference?
Lord, the difference that it will make is, my Lord, that this document, when it is admitted in 1958, my Lord, it shows that the property belongs to Chikka Chinnanna bin Nanjundappa, who is my grandfather.
This
Before, my Lord, Lord,
this survey sketch is pursuant to some registered instrument. It cannot be independent.
no, this is ancestral property.
One minute. If I clarify it, this is not a survey sketch. This is what is called Karda. Karda is a document drawn by the surveyor at the time of survey. He records the names of the persons who present, nothing else.
Not present, who are
Then,
liable to pay tax.
ಅಲ್ಲ ಮೇಲೆ ಇದೆ ಪ್ರತಿ ವೇಳೆ ಹಾಜರ್ ಅಲ್ಲಿ ಬೇರೆ ನೋಟೇ ಇದೆ ಪ್ರತಿ ವೇಳೆ ಹಾಜರ್ ಸರ್ಕಾರಿ ಕೆಂಪು ಪುಸ್ತಕಗಳು.
Pata Hajar, that's something else.
At the time of survey, people were
ಪಟ್ಟ ಹಾಜರ.
ಹಾಜರ್. ಯಾರು ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಂತಾರೆ ಅಷ್ಟೇ.
ಸರ್ಕಾರಿ ಕೆಂಪು ಖುಷ್ಕಿ ಸಾಗು.
ಕರ್ದ.
ಕರ್ದ.
The persons who are present, their names are recorded.
ಅಲ್ಲ ಹಿಂಗಂದ್ರೆ ಏನು? ಪ್ರತಿ ವೇಳೆ ಪಟ್ಟ ಹಾಜರ್. ವಾಟ್ ಈಸ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್? ಯಾರ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೇಕು. ಹಿಂಗಂದ್ರ ಏನು ಅಂತ?
ಅದು ಅವ್ರು ತಂದು ಹಾಕಿರೋದು. It is produced by them. It is a Karda extract.
To only show, my Lord, that the property, that is survey number 37.
Which witness has spoken about this? Where is it said?
Yes, my Lord. The plaintiff has spoken about this, but I will come to, my Lord, defendant's thing, if your Lordship will permit me, because plaintiff has not said it in so many words for that. But he has actually, my Lord, got it marked through, my Lord, defendant number 2, my Lord.
Confrontation.
DW1 at page 123, my Lord.
ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದ್ದನಿದು.
Confront ಮಾಡಿ.
ಏನಂತ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದ್ರಿ?
I will read that. Page 123, my Lord.
123.
Yes, of volume 1, sorry.
Para nine,
Para eight.
para eight.
May I read, my lord?
Huh.
The total extent of one, may I read?
ಎಲ್ಲಿಂದ ಓದ್ತಾ ಇದ್ರಿ?
Para 123, para 8.
Para
8.
Into.
8.
123.
Huh.
8. The total extent of Schedule A.
Total extent of Schedule
9
A
acres,
property,
half,
where
9 and a
survey
half.
number 37 is 9.5 acres. I do not know whether as per the revenue records, the entire survey number 37 to the extent of 9.5 acres was earlier standing in the name of my paternal grandfather, Chikka Chinnanna Reddy, my lord. I'll stop it here, my lord. This is, my lord, a suggestion about, my lord, P45. My lord, then, my lord, your lordship may go to page 124, last 5 lines. It is correct as per survey sketch now shown to me. Survey number 37 is shown as having 9 acres, 21 guntas. This survey sketch is marked as exhibit P45.
It only says land measures 9 acres, 20.
No, my lord. It says it was earlier standing in the name of my paternal grandfather, Chikka Chinnanna Reddy, my lord, at 123. Commencement of para 8. 8.
I do not know.
I do not know whether as per the revenue records, the entire 37 was earlier I do not know.
But that is why I confront him with the document. And he says yes.
Only extent.
No, that sketch. A document nalli very, very frugal document. It is marked by frugality.
Lord, before the Land Revenue Act, my lord, these were the documents, these and index of lands, my lord, were the only documents which recorded, my lord, the ownership.
Those days.
Those days, my lord.
D45. Last.
P45.
P40. It is confronted to the witness and marking.
It is marked through
his
his
deposition.
And now please come to page 135. It is true that in the document P45, the name shown is as Chikka Chinnanna, who is my grandfather. I do not know whether Chikka Chinnanna had sold the property bearing survey number 37 to anybody. Whether Chikka Chinnanna has sold the property bearing 37 shown in exhibit P45, I do not know. Today, the answer being developed before your lordship is totally contrary to this. The answer should have been yes. Chikka Chinnanna sold it. I have purchased 37 in 1970-71.
ನಮ್ಗೆ ಇದೊಂದು ಸ್ವಲ್ಪ ಇಷ್ಟೇ ತೋರಿಸಿ. D1, D2 alienated that property, the B schedule property, in favor of any other property, B2E.
Yes, ma'am.
They have alienated any part of that property to anyone.
They have not, there is no document of such record on record. They are not, as I said before to your lordship, my lord,
Where have you stated in your pleadings
about, sir, my lord,
about D1, D2 having alienated the properties in favor of D4, D5, and
Yes.
they in turn
no, D4, D5 was,
6 to 9.
yes, my lord.
ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿ.
Yeah, there is like pleading.
Underlining reason for giving that statement to the honorable court that we are not interested in B, C, D, E properties is found in para 2.
That's right.
Page 135.
Correct. Our question is,
I-
My lord, page 13.
D1, D2 have alienated or encumbered
By whom and
B
who?
to E properties and to whom?
No,
I put it by whom and to whom.
That's what. Yes. ಅದ್ರ
Lord,
ಬಗ್ಗೆ
I
pleadings ಅಲ್ಲಿದೆ.
page 13, my lord, para 8, in the middle of,
1-3
yes, my lord.
in your WS,
No, plaint.
in the plaint,
Yes,
in his plaint.
yes, yes.
You have adopted that. You
Lord, I have not filed it.
Therefore, I am asking.
Sub silentio.
Sabbalidu, absolutely silentio.
Page 13, middle of the para, my lord. Subsequent to, Subsequent to the dismissal of the above suit for non-prosecution, defendant number 1 and 2 have alienated.
That was
the properties in favor of
in respect
defendant
of
4
which
and
you had
5.
sought for restoration. That suit.
Defendants 1 and 2
Have alienated the properties in favor of defendant 4 and 5 and other parties.
Yellide anta?
Plaintiff is not aware of the other parties who have purchased the property.
No, the alienation cannot happen orally. It has to happen by some instrument, perhaps by registered instrument only. Where are that
But I've said, my
Adilla.
lord, the pleadings in this case, my lord, is a little.
alienation cannot happen just by ಹೇಳ್ಬೇಕು ಯಾವತ್ತಾಯ್ತು ಯಾರಿಗಾಯ್ತು ಯಾವ ಇನ್ಸ್ಟ್ರೂಮೆಂಟು ಅದರ್ವೈಸ್ ವೆರಿ ಫ್ರೂಗಲ್ ಪ್ಲೀಡಿಂಗ್ ಆಗ್ತದೆ. ವಿ ಕ್ಯಾನಾಟ್ ಟ್ರೀಟ್ ಇಟ್ ಅಟ್ ಆಲ್. ಇದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಏನಾಗಿದೆ ಈ ವರ್ಷನ್ ಮೇಲೆ ಯಾರ್ದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ? ಶೋ ದಟ್ ಹೌ ದೇ ಹ್ಯಾವ್ ಸೆಡ್.
Yes, my lord. Lord, my endeavor was to show, my lord, that, Lord, as I said to your lordship, my lord, there are two defenses taken, my lord. One is prior partition. And for prior partition, they say, my lord, that your father has sold the properties allotted to him. The second limb of the defense was that Schedule A property, 6 acres, 16 guntas, I have purchased in 1970 and 71. This is the defense version. If your lordship read both the amended and as well as not the
ಅಲ್ಲ ಶೆಡ್ಯೂಲ್ ಎ ನಾವು ಸಪರೇಟ್ ಹೋಗೋಣ. ನಾವು BC-D-E ಮೇಲೆ ಇದೀವಿ. BC-D-E.
Lord, in fact, my lord, there is not much on B, C, D, and E, my lord. So I was concentrating, since, my lord, the other.
ಯಾರ against decree ಬೇಕು ಈ ಪ್ರಾಪರ್ಟಿ?
Lord, decree is in my favor, it's not against me, lord. In a partition suit, my lord. I have to show that it is, my lord, a joint family property in which I have a share. And I claim that share, and my lord, how I get it separated, my lord, is a part of the execution.
That's all right. You
The
can
preliminary decree today I have to show that I am entitled to a share.
ರಾಜೇಶ್ ಇದಲ್ಲ ಡಿಕ್ರಿ ಕೊಡೋದಿದ್ರೆ ಮುಲ್ಲಾ on a key to Indian practice.
Yes.
He writes to grant a decree except in the 4 rem jurisdictions. There has to, and the interpolator suits.
Yes.
There has to be a person against whom it should be given.
Lord, I am claiming it against, my lord, defendant number 1 and 2, who are the branch of.
ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಈಗ ಅವರು ನಮ್ಗೆ ಹೇಳ್ಬಿಟ್ರು ನಮ್ಗೆ ಇದ್ರ ಮೇಲೆ ಏನಿಲ್ಲ ಅಂತ. ಈಗ ಹಂಗಿದ್ದಾಗ ನಾವ್ ಯಾವ ರೀತಿ ಬರಿಬೇಕು ಜಡ್ಜ್ಮೆಂಟ್ ನಮಗ್ ತೋರಿಸಿ.
No, this is exactly what I read.
He says, ನೀವು ಯಾರಿಗಾರ ಕೊಟ್ಬಿಡ್ರಿ ನಮ್ ಹೆಸರು ಬರಿಬೇಡ್ರಿ ಜಡ್ಜ್ಮೆಂಟ್ ಲೆಟರ್ ಅನ್ನೋ ಕಡೆಯಲ್ಲಿ ಅಂತ. ನೀವು ಯಾರೋ ಹೇಳ್ತಾರ ಅನ್ಕೊಂಡು ನಮ್ ನಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ಲೆಟರ್ ಮಾಡೋರು ನೀವು ಅಂತ. What that's what he saying.
No, if they are not in possession of.
Not fit into order 12, order 8 rule 12 ಕೆಳಗೇನು ಬರಲ್ಲ ಅದು. ಜಡ್ಜ್ಮೆಂಟ್ ಆನ್ ಅಡ್ಮಿಷನ್ ಆಗಲ್ಲ. ನಾನು ನೋಡಿದೆ ಅವ್ರ ಬುಕ್ಕನ್ನ ನೋಡಿದೆ ಮುಲ್ಲಾ ಆಮೇಲೆ ಏನ್ ಸಾ ನೋಡಿದೆ ನಾನು.
There are 2 latest judgment I will give that point. The lordship decided that I must.
ಹೌದು ನೀವು ಸ್ವಲ್ಪ ಬೇಗ ಮುಗಿಸಿದ್ರೆ ಬೇರೆ ತಗೋಬಹುದು ನಾವು.
But
Otherwise
I will not take another more than 10-15 minutes.
You may run risk at the hands of people who are sitting behind you. Just ದಿವಸ ಆಗ್ತಾ ಇದೆ. Of course complexity ಇದೆ, that's true.
Lord, this P45 I am pointing out only for, my lord, Schedule A, my lord.
Schedule A.
Property.
That only say, and there is an explanation given to the other side. We have made an appeal for rectification of the extent of the land also.
That is B schedule property, my lord.
B schedule property.
That is B schedule.
Not A.
Not A, my lord.
Exhibit
B schedule
45.
36/4, initially when the suit plaint was filed, it was shown as 36/3, thereafter amended to 36/4. So A schedule property, my lord, the document, now the contentious property is only A schedule property because, my lord, they claim in the second limb of their defense that we have purchased the properties, therefore it is self-acquired property.
You are reading the written statement D5, whatever you want. So read the difference in D5.
Written statement.
My friend has read the written statement D5. D5 is deleted by the order of the court on 14/2/2011.
D5.
D5 is deleted. Because he contended that the property belongs to me. They gave us that property, a different property substitute in B schedule.
ಅಲ್ಲ D5 ಡಿಲೀಟ್ ಆದ್ಮೇಲೆ D5 ಅದನ್ನ ಬೇರೆ ಯಾರಿಗಾರು ಮಾರಿದ್ನಾ?
ಅಲ್ಲ, third party ಅವರು.
Third
Third party's property.
I'll explain that. Lord, initially it was 36/3, my lord. 36/3, D5 comes and says that it is my property. Therefore, my lord, that we amended to 36/4, my lord, and 36/3 mele we don't have any right. So
Therefore,
he is deleted.
36/4 remains.
4 remains.
Then, no, what is the, there is no question of reading the
Anyway,
letter
you
statement.
you have no say in the matter. You have given up all that property. Well, if you say something more, we will not decree against you in respect to those properties.
No, my lord. So, my lord,
Now, D4 is deleted, huh?
D5.
5 is deleted.
My friend has read the return statement D5.
That part is.
Bring some points before the court. But actually D5 is deleted. No use in reading the return statement D5.
ಅಲ್ಲ, ಆಮೇಲೆ 36/4 ಮಾಡಿದ್ದಾರೆ.
yes, that is the point I wanted to show.
36/4. See, in survey number 36 also, no, this Krishnappa sold the property. I will point out that. Tell it also.
ಏನ್ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀರಿ? You have given up your case against those properties.
Adralli, no, in that also, there is a reference that there is a partition for that purpose.
Correct. How you are concerned with?
No, that is, no. Say that earlier partition is there.
ಅದ್ಮೇಲೆ ನಿಮ್ಗೆ ಅಫಿಡೇವಿಟ್ ನಲ್ಲಿ ಹಾಕಿ ಬಿಟ್ಟು ಕೊಟ್ಟಿರಿ, ನೀವು ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಂತ ಅಧಿಕಾರ ರೈಟ್ ಇಲ್ಲ ನಿಮ್ಗೆ.
Lord, I'll just read one more thing and I will finish, Lord, because there's not, Mr. Shankar has already completed the thing. I just wanted to highlight these points, Lord.
Yes.
At page 136, Lord, para 4.
I do not know.
I do not know when my father and father of the plaintiff got divided the properties, but they divided properties during their childhood. In the said partition, no properties were fallen to the share of my father. In the said partition, 1 acre 27 guntas of 37 and another item in the same 36/1 fallen to the share of the father of the plaintiff. Father of the plaintiff. I just wanted to highlight this portion to say that, Lord.
Where is your WS for a moment? When pitch? You are not with WS only.
I said subsilential.
Then that itself will be a constraint to you.
I'm just supporting the thing. Therefore, my lord, Mr. Shankar has brought out everything else, my lord. And the only other thing remains, my lord, is about
D3. Counsel for the D3 admits that no WS has been filed. Counterclaim ಅಂತದ್ದು ಏನು ಇಲ್ಲ ನಿಮ್ದು in the subject suit. First, counsel submits that he is only adumbrating the case sought to be made out by the net senior advocate, Mr. S.P. Shankar, appearing for the plaintiff.
Now what remains, my lord, is exhibit D 18, 27 and 28. My lord. These are the sale deeds, certified copies. My lord, I will not go into the rest of
You have not cross-examined anybody also.
I have not. My lord, now, my lord, it has been shown to your lordships, my lord, that Krishnappa, son of Chinnanna, my lord, in one and in another one, Krishnappa, son of Dodda Chinnanna, is who are the vendors in those documents. What your lordship will notice.
Decree ಏನಂತ ಕೊಡಬೇಕು?
Lord, if I pay the court fee, my lord, I will also be entitled in the thing.
Claim ಮಾಡಿಲ್ಲಲ್ಲ ನೀವು?
Now, madilla, but I'm saying I can, my lord, even at any stage of these proceedings, my lord, I can pay the court fee and ask for my share also to be separate. In FDP also I can do it, in execution also. Your lordships in fact said that, my lord, when another person wanted to implead in this case, my lord, that is another sister of these two brothers, Guramma, she was unknown. Somebody came here as her children and said, we also want to implead in this appeal. The lordship said, if you have a right, you can go and
work out in
that order your lordship have passed.
Yes,
No, only other one last sentence that I want to say, Lord, is that these exhibit D 18, 27 and 28, my lord, are not confronted to, my lord, the witness, my lord.
E 18,
27, 26, 27 and 28.
26.
Actually, 26 has nothing to do with us. 27 and 28 is relevant. When your lordship sees the cross-examination,
27, 28. Yeah, that is in respect of Schedule A property.
Schedule A property, where they say that my father has sold the property. Apart from the names being different, apart from the names being different, apart from the property number being different, my lord, it has to be confronted, my lord. That is why, my lord, Mr. Shankar, my lord, was laboring on that Calcutta judgment, saying at least what you have to do is confront it. You have to show that document to the witness and say, this under this document, your father has sold the property. What do you say? That confrontation is not there.
Context of the admission made by defendant.
Yes.
in the witness bar.
Because of admission made by other side.
Yes. So, my lord, I'll just conclude by this thing, my lord. They are now saying, my lord, bringing new documents to your lordship, before your lordship, saying my grandfather has sold it in 1951, whereas Exhibit P45, my lord, still bears my grandfather's name in 1945, 58. 58. Thereafter, they say, my lord, they give a chart and say that some property was sold by my father, some property they have purchased, my lord. Now, my lord, that para 9 itself becomes, my lord, false, my lord, when my lord, Exhibit P45 is admitted. So, my lord, this is the entire evidence that is on record.
Any document can you show to us where under D1, D2 sold the property to D5, D6, 7, 8, 9?
D4, 5, 9.
Lord, Anna, I have not made that homework, my lord. I will do it. Because it is. It's dangerous.
On the brief synopsis. Okay, ಯಾವ್ದಾದ್ರು ಒಂದು document ಇದೆಯಾ?
None, I will look up. Lord, as an officer of the court, my lord, I will definitely assist.
ಅವ್ರದ್ದು you have given up on affidavit ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
ಅಲ್ಲ ಅದು ಇಲ್ಲೇ ಹಾಕಿದೆ. I will give it to you. ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲಿ ಫೈಲ್ ಆಗಿದೆಯಾ ನೋಡ್ರಿ, ಫೈಲ್ ಆಗಿದೆಯಾ ಅಫಿಡವಿಟ್ ಅವ್ರದ್ದು?
Lord, only one last thing. So
Reply tomorrow, day after.
Only one.
ನಾಳೆ.
Lord, our insistence, Lord, on that certified copy is not being admissible, Lord, as far as
I will give you the judgment.
18, 27 and 28, Lord. Lord, per se, what our argument is that, my lord, if the original document or at least some other document was there, my lord, it could have, your lordship could have compared the signatures.
ಅದನ್ನ ಹೇಳಿದ್ರೆ ನಾವು ಬೈಸ್ಕೊಂಡಿದ್ದೆ.
ಇಲ್ಲ ವೈಷ್ಣವಿದ್ದಲ್ಲ, ನಾವು ಓನ್ಲಿ ಸೈಡ್ ಅದು ಯಾವಾಗ ಏನು ಅನ್ನೋ ಬಗ್ಗೆ ಸೆಕ್ಷನ್ 90 ಮೇಲೆ 65 ಮೇಲೆ ಅಷ್ಟೇ.
There is a latest.
We hold you, Mr. Shankar, we hold you in the highest esteem.
No, your lordship.
We consult you. Even otherwise also we consult.
There was no need to precipitate, and that's where people.
Your lordship sees section 90. Your lordship sees section 90. One of the presumption is of the signature, whose signature it purports to be, my lord. Here, that presumption can't extend, my lord, to assuming that it is about the person, the identity of the person. Lord, if a document contains a name and its signature.
Right, Mr. Shankar said rightly, and we agreed also. The question of presumption under 90 arises, provided it is original document coming from a proper custody. Only then, and even presumption is selective.
I'm not on presumption.
Rebuttable.
I am only saying
Not
that
only rebuttable, presumption is selective also.
what I'm saying is, my lord, the signatures could have been compared. The thumbprint could have been compared. Today, we are in a situation where the names are different, property numbers are different, and there is nothing to, my lord, compare.
Properties ಇದೆ.
No, it's 37 bar 2.
Name ಸ್ವಲ್ಪ ವೇರಿಯೇಷನ್
It is 37 bar 2, my lord.
37 bar, yes.
There, Lord, and my lord, one of the witnesses admitted that the 4D happened only in 2005. I will just show it, my lord, within a minute.
Yeah, I think that's material.
That is
All these
material.
things happen in 2005.
Sorry, I missed that, my lord.
2005.
Conversion order.
Lord,
Body of,
DW4 says so.
DW4.
Yes,
Who is the DW4?
he is not
Supporting witness.
purchaser, my lord.
Purchaser.
Durani. 150, page
Purchaser
150.
of B schedule, huh?
No.
Schedule.
Yes,
A schedule.
Page
37.
150, page 150.
Eight. Different number 8.
DW4.
ಅಲ್ಲ ಡಿಪೆಂಡ್ 9 ಅವನು ND. Yes, 8, correct. Durani. 8. That is the charm of
Volume 3 ಅಲ್ಲಿ ನೋಡಿಸಿ.
Lord, at page 168. 160. No, I'm sorry. ಅಲ್ಲ.
ಏನಂತ ಹೇಳ್ತಾನ ಅವನು?
Lord, that after his purchase, only the 37 has been voted.
37 is coded as 37, 2, 3, 4 ಅದೆಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ ಅದ? ಅವ್ನ್ ಯಾವ್ದದು?
There are up to 6, 7 also. Lord, I'm sorry, I not marked that.
Anyway,
Yes, Lord.
synopsis ನಲ್ಲೂ ಹಾಕ್ಬಿಟ್ಟು.
Yes, please, I'll do that.
Tomorrow. Reply ಮಾಡ್ಬಿಡು. One, 43 pointer, ನೀವಾ? ಹಾ. You bought property from whom?
He has not gone through the paper.
Not read. ಮತ್ತೆ ಇಷ್ಟು ದಿವಸ ತನಕ ಉದ್ದಕ್ಕೆ ನಾವು ಕೇಶವಾನಂದ ಹಿಯರ್ ಮಾಡ್ದಂಗೆ ಮಾಡೀವಿ ಇದನ್ನ. ಅವಾಗೂ ನೋಡ್ಕೊಂಡಿಲ್ವಾ ಪೇಪರ್ಸು? ಬಹಳ ನಮ್ಗೆ ತುಂಬಾ ಪಾಠ ಮಾಡಿದ್ರಿ 2 ಸೈಡ್. ನಾಳೆ ಎಷ್ಟು ಅವಷ್ಟ ಹಾಕಿ ಹೌದು ಮತ್ತೆ ಇದು ಇಷ್ಟ ಎಸ್. ನಾಳೆ ಸುರಾನ 2:30 ಬಂದ್ಬಿಡ್ರಿ. 2:30 ಮುಗಿಸ್ಕೊಂಡ್ಬಿಡ್ರಿ ಬಂದ್ಕೊಡ್ರಿ.
I'm obliged for the patient hearing.
ಬೇರೆ ಯಾವ
ಫ್ರೈಡೇ ಇರ್ತೀನಿ ನಾನು. ಫ್ರೈಡೇ ಇರ್ತೀನಿ. ಫ್ರೈಡೇ ಈವ್ನಿಂಗ್ ಹೋಗೋದು. ಫ್ರೈಡೇ ತನಕ ಇರ್ತೀನಿ ನಾನು.
Friday there's no.
ಫ್ರೈಡೇ ನೋ ಬೆಂಚ್ ಅಲ್ಲ. ಅಲ್ಲಿ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಅಲ್ಲ.
ನಾಳೆನೆ ಮುಗಿಸ್ಬೇಕು.
37 ಒಂದು ಡೇಟ್ ತೊಳಿ ಎಲ್ಲರೂ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಎಲ್ಲರೂ. ಕರೀರಿ ಬರ್ಲಿಕ್ಕೆ.
31 ಪಾಸ್
ಎಲ್ಲ 28 ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟು ನೋಡ್ಕೊಂಡೆಲ್ಲ ಯಾವ್ಯಾವ ಡೇಟ್ ಇದೆ ನೋಡ್ಕೊಂಡು ಕೊಡ್ಬೇಕು. ಯಾರ ಪ್ರೆಷರ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳ್ಬೇಕು. ಫ್ರೈಡೆ ಬೆಂಚ್ ಇರಲ್ಲ.
They have passed an order and served on me today that I am under suspension. My lien is shifted to Bidar.
ಮತ್ತೊಂದು ಯಾವ್ದಾರ ಡೇಟ್ ಕೊಡಿ.
If my lords would ask them not to enforce it for 3 days, my lords.
ಅವ್ರು AAG ಬಂದು ಏನೋ ಹೇಳ್ಬೇಕು ಹೇಳ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
That's only lien has been shifted. That can be,
ಅಲ್ಲ ಈಗ ಒಂದು ವಾರ ಅದಕ್ಕೆ ಡೋಂಟ್ ಗಿವ್ ಇಫೆಕ್ಟ್ ಟು ದಟ್. ಬರ್ಕೊಳ್ಳಿ. ಯಾವ ನೋಟಿಸ್ ಡೇಟೆಡ್?
Notice dated for 12th November 2024, directing me to report at.
The notice dated 12/11/2024 pursuant to which
I have been directed to report at.
Sir is directed to report at whether
Yes.
is kept under suspended animation. Abeyance. Abeyance. Till next date of hearing. Call this matter in the first week of January. First week of January. ಹಂಗಿರ್ಬೇಕು. ನಿಮ್ ಸಿಗ್ನೇಚರ್ ಬೇಕಾಗಿಲ್ಲ.
Week of January, interim order. First week of January 2025. 28. 28. 28. ಇಲ್ಲ ನಾಟ್ ರೀಚ್ ಲಾಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಆಗಿದೆ.
ಆಗುತ್ತೆ ಸರ್ 29.
ಮೆಮೊ ಕೊಡಿ, 1 week ಆದ್ಮೇಲೆ ಒಂದು ಮೆಮೊ ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಅದು.
ಆಗುತ್ತೆ ಸರ್ 29.
29 ನಾಟ್ ರೀಚ್ 2 weeks. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಮೆಮೊ ಕೊಡಿ, ಮೆಮೊ ಹಾಕ್ಸ್ಕೊಂಡಿ ಸರ್.
ಒಂದು ಡೇಟ್
ಸರ್ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು? ಸಾಹೇಬ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅಂದ್ರೆ ನಿಮ್ಮ ಮ್ಯಾಟ್ರ್.
19 ಬೇಡ ಸರ್. 21st ಆಗಲಿ, 19, 29 ಬೇಡ.
ಅದೇ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್.
ನೋ ಅಲ್ಲ, ಅವತ್ತು ಏಜ್ ಇಲ್ಲ ಅಂತ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ ಸರ್. ಕೊಡುತ್ತೆ.
ಅವತ್ತು ಏಜ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಂದ್ಬಿಡ್ತದೆ. 24 ಯಾವಾಗಲೂ ರೀಚ್ ಆಗುತ್ತೆ.
ಡೇಟ್ ಕೇಳ್ಬಿಡ್ತಾ ಇದ್ದಾರೆ.
19 ಬೇಡ, ಅವ್ರಿಲ್ಲ ಏಜ್ ಇಲ್ಲ. 21st ಹಾಕ್ಬಾರ್ದು.
ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಪಾರ್ಟಿ ಅಂದ್ರೆ
ಏನಾಗಲ್ಲ, ಒಂದ್ ದಿನ ಅಷ್ಟೇ. 15 ಸೆಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತೆ. 19
ಸೀರಿಯಲ್ ನಂಬರ್ 30
20th ಹಾಕೊಂಡು 20th.
20th
ಇಲ್ಲ 18th ಹಾಲಿಡೇ ಇದೆ.
ಜನರಲ್ ಹಾಲಿಡೇ.
18th ಹಾಲಿಡೇ ಇದೆ ನೋಡಿ ಸರ್. ಅಲ್ಲಿ
ಕನಕದಾಸ ಜಯಂತಿ
18th ಹಾಲಿಡೇ ಇದೆ, ಅದಕ್ಕೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 30.
20th
30 ನಾಟ್ ರೀಚ್ 2 weeks. 2 weeksಗೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಮೆಮೊ ಕೊಡಿ. ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಸರ್. ಪ್ಲೀಸ್ ಅದೇನು ಹೇಳ್ತೀರಿ ಸಾಹೇಬ್ರು, ಯಾರು ಅರೆಸ್ಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಹೆಸರು ತಗೊಳ್ಳಿ ಅಂದ್ರು. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಂದು ಮೆಮೊ ಕೊಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರೀತೀವಿ, ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಯಾವಾಗ ಬೇಕಾಗುತ್ತೆ. ಅದ ಪಾರ್ಟ್ಲಿ ಕಂಪ್ಲೈಂಟ್ 2 weeks.
ಸರ್ 3 ಯಾವತ್ತು?
4 weeks ಸರ್. ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ಲ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 4 weeks. So come and appear, none appears for petitioner in RFA ಅಂತ ಹಾಕಿ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 4 weeks. ಅವರೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು, ಅವರೇ ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಫೋನ್ ಮಾಡಿಲ್ವ ಅವ್ರಿಗೆ?
ಸರ್ ಅವ್ರು ಇಲ್ಲ, ಯಾರು ಗೊತ್ತಾಗ್ತಾನೆ.
ಮತ್ತೆ ಅವ್ರು ಇಲ್ಲೇ ಬೇಕಲ್ಲ
ಸರ್. ಸರ್ ಬರ್ದು ಬಿಟ್ರೆ ಏನ್ ಸರ್ ಅದು?
ಬರ್ದಿದ್ದು ಆಯ್ತು ಸರ್. ಈಗ ತಗೊಂಡ್ ಹೋಗ್ತಾರೆ ನೋಡಿ ಸರ್. ಬರ್ದಿದ್ದು ಆಯ್ತು ಸರ್. ಅದು ಒಂದು ಮೆಮೊ ಕೊಡಿ 4 weeks ತನಕ. ಅವ್ರು ಅಷ್ಟಲ್ಲಿ ಇಮ್ರಾನ್ ಎಲ್ಲಿದ್ದಾರೆ ನೋಡ್ಬಿಟ್ಟು ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. ಇಲ್ಲ ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ಕೆಲಸ ಆಗಲ್ಲ, ತಿರ್ಗಿ ಅವತ್ತು ಇದೇ ಆಗುತ್ತೆ. 36 ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಬೆಳಗ್ಗೆನೇ ಹೋಯ್ತಲ್ಲ ಮೇಡಮ್. ಕಾಲ ಸೀರಿಯಲ್ ನಂಬರ್ ಸೊ ಅಂತ ಬೆಳಗ್ಗೆ BSVಗೆ ಬೆಳಿಗ್ಗೆನೆ ಪೋಸ್ಟ್ ಅಲಾಂಗ್ ಅಂತ ಇತ್ತು. ನಿಮಿಷ ನಂಬರ್ ಅದು ಅದೇ 19. 19/11 ಡೇಟ್ ಕೊಟ್ರ ಅದಕ್ಕೆ. serial number 19. 19 entry ಮಾಡಿ extended ಆಯ್ತು. ಅದಾಯ್ತು. ನಮ್ಗೆ ಇದೊಂದು ಇನ್ನೇನು 31 ಮೇಡಮ್ ಆಗಿದೆ. 2011 ಡೇಟ್ ಅದು ಒಂದು ಕೊಡ್ಬಿಡಿ ನಾನು ಕಾಪಿ ಹೋಗ್ಬಿಡ್ತೀನಿ.
ಸರ್ ಏನೋ ಕೇಸ್ ಫೈಲ್ಸ್ ಏನಾರು ಇದೆಯಾ ಸರ್ ಓದೋದಕ್ಕೆ?
ಕೇಸ್ ಫೈಲ್ಸ್ ಇವತ್ತು ಬಂದ್ರೆ ಏನು ಕೊಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್. ನೀವು ಆಗ್ಲೇ ಬರ್ಬೇಕಲ್ಲಿ ಕೂತಿದ್ರೆ ಯಾವ್ದಾರ ಕೊಡ್ತೀವಿ ಫೈಲ್ಸ್ ಓದ್ಕೊಂಡು ಕೂತ್ಕೊಬೋದು.
42.
ಅಲ್ಲಿ ಲೇಟ್ ಆಗಿ ಬಂದಿದೆ ಸರ್ ಸ್ವಲ್ಪ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಕುತ್ಕೋಬೋದಾ ಇಲ್ಲ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಕೂತ್ಕೊಬೋದು ಇಲ್ಲ ಬಂದ್ರೆ ಇಲ್ಲೂ ಕೂತ್ಕೊಬೋದು ಜಾಗ ಇದ್ರೆ ಹೇಳಿ ಸರ್.
42.
42 not reach 2 weeks.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಬೇಕು ಸರ್, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
ಇವಾಗ ಡಿಕ್ಲೇಷನ್ ಕೊಟ್ರಲ್ಲ ಸರ್ ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರು, ನೀವೇನ್ ಸರ್ ಕೇಳಿಸ್ಕೊಂತೀರಾ?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋ ಮುಂಚೆ ಬೇರೆದಿದೆ, ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
ಇವಾಗ ಕೊಟ್ಟಿಗಿಂತ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇತ್ತ ಅದ್ರಲ್ಲಿ.
ಆ ಕೇಸ್ ಆಯ್ತು ಇರ್ಲಿ ಬಿಡಿ ಸರ್.
ಯಾವುದು
ಸರ್ ನಾಳೆ ಏನಾದ್ರು ಸಿಗುತ್ತಾ ಸರ್ ಫೈಲ್ ನಿಮ್ದು?
ನಾಳೆ ಬಂದ್ರೆ ಫೈಲ್ಸ್ ಕೊಡ್ತೀವಿ.
ಓಕೆ
ನಮ್ ರಘುನ ಏನಾದ್ರೆ ಇದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಅವ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಸಾಕು. ಅವ್ರು ಲಾ ಕ್ಲರ್ಕು ನಮ್ ರಘುನಂದನ್ ಅಂತ ಇರ್ತಾರಲ್ಲ ಅವ್ರು ಲಾ ಕ್ಲರ್ಕು, ಅವ್ರ ಏನಾದ್ರು ಹೇಳ್ತಾರೆ. ಪಕ್ಕದಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ, ಫೈಲ್ಸ್ ಬೇಕಂದ್ರೆ ಫೈಲ್ಸ್ ಕೊಡ್ತೀವಿ, ಓದ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳಿ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
37 ಮಂದಿ ಬಂದ್ವಿ ಯಾವ್ದ್ರಲ್ಲಿ? ಚೇಂಜ್ ಮಾಡಿ ಅದೇ ಸಾಹೇಬ್ರ ಆಮೇಲೆ ಕೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿಲ್ಲ ಅಂತ. ಇಟ್ಕೊಳ್ಳಿ ದೊಡ್ಡ ತರ ಇತ್ತಲ್ಲ ಎಲ್ಲಿರ್ಬೇಕು ಇದೊಂದು ಹೆಸರು ಇಲ್ಲ ಇಲ್ಲಿ 43 ಇದು ಇಮ್ರಾನ್ ಏನಾ ಅದ್ರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಸರ್?
Amendment has been carried out. In the branch I have done it.
ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ಬಿಡಿ ಕೇಳಿ ಸರ್.
Just see.
Go to that concerned RFA branch and you make it not that one, serial number 3. 3 ನಲ್ಲಿ ಯಾರು ಸರ್?
Serial number 3 I have for the appellant.
Which matters? 3 matters are there.
3 matters is 2. One is RFA.
Who is Imran A?
And he is on the
colleague.
colleague.
ನಿಮ್ colleague?
Yes sir.
ಅದ್ರಲ್ಲಿ ಬ್ರಾಂಚ್ ಹೋಗಿ ಅದ ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ವಿತ್ ಸಿಂಗಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಮೆಮೋ ಫಾರ್ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಅಂತ ಇದೆ. ಆಮೇಲೆ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ 3.1 ಅಲ್ಲಿ ಇದೆ. ಶಿವರಾಮ್ ಗೌಡ ಯಾರು?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಸರ್ 3.1 ನೋಡಿ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್. ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೋ ಅಂತ ಇದೆ. MFA ಶಿವಕುಮಾರ್ ಗೌಡ. They have to amend the cost title.
There are some objection is there, no? Okay. Any date to fix?
Next year.
Yes, it is adjourned by 4 weeks, sir. By 4 weeks, you comply all the office objections. ಅವ್ರು ಯಾರು ಬಂದು ಹೇಳಲ್ಲ ರೀ, ಇಮ್ರಾನ್ ಏ ಬರ್ಬೇಕು, ಅವ್ರು ಬಂದು ಹೇಳ್ಬೇಕು. ಅಟ್ಲೀಸ್ಟ್ ಮೆಮೋ ಫಾರ್ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ? ಅವ್ರು ಬಂದು ಹೇಳ್ಬೇಕಿದೆ ಡಿಸೀಸ್ R6 ಓನ್ಲಿ R6 A to H ಅಲ್ಲ ಅಂತ. ಎಲ್ಲಾ ಕಡೆ R6 A to H ಇದ್ದಾರೆ. ಇವ್ರು ಒಬ್ರು ಅದನ್ನ ರಿಪ್ಲೇಸ್ ಮಾಡ್ತಾರಂತ, ಬರೀ ಒಬ್ರೇ ಅಂತ. ಸರ್ ಅದಕ್ಕೋಸ್ಕರ ಅದು ಏನಿದೆ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಟ್ರೆ ಇದೆ. ಇವ್ರು ಏನ್ ಕೇಳಿರೋದು ಈ ಮೆಮೋನಲ್ಲಿ R6 A to H ಅಂತ ಇದೆ. R6 A to H. He has filed a memo for rectification treating R6 to A to H are not the proper parties. Only single respondent is the proper. That he has to explain it to his lordship. ಅದ್ರಲ್ಲಿ ಮಾಡ್ಬೇಕು. ಇದರಲ್ಲಿ ಶಿವಕುಮಾರ್ ಗೌಡ ಯಾರು? ಶಿವಕುಮಾರ್ ಗೌಡ ಯಾವ್ದ್ರಲ್ಲಿ? ಅಲ್ಲ ಅಲ್ಲ 4 weeks ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಮೆಮೊ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ. ಇನ್ನೊಂದು ರಿಪೀಟ್ ಆಗ್ತಿಲ್ರಿ ಎಮ್ಮನ್ಗೆ 17 ಇದೇನ್ರಿ? ಯಾವ್ದಪ್ಪ ಬರ್ರಿ ನೋಡಿ, ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲ ಡೇಟು ನೋಡಿ. ಡೇಟ್ ಈಗ ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಈಗಲೇ ತಂದ್ಬಿಟ್ಟ. ಮೆಸೇಜ್ ನೋಡಿದೆ ಅಂತ ಗೊತ್ತು ಅಂತಾನು ಹಾಕಲ್ಲ ಅವರು. ನಾಳೆ ಕೊಡ್ತೀವಿ. ಒಂದು ರಿಪೀಟ್ ಬಂದಿದೆ ನೋಡಿ. ಹಲೋ, ರಿಪೀಟ್ ನನ್ನ ಮೆಸೇಜ್ ನೋಡಿದೆ ಮೇಡಮ್? ನೀವು ಒಂದು ಮೆಸೇಜ್ ನೋಡಿದ ತಕ್ಷಣ ನಾನು ಮತ್ತೆ ಸಾರಿ ಅಂದ್ಬಿಟ್ಟು ಅದು ರಿಪೀಟ್ ಆಗ್ತೀರಾ ಅದು? ಹಾ ಸಾರಿ, ಯಾವ್ದು 14% ಅದು ಬಂದಿದೆ. ಓಕೆ, ಇವಾಗ ಇನ್ನೊಂದು ರಿಪೀಟ್ ಬರ್ಕೊಳ್ಳಿ. ಒಂದೇ, ಈಗ ಇನ್ನೊಂದು ಬರ್ಕೊಳ್ಳಿ. ಈಗ ಕೊನೆ ಮ್ಯಾಟ್ರ್ ಅರ್ಜನ ಮತ್ತೆ